16 ಮ್ಯಾಟ್ರು ಅಯ್ಯ ಹಾಕೋಬೇಕಾ ಮೆಮೋ ಆಗಲ್ವಾ
ಅದಲ್ಲ
ಏನಿಲ್ಲ
2016 ಮ್ಯಾಟ್ರ್ ನೋಡ್ಕೊಂಡು ಡೆಮೋ ಮೂವ್ ಮಾಡ್ತಾರೆ ಆಗಲ್ಲ
ಹಾ ಬಿ ಗ್ರೂಪ್ ಬರೀ ಮೆಮೋ ಆಗಲ್ವಾ ಸರ್ ತಗೊಳಲ್ವಾ ಸಾಹೇಬ್ರು ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ಸರ್
ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ಅಂತ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ ಟೈಮ್
ಒಂದೊಂದು ಕಥೆಗಳು ಹೇಳಿದ್ರು ಅವಾಗ ಫೋಟೋ ಹೋಗ್ತೀನಿ ಮೇಡಮ್
ಈಗ ಕ್ಯಾಮ್ರಾ ತೋರಿಸೋದು ಕ್ಯಾಮ್ರಾ ಬರಲ್ಲ ಅನ್ಸ್ಲಿ 2-3
Fresh matters.
All fresh matters.
When for number 53 is pending, my lord, they have allotted for burial ground, my lord.
Sir. Sir.
ಕೊಡಿ sir, ಕೊಡಿ.
For orders on IML, while IFR.
ಕೊಡ್ಬೇಕಾ?
My lord, Marco.
What are you doing?
Sir.
You have to
Sir.
file
Sir,
IF
sir.
for early hearing. Yes.
Matter has been settled, my lord. By time you have it tomorrow, my lord. 5 members for withdrawal.
Sorry.
And it's
Other. If it has to come up for any other stage like B group or final hearing, you'll have to file application for early hearing. Otherwise, it won't come. Yes.
My lord, sir, 2018 matter, my lords. The third respondent on the basis of connection.
What do you want, madam? If it is a
Finally- fresh
fresh matter, please give. If it is a old matter, you'll have to file application for early hearing. Yes.
Fresh matter.
Fresh matter.
This number one, fresh matter, serial number one. Sundaresh, it's
Petition in this case. Let the petition belong to scheduled caste melody. He has filed an application. He has unauthorizedly cultivating 3 acres of land in survey number 203 of Kelaguru village, Aldur Hobli, Chikamagalur Taluk. Where the form number 53 has also been filed before the committee for regularization.
It was
The
rejected.
That said application came to be rejected on
Hmm.
the ground that the land is reserved for rehabilitations to the Badra, the residents of Bandra Wildlife Sanctuary. Then when appeal has been filed before the appellate authority, then same endorsement came to be issued.
Huh?
Annexure F may kindly be seen, same endorsement, only on the ground that, but RTC
Filed
had
an appeal before the assistant commissioner.
assistant commission, no, before the DC,
Huh?
before the deputy commissioner.
Tahsildar issues an endorsement as per annexure B.
Allappa, 2016,
Please,
the application was rejected.
yes.
What did you do?
Then my lord, appeal has been filed before the deputy commissioner.
Deputy commissioner ಮುಂದೆ ಹೆಂಗಾಗತ್ರಿ?
108D ನಲ್ಲಿ,
Huh?
108D, read with section 49 of the annexure C
If an order is passed by the committee,
committee.
appeal lies to the deputy commissioner, is it?
This is a C,
Huh?
53 application, the additional committee, the power of the additional. The deputy commissioner has passed a detailed order under the 108D.
Milord, what has happened?
108D6 of the Karnataka Land Revenue.
They have not challenged that said order, Milord. They have challenged the annexure B endorsement issued by the Tahsildar. Tahsildar ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ endorsement ಕೊಟ್ಟಿದ್ದಾರೆ. That can be challenged under 108D6. Recommendation of the as per next 108D.
108D. D ನಲ್ಲಿ.
Yeah, procedure of the committee.
Committee.
ಹೌದು ಅಲ್ಲ ಅದರಲ್ಲಿ 108
Appeal against orders made by the Tahsildar on the recommendations of the committee or additional committee shall lie to the assistant commissioner. That is what I am saying.
But the
How
appeal,
could you file a appeal before the deputy commissioner?
but the appeal was entertained by the deputy commissioner and under 108DC. And order came to.
It also is wrong.
is procedural lapse. But ಅವರು 1998 ಅಲ್ಲಿ application ಹಾಕೊಂಡಿದ್ದಾರೆ. But the said land has already been given to Badra Wildlife in 1997 ಗೆ
Really, there,
these lands have been allocated for ಇದು Badra Wildlife rehabilitation.
the
Center.
RTC clearly shows Malad is an agricultural land, is a revenue land. And then Malad, they have granted, allotted, the grant was made in favor of some other applicants.
Before your application, it has been granted.
No, your lordship may
That's
kindly
what has
see,
been pointing
I have produced the RTC extracts.
ಅದಲ್ಲ ಅವ್ರು-
Recently they have allotted, 2014 they have allotted.
ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಡೆಪ್ಟಿ
ಹೌದು.
ಕಮಿಷನರ್?
ಅದನ್ನೇ ಹೇಳಿದ್ರು ಪೇಜ್
7-8-2013 ಅಲ್ಲಿ allot ಆಗಿದೆ.
ಪೇಜ್ ನಂಬರ್ 23 ಮಿಲ
25 may kindly be seen, your lordship.
25.
ಇದು ಚೌಡಯ್ಯ ಬಿನ್ ಮರಿಯಪ್ಪ ಅನ್ನೋರಿಗೆ 7/8/2013 ಅಲಾಟ್ ಆಗಿದೆ.
Please read from the order.
Please.
ಅನೇಕ್ಷರ್ ಎಫ್ ಲಾಸ್ಟ್ ಪ್ಯಾರಾ.
Yeah.
ಆದೇಶ ಮುಂಚೆ ಎಕರೆ ಜಮೀನನ್ನು ಭದ್ರಾ ಅಭಯಾರಣ್ಯ ನಿವಾಸಿಗಳಿಗೆ ಪುನರ್ವಸತಿ ಕಲ್ಪಿಸಲು ದಿನಾಂಕ 29/7/97
That is what I am saying.
Your application
before you filed the application, it has been granted.
No, your last main application was filed in the year 1998. Then, before that, after passing this order, they have granted land in favor of some other allottees.
Can't you read it? They have said 1997.
Annexure.
It has been granted for rehabilitation of the displaced persons of Bhadra project.
Annexure G may kindly be seen.
Annexure
G. Annexure G. G ನಲ್ಲಿ ಚೌಡಯ್ಯ ಬಿನ್ ಮರಿಯಪ್ಪ 2 ಎಕರೆ 23 ಗುಂಟೆ ಮಂಜೂರು 7/6/2013 ಮಂಜೂರಾಗಿದೆ. And then your lordship may kindly see next page G2 to page 27. K. Chandrasekhar bin Lingayya ಇವರಿಗೆ ಅಕ್ರಮ ಸಕ್ರಮದಲ್ಲಿ 2018 ಅಲಾಟ್ ಆಗಿದೆ. 7/8/2017 ಅಕ್ರಮ ಸಕ್ರಮ ಅಂತ.
What do you say now?
Lord, I'll have to ascertain.
First of all, they have gone before authority which has no jurisdiction. Please. But anyhow, an order has been passed now. And he is pointing out that subsequently also there have been
They have allotted
land.
land. Yes, ma'am.
Under the under section 94A.
I will just ascertain with regard to on when this allotment was made, maybe taken up next week. I will take instructions.
Learned HCGP takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned HCGP. Stop. Next paragraph. Learned counsel for the petitioner submits that on rejection of the application filed by the petitioner in form number 53. And an endorsement being issued by the Tahsildar on 28/9/2016. The petitioner filed an appeal before the Deputy Commissioner, Chikmagalur District, invoking Rule 108, capital D, bracket 6 of the Karnataka Land Revenue Rules, 1966 and section 49 of the Karnataka Land Revenue Act, 1964. Full stop. The Deputy Commissioner has rejected the appeal, upholding the orders passed by the committee on the ground that the lands in survey number 203 of Kelaguru village have been reserved and allotted to displaced persons from the Bhadra Wildlife Sanctuary Full stop. However, learned counsel for the petitioner draws the attention of this court to annexures G and G2, which are the RTCs in respect of the very same survey number, and submits that two other persons have been granted lands subsequently in the years 2013-14 and 2017-18. And therefore, the reasons for rejecting the application is contrary to the facts and law. Full stop. Next para. Learned HCVP seeks for a short accommodation to seek clarification in respect of the grants said to have been made in terms of annexures G and G2. G2. Full stop. Release this matter on 6th of March. Please.
Case number 2, Sri Prakash.
The order is at annexure A, wherein the deputy commissioner, after having found that that the petitioners or the respondents before him had derived title way back in 1932, the operative portion, just before the operative portion of the order at page 20, the preceding paragraph for the learned the deputy commissioner says that the land is acquired by the ancestor of the petitioners way back in 1932. But however, the sixth respondent has ಪಾವತಿ ಖಾತೆ ಮಾಡಿಸ್ಕೊಂಡು ಈಗ ರಿವಿಷನ್ ಬಂದಿರೋದ್ರಿಂದ ನೀವು ಸೂಕ್ತ ಪರಿಹಾರನ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಮಾಡಿ. And this is the finding of the
Please read that paragraph.
page 19.
Yes.
Page 19.
Yes.
ಒಟ್ಟಾರೆ ಪ್ರಕರಣವನ್ನು ಈ ಮೇಲಿನ ಅಂಶಗಳ ಮೇರೆ ಗಮನಿಸಿದಾಗ ಪ್ರತಿವಾದಿಗಳ ಮೂಲ ವಂಶಸ್ಥರಾದ ಕ್ಯಾರೆಗಂಡೆ ರಾಚಯ್ಯನ ಹೆಂಡತಿ ಸಿದ್ದಮ್ಮನವರು ದಿನಾಂಕ 6/5/32 ಕ್ರಯ ಪತ್ರದ ಪ್ರಕಾರ ಸರ್ವೆ ನಂಬರ್ 79ರಲ್ಲಿ 5 ಎಕರೆ ಪೈಕಿ ಕೇವಲ 2 ಎಕರೆ ಮಾತ್ರ ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುತ್ತಾರೆ. 2 ಎಕರೆ ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುವ ಬಗ್ಗೆ ಪ್ರತ್ಯೇಕ RTC ಇದ್ದು ಇದೇ ಸರ್ವೆ ನಂಬರ್ 79 ಎಂದು ಬೋರ್ಡ್ ಆಗಿ 1 ಎಕರೆ 39 ಗುಂಟೆ ಕಂದಾಯ ದಾಖಲೆ ಬರುತ್ತಿರುತ್ತದೆ. 6ನೇ ಪ್ರತಿವಾದಿ ಪಾವತಿ ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡು ಈಗಾಗಲೇ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರಿಗೆ ಕ್ರಯ ಕೂಡ ಮಾಡಿರೋದ್ರಿಂದ ಕ್ರಯವಾದ ಜಮೀನನ್ನು ಪುನಃ MR 8/18-19 3ರಿಂದ ಪ್ರತಿವಾದಿಗಳಿಗೆ ಜಂಟಿ ಖಾತೆ ಮಾಡಿ ಕ್ರಮಬದ್ಧ. ದಿಸ್ ಇಸ್ ದಿ ಸಾಲಿಟರಿ ರೀಸನಿಂಗ್ ಗಿವನ್. ಅಂಡ್ ಡೆಪ್ಯೂಟಿ
What is the meaning?
second the operative portion is
Siddhamma purchased
Siddhamma
2
purchased in 1932
in survey number 79.
79
Ah.
2 acres.
The total extent of land was 5 acres.
5 acres.
Ah.
That is also not disputed.
2
acres, the purchase is also not disputed by both the authorities, by the revenue authorities.
Yes.
But the only solitary reason given is the sixth respondent ಪಾವತಿ ಖಾತೆ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ಪ್ರಶ್ನೆ ಮಾಡಿರೋದ್ರಿಂದ ಇವ್ರ ಹೆಸರು ಮಾಡಿರೋದು ಸರಿ.
Which lands?
The same land.
How can it be same land, sir? 5 acres ಇದೆ ಅದರಲ್ಲಿ.
ಹೌದು.
So what you purchased, are you claiming from Siddhamma?
Yeah, I mean,
You are claiming through Siddhamma?
my ancestor is Siddhamma.
Siddhamma.
ಹೌದು.
2 acres were purchased.
ಹೌದು.
2 acres of land ನಿಮ್ಮ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಸಿದ್ದಮ್ಮ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇಲ್ವಾ?
ಇದೆ 1932 ಪತ್ರ ಇದೆ. 19 that is annexure G.
Which is the latest RTC?
RTC. Ali. Last me kindly come to page 43 RTCಗಳು 2001ರಿಂದ 2ರಿಂದನು up to page 53 ವರ್ಗುನು ಮಾದಯ್ಯ is ಅಲ್ಲ ಮಂತಮ್ಮ ಸಿದ್ದಮ್ಮ ಅಲ್ಲಿ ಆಕ್ಚುಲಿ 2ನೇ ಮಗ ಮಂಟಯ್ಯ ಅಂತ ಮಾದಯ್ಯ ಅಂತ. ಈ ಒಂದು ರಾಂಗ್ ಎಂಟ್ರಿನೇ ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡು ಮಾದಯ್ಯನ ಮಗ ರಾಜಶೇಖರ ಅಂತ ಹೇಳಿ ಅವರು ಪರ್ಚೇಸ್ ಮಾಡಿ ದೇ ಕ್ರಿಯೇಟ್ ಎ ಸೇಲ್ ಡೀಡ್ ಅಂಡ್ ದೆನ್ ಇಟ್ ಇಸ್ ಸೋಲ್ಡ್ ಟು ಒನ್ ಅನಂತ ಹೂ ಇಸ್ ದಿ 4th respondent before your lordship. And even the assistant commissioner would also say that I would just pinpoint just 2 lines from the order of the assistant commissioner at page 22, page 22, last paragraph.
In terms of the RTC,
ಹೌದು.
right from the year 1957-58,
ಹೌದು.
there is a mutation entry
That's a wrong entry.
in terms
ಮಾದಯ್ಯ
of
ಅಂತ ಮಾಡಿದ್ರೆ ತಪ್ಪು.
1420 of 1957-58.
ಹೌದು
ಕ್ರಯ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
ಹೌದು.
ಕ್ರಯ
ಮಾದಯ್ಯ ಮಂಟಯ್ಯ ಅನ್ನೋದ್ರ ಬದಲು ಮಾದಯ್ಯ ಅಂತ ತಪ್ಪು ಉಲ್ಲೇಖ ಆಗಿರೋದನ್ನೇ ಅವ್ರು ದುರುಪಯೋಗ ಮಾಡ್ಕೊಂಡು, ದಟ್ ಈಸ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ ವಾಸ್ ಮೈ ಕೇಸ್ ಬಿಫೋರ್ ದಿ ಅಥಾರಿಟೀಸ್. ಮಂಟಯ್ಯ ಅಂತ ಬರ್ಬೇಕಾಗಿತ್ತು, ಎರಡನೇ ಮಗ ಸಿದ್ದಮ್ಮನವ್ರ ಮಗ. ಮಾದಯ್ಯ ಅಂತ ತಪ್ಪು ಉಲ್ಲೇಖ ಮಾಡಿರೋದ್ರಿಂದ ಮಾದಯ್ಯನ ಮಗ ನಾನು ಅಂತ ಹೇಳಿ ಇವರು ದಿ ರಾಜಶೇಖರನ್ ಅವರು ನಾನು ಮಾದಯ್ಯನ ಮಗ. ಬಟ್ ವೋಟರ್ ಲಿಸ್ಟ್ ಶೋಸ್ Rajshekar is not the son of Madaya, but is son of Rachaya. Voter list also I have produced. Your lordship would find that.
So therefore, these becomes disputed questions of title.
No, of course, your
You will have to go before the civil
declaration of title ಆಗ್ಬೇಕಾಗುತ್ತೆ.
They will not be able to decide all this.
ಇಲ್ಲಿ ಈಗ ಒಂದು ಕ್ರಯ ಪತ್ರ ಇದೆ.
Madaya is the son of Siddhamma.
It's all a matter of
Mantaya is the son of
Siddhamma. It's all a matter of trial. It has to be gone before. I would only request at this point, let me not waste the court's time. Let liberty be reserved to the petitioners to approach the civil court.
Is always there with you.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ಲಿಮಿಟೇಷನ್ ಪ್ರಶ್ನೆಗಳೆಲ್ಲ ಬರೋದ್ರಿಂದ that liberty can.
ಪ್ರಶ್ನೆ ಏನು ಬರೋದಿಲ್ಲ ಇದರಲ್ಲಿ. ಯಾಕಂದ್ರೆ Siddhamma has not disposed it of to anyone.
No one.
And those people also are not claiming that they have purchased it from Siddhamma or anything like that.
ಇಲ್ಲ.
But they are saying we are the legal heirs. So
ಅದು ತಪ್ಪದು. ಅದು see, it's a matter for a full-fledged trial. I know the limitations of my submission. My only request is that the matter may be disposed of at this stage itself. Let them approach the civil court anta ಒಂದು ಸಾಲ್ ಬರೆದ್ರೆ, then I would go to the civil court and
so you approach the assistant commissioner.
ಅದ್ಯಾಕಂದ್ರೆ
what did the assistant commissioner
assistant commissioner categorically said ಇಲ್ಲ ಒಂದು ನಿಮಿಷ annexure B
ಕಾನೂನು ರೀತಿಯ ಕ್ರಮವಹಿಸಲು
ಅಲ್ಲಿ ಇಲ್ಲಿ 22ನೇ ಪುಟದಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್, ಸಿದ್ದಮ್ಮನವರ ಮಕ್ಕಳು ಮತ್ತು ಮೊಮ್ಮಕ್ಕಳು ಜಮೀನಿನ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ 22. ಸಿದ್ದಮ್ಮನವರ ಮಕ್ಕಳು ಮತ್ತು ಮೊಮ್ಮಕ್ಕಳು ಜಮೀನಿನ ಹಕ್ಕುದಾರರಾಗಿದ್ದು ವಾರಸುದಾರರಾಗಿರುತ್ತಾರೆ. ಮಾದಯ್ಯ ಬಿನ್ ಸಿದ್ದಮ್ಮನವರ ಹೆಸರಿನಲ್ಲಿ ಖಾತೆ ಇದ್ದು ಜಮೀನಿನ ಅದು ಇದಾಗಿದೆ. 6/2012-13 ದಿನಾಂಕ 27/7 ಮೇರೆಗೆ ಮಾದಯ್ಯನವರ ಮಗನೆಂದು ರಾಜಶೇಖರ್ ಅವರಿಗೆ ಮ್ಯೂಟೇಷನ್ ಅಂಗೀಕಾರವಾಗಿ ಖಾತೆ ಬದಲಾವಣೆ ಆಗಿರುತ್ತದೆ. ಹಾಜರುಪಡಿಸಿರುವ ಮತದಾರರ ಪಟ್ಟಿ ಪರಿಶೀಲಿಸಲಾಗಿ ರಾಜಶೇಖರಯ್ಯನವರ ತಂದೆ ರಾಚಯ್ಯ ಆಗಿರುತ್ತಾರೆ. ಕಂದಾಯ ಅಧಿಕಾರಿಗಳು ರಾಜಶೇಖರ್ ಅವರು ಅಧಿಕಾರಿಗಳಿಗೆ ರಾಜಶೇಖರ್ ಅವರು ತಪ್ಪು ಮಾಹಿತಿ ನೀಡಿ ಮಾದಯ್ಯನವರ ಮಗನೆಂದು ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಕಂದಾಯ ಅಧಿಕಾರಿಗಳು ಸಹ ಸ್ಥಳದಲ್ಲಿ ವಿಚಾರಣೆ ನಡೆಸದೆ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸದೆ ಮ್ಯೂಟೇಷನ್ ಅಂಗೀಕರಿಸಿ ಖಾತೆ ಮಾಡಿದ್ರು ತಪ್ಪು ಕ್ರಯವಾಗಿರುತ್ತದೆ. ಹಾಜರುಪಡಿಸಿರುವ ಕ್ರಮ ಅಂತಿರ್ಬೇಕು, ಮೋಸ್ಟ್ಲಿ ತಪ್ಪು ಕ್ರಮ ಅಂತಿರ್ಬೇಕಾಗುತ್ತೆ.
ಬಟ್ you have no grievance regarding the entry of the name of Madaya.
ಅಲ್ಲ, ಮಾದಯ್ಯ ಅದು ತಪ್ಪು, ಅದು ಮಂಟಯ್ಯ ಅನ್ನೋ ಬದಲು ಮಾದಯ್ಯ ಅಂತ ಮಾಡಿದ್ರೆ
ಇಲ್ಲಿ reading this paragraph.
ಅಲ್ಲ, ಮಾದಯ್ಯ ಅನ್ನೋದು ತಪ್ಪು.
ಮಾದಯ್ಯ ಅವ್ರದ್ದು 57-58 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಆಗಿರೋದು.
ಹೌದು.
You are aggrieved by the entry of the name of Rajshekar.
And later to the other respondent.
According to you, according to the voter ID, Rajshekar's father is M. Rachaya.
ಹೌದು.
And not Madaya.
ಹೌದು. Correct.
But the problem is, you have not challenged the earlier mutation order.
ಅಲ್ಲ, ಅದನ್ನ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ಮಾಡಿ your lordship finds it at entry.
How can you do it now in the year?
ಇವ್ರು 3 ಜನದ ಪರವಾಗಿರು ಎಂಟ್ರಿ ಮಾಡಿದ್ದಾರೆ. 2000 page 59 ನಲ್ಲಿ ಇವರು ತಕರಾರು ಕೊಟ್ಟು ಈ ಪುಟ್ಟರಾಜ್ ದಿ ಪೆಟಿಷನರ್ಸ್ ಬಿಫೋರ್ your lordship their names are entered. ಈಗ ಇವ್ರುಗಳು ಹೆಸರುಗಳು ಹೋಗಿ ಅವ್ರದ್ದು ಹೆಸರು ಬಂದಿದೆ. ಅಲ್ಲ, ಬರುವಂತ ಸಂಭವ ಇರೋದ್ರಿಂದ ಐ ಆಮ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. page 59 annexure M series 2008 ಇಂದ 1819 ಇಂದ 23-24ನೇ ಸಾಲಿನವರೆಗೂ ಇವ್ರ ಹೆಸರು ಬರ್ತಾ ಇದೆ. ಇವತ್ತಿಗೂ ಪೆಟಿಷನರ್ಸ್ ಹೆಸರು ಬರ್ತಾ ಇದೆ. ದೀಸ್ ಆರ್ ಆಲ್ ದಿ ಪ್ರಾಜಿನೀಸ್ ಆಫ್ ಇವರು ಈ ಪುಟ್ಟರಾಜು ತಾಯಮ್ಮನವರೆಲ್ಲಾನು
ಪೌತಿ ಖಾತೆ ಮಾಡಿಸಿಕೊಂಡು ಈಗಾಗಲೇ ರಿವಿಷನ್ ಅರ್ಜಿದಾರರಿಗೆ ಕ್ರಯ ಮಾಡಿಕೊಂಡಿರುವುದರಿಂದ ಸೇಲ್ ಡೀಡ್ ಆಗೋಗಿದೆ. ಏನ್ ಮಾಡೋದು?
ಅದು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ಸೊ ಐ ಹ್ಯಾವ್ ಟು ಗೋ ಬಿಫೋರ್ ದಿ ಸಿವಿಲ್ ಕೋರ್ಟ್.
ಬರ್ಕೊಳ್ಳಿ. Learned HCGP takes notice for response number 1 to 3. Notice to response number 4 and 5 is not necessary for the following reasons. Next para. the petitioners are aggrieved of the impugned order dated 3/10/2023 passed by the Deputy Commissioner, Mandya District in RP number 104 of 2021. Full stop. Next para. It is the contention of the petitioners that their grandmother, their grandmother, Srimati Siddhamma, purchased 2 acres of land out of 5 in survey number 79. 79 or 79/1 na?
79 ಅದು ಪೋಡಿ ಆದ್ಮೇಲೆ 79 1 ಅಂತ
79
79
of ದೇವಲಿಂಗನಪುರ, Kasaba Hobli, Malavalli Taluk, under registered CLD dated 6/5/1932. Full stop. Consequent to the sale deed, the name of Srimati Siddhamma was entered in the land records. And after Podi, a new number 79/1 was given to the 2 acres of land which was purchased by Siddhamma. Full stop. Nevertheless, the petitioners filed an appeal before the Assistant Commissioner, Mandya Subdivision, RMIS 276 of 2014, invoking section 136(2) of the Karnataka Land Revenue Act of 1964. Calling in question mutation entries made in MRH 6 of 2012-13 and MRH 9 of 2012-13, whereby the names of response number 5 and 4 were entered in the RTC in column number 9. Full stop. The Assistant Commissioner allowed the appeal and directed the Tahsildar to take action in accordance with law. Full stop. Being aggrieved, respondents number 4 and 5, or respondent number 4, approached the Deputy Commissioner, invoking section 136(3) of the Act. Full stop. Respondent number 4 had purchased the land in question under a registered CLD dated 5/11/2012. And thereafter, the name of the 4th respondent was entered in the RTC. In MRH 9 of 2012-13. Full stop. The Deputy Commissioner upheld the contention of the 4th respondent and set aside the orders passed by the Assistant Commissioner. Full stop. Next para. learned counsel for the petitioner seeks to contend that the fifth respondent, Shri Rajshekar, is not a legal heir claiming under Srimati Siddhamma, and therefore he could not have executed a sale deed in favor of respondent number 4 here. Full stop. Next para. However, learned HCGP draws the attention of this court to the RTCs produced by the petitioner. That annexure K, and submits that the name of one Sri Madhaiya, son of Siddham, was entered in the RTC in terms of mutation order bearing MR number 1420 of 1957-58. Full stop. Learned HCGP submits that the petitioner has not called in question the said mutation entry made way back in the year 1957-58. Full stop. Consequent to the death of Sri Madhaiya, it appears that the fifth respondent, Rajshekar, Sri Rajshekar, got his name entered in the land records on the basis of inheritance in terms of MR number
number H8, 2008,
8.
huh?
MR number H8,
2018.
18, 19.
1819 ಅಲ್ಲ ರೀ 2012 ಅಲ್ಲಿ ಅವರು ರಾಜಶೇಖರ್ ಅವರು ಇವ್ರಿಗೆ ಮಾರ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
ರಾಜಶೇಖರ್ ಅವ್ರ ಹೆಸರು ಯಾವಾಗ ಎಂಟರ್ ಆಗಿದ್ದು?
ಒಂದು ನಿಮಿಷ. That is MRH 6 ಅಂತ ಆಗಿದೆ. Just 1 month later. I'm sorry.
6 of 2012-13.
ಹೌದು.
ಅವ್ರದ್ದು ಈ ಅನಂತ್ ಕುಮಾರ್ ಅವ್ರದ್ದು
ಪೇಜ್ 26. ಪೇಜ್ 26 ನಲ್ಲಿ MRH H6 ಅಂತ ರಾಜಶೇಖರ್ ಹೆಸರಿಗಾಗಿರೋದು.
ಕರೆಕ್ಟ್. 6 of 2012-13.
ನಂತರದಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಈಸ್ ಇವರು ಅನಂತ್ ಕುಮಾರ್ ಆಗಿರೋದು ರಾಜಶೇಖರ್ ಇಂದ. ದಟ್ ಈಸ್ H9.
The learned HCGP would therefore submit that the question as to whether Madhaiya is the legal heir of Srimati Siddhamma and whether the fifth respondent, Shri Rajshekar, is the legal heir of Shri Madhaiya or otherwise are all disputed questions which cannot be decided by the revenue authorities. Full stop. Next paragraph. Having regard to the facts narrated herein above and the contentions of the learned HCGP, this court is of the considered opinion that the assistant commissioner could not have allowed the appeal filed at the hands of the petitioners herein. Full stop. the deputy commissioner also could not have entered into disputed questions of title. Full stop. The revenue authorities should have directed the petitioners herein to approach a competent civil court to get a declaration of title. Full stop. Next paragraph. In that view of the matter, the writ petition stands dismissed. While granting liberty to the petitioners to approach a competent civil court to get a declaration of their title. Full stop. As and when the petitioners secure a declaration in their favor, comma, they will be entitled to have their name entered in the land records. Full stop. Ordered accordingly. Published.
Serial number 3 is H.V. Devaraju.
That order of the assistant commissioner and deputy commissioner is challenged. That where that petitioner hearing that the entered in agreement that he was put in position 1998. By virtue of the agreement that he was filed a suit.
Agreement of sale.
Agreement of sale. 12/10/1998. That by virtue of the agreement of sale, he was put in position. He was put in position. And then he was filed a suit that 1628/2004, which came to be decreed and also granted temporary injunction against them, interfere as well as not to alienate.
Decree for a specific performance.
Specific performance and also granted injunction in favor of the petitioner. But in the meanwhile, what happened that sale deed was executed in favor of the fifth respondent.
Yavaga?
That is on 16/10/2004.
16/10/2004. 2 months before the
suit was filed.
Before the suit was filed.
Yes, yes, that. Agreement that 12/10/1998.
Judgment and decree yavagagidu?
The decree was passed. That the 21/4/2006.
21/4/2006.
That the sale deed was executed in favor of the petitioner through execution.
By the court?
By the court. On 19/1/2007. That the way that it is in the based on that earlier sale deed, mutation has affected in his favor, fifth respondent. I have filed an appeal before the assistant commissioner. The assistant commissioner set aside and remitted back to the Tahsildar to consider that judgment as well as that sale deed in favor of the petitioner and to pass an order. Tahsildar that considering all this climate by virtue of the sale deed as well as that sale deed executed by the court of law, that order to mutate in my name. That order has been challenged before the assistant commissioner. But in the meanwhile, the fifth respondent filed a suit for injunction against the petitioner herein. That is suit in OS number 1106/2011. That came to be dismissed on merits. And way that he has filed a RA. In RA 40/2015, under which he has sought for temporary injunction against me that not to interfere. Where observation that agreement to sell that position was delivered, where the court has protected my position and sale deed executed by the court, therefore that injunction application rejected. Subsequently, that appeal is been withdrawn. And later now that he has filed a suit for declaration, declared that he is the owner and also declared that sale deed as well as the decree which has been passed in my favor has to be set aside. In the meanwhile, where that in the second round of the appeal assistant commissioner, the records finding saying that before filing of the suit, there was a sale deed in his favor. Therefore, the mutation has to be effected in his name. That is the findings which is given. That is the finding has to be given only trial court, where that it is a position has given to the agreement, where my position has been protected or not. In the first round, the deputy commissioner, annexure J, may kindly be in the first round, given a directions saying that Annexure J, page 91, first the assistant commissioner has to decide whether the revenue courts have a jurisdiction. May kindly in page 96, may kindly. Annexure J, page 91 starts. Page 96.
You are agreed of the orders of the deputy commissioner.
Both the assistant commissioner as well as deputy commissioner. This is the first round. Now, so later the assistant commissioner and deputy commissioner both have concurrent. The first round, the deputy commissioner remitted back. While remitted back, this is the observations made in the remitted back, page 96. May kindly page 96 after the sixth line, but has not considered the point whether the second respondent has got a jurisdiction to adjudicate legality or otherwise of the decree passed by the Honorable Civil Court, directly or indirectly. Therefore, in my opinion, the second respondent consider the facts and documents produced by both the parties and prosecute manner as to not given a proper and valid. Then after remitted back, again the assistant commissioner passed a similar order which was passed in the earlier. The deputy commissioner now that confirming that order, that giving a finding where contrary to the decree which has been passed in my favor. But that has to be that the civil court has to that look into has to.
So presently, an OS suit is also pending.
That is a suit filed by fifth respondent.
HCGP takes notice for response number 1 to 4.
1 to 4.
Issue notice to respond number 5.
Right.
Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned HCGP. Full stop. Next para. Learned counsel for the petitioner submits that the respondents Tahsildar, Bangalore East Taluk, the assistant commissioner Bangalore North Taluk, North Subdivision, and the deputy commissioner Bangalore Urban District.
Yes.
Have all fallen into error in coming to a conclusion that although the petitioner herein obtained a judgment and decree in his favor in OS number 1628 of 2004 on 21/4/2006, consequent to which a sale deed was executed by the court in his favor in respect of the land in question, nevertheless, the fifth respondent herein had purchased the land in question on
16/10/2004.
16/10/2004, much prior to the execution of the sale deed in favor of the petitioner, therefore, the sixth respondent is entitled to have his name continued in the land records. Full stop. Learned counsel submits that this finding of the authorities is contrary to the express provisions contained in section 128 of the Karnataka Land Revenue Act 1964. Full stop. Whenever a competent civil court passes a decree in favor of a person, such person is entitled to have his name entered in the land records, and the revenue authorities cannot sit in judgment over such orders passed by the competent civil court. Full stop. Moreover, the sixth respondent has filed OS number
that 783/2016.
2016,
yes,
seeking a declaration in his favor and challenging
decree passed in my favor.
Judgment in decree passed in favor of the petitioner,
yes,
and setting aside of the sale deed,
yes,
executed in favor of the petitioner.
Yes.
Full stop. Next para. Consequently, there shall be an ad interim order of stay of orders at annexures
Q and P, my lord.
Q and
P. Short for annexure Q, the order of the deputy commissioner.
ಒಂದೇ
ಒಂದೇ ಮಾಡಿ. Q and P.
ಏನ್ ಪ್ರಯೋಜನ?
Q and P, may permit.
ಹಾ?
ಎರಡು stay ಆಗ್ಬೇಕು.
In fact, you have to ask for stay of the order of the Tahsildar also. ಏನ್ ಸ್ಟೇ ಮಾಡಿದ್ರು ಏನ್ ಪ್ರಯೋಜನ ಆಗಲ್ಲ. Your name cannot be
That findings, my lord, which is
annexures P and Q till the next date of hearing.
one correction, my lord, that here in the fifth respondent, my lord, fifth respondent, my lord dictated in the sixth respondent.
Fifth respondent. Fifth respondent.
Much.
Number 5, Arkesh Kumar Gowda.
I pay for the petition. My lord. My lord, I have made an application under forum number 50 of the regularization of the unauthorized occupation, my lord. There is a direction from the first respondent as well as from the KAT, my lord, to consider the applications.
ಏನ?
I made an application,
In form number 50.
forum number 50.
ಹಾ.
There is a direction from the first respondent as well as from the KAT, my lord, to consider the applications prepared by me, my lord. I made a representation to also to consider the applications that has been prepared in the year 1991, but still it has not been considered.
There is a direction by the KAT.
Okay,
How did you go?
one Chinnappa, my lord, had also made a representation for the regularization of the unauthorized occupation. After knowing that, my lord, I preferred an appeal before the first respondent. The first respondent allowed the appeal, my lord. Thereafterwards, my lord,
ಹಂಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ ರೀ. ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಹೇಳ್ಬೇಕು.
assistant commissioner,
ನಾವು ಪ್ರತಿ ಸರಿ ತೆಗೆದು ನೋಡ್ಬೇಕಿಲ್ಲ ಅಂದ್ರೆ.
assistant,
ಹಾ.
assistant commissioner. Thereafter, my lord, the assistant commissioner allowed the appeal. And my lord, the one Chinnappa agreed by the order of the assistant commissioner, preferred an appeal before the Karnataka
There is
appellate
the
tribunal.
question of the parties going before the authorities
Authority,
even before orders are passed by the committee.
committee. Adi
Committee has not passed any order.
he was claiming that it has already been regularized. Therefore, my lord, I preferred an appeal before the first respondent. Afterwards, my lord, the one Chinnappa,
Where is that order?
page annexure B, my lord, page number,
Yes. Page number 14.
page number 14. Thereafter, my lord,
ಏನಾಯ್ತು?
there is a direction from the first one, from the assistant commissioner to consider the applications of the petitioner as well as one Chinnappa and dispose accordingly to the second respondent,
To consider both the applications.
both the applications. And thereafter, my lords, agreed by that order, one Chinnappa preferred an appeal against the order of the assistant commissioner, my lord.
Before?
KAT, before the Karnataka appellate tribunal, my lord, the appeal came to be dismissed.
As per the AC order, they have to consider both the applications.
Both the claims.
Both the applications. I have made a representation to consider the applications, and they have not considered the applications, my lord.
But idರಲ್ಲಿ why have you not made them a party?
My lord, even their applications may also be considered, my lord, since
What? You do not know.
since. Please.
These are the basic faults you advocates are doing. You cannot be permitted to secure an order at the hands of the court when another private party is contesting the matter. In all fairness, you have to implead them.
I'll implead, my lord. A week time may be granted, my lord. I'll implead them as party.
Learned HCGP takes notice for both the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned HCGP. Full stop. Next para. On going through the material available on record, this court finds that one Sri Chinnappa has been contesting the matter against the petitioner in respect of the very same land.
Please, my lord. But
Seek-
KIT ಮೇಲೆ appeal ಆಗ್ಲಿಲ್ಲ.
Grant of
It was completed. KIT ನಲ್ಲಿ
seeking regularization of unauthorized
Unauthorized
occupation. Full stop. However, the said Sri Chinnappa has not been made a party to these proceedings. Full stop. Learned counsel for the petitioner makes an oral request permitting the petitioner to implead Sri Chinnappa as a party respondent to these proceedings.
Please,
Full stop. The submission is accepted. Full
Please.
stop. The petitioner is permitted to implead Sri Chinnappa, son of late Muniyappa, as a party respondent to these proceedings. Full stop. Learned counsel shall carry out the amendment forthwith.
please,
Full stop. Next para. Issue notice to the newly impleaded respond number 3.
please. Much obliged.
Number 5. Clarification,
Petition. Writ of mandamus. Consider the application filed by the petitioner, form number 50 and 53, my lord. 9/7/1991. Annexure A,
Has
para,
not been considered.
not been considered.
You have filed applications once in form number 50
50 and also.
and
53.
thereafter in 53.
Yes, my lord. And also filed a written representation also.
ಯಾವ್ದ್ರಿ ಅದು?
17659 of 23.
Same orders.
17659 of
17659 of
ಫಾರಂ
23.
23 ಇದೆ, ಅದ್ರಲ್ಲಿ 51 sir.
ಈ ಎರಡು ಹಾಕಿದ್ರಲ್ಲಿ.
ಇದು ಎರಡು ಇದೆ.
Has filed applications in form number 50 and 53.
Yes.
Huh? Seeking regularization of unauthorized occupation of 2 acres in survey number 97 of Ukkasagara village, Kasaba Hubli, Anekal Taluk. ಅದು ಒಂದು ಸೇರಿಸ್ಕೊಂಡು ಈ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಹೆಚ್ಚಿದೆ. ಇಲ್ಲಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಅನೆಕ್ಷರ್ ಎಲ್ ಅಂತಿದೆ, ಅದನ್ನ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟು ಅನೆಕ್ಷರ್ ಸಿ ಅಂತ ಮಾಡ್ಬಿಡಿ. Yes.
Number 6. Mohan BK, 79 AB.
79 A and B.
ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ 4 weeks are granted to the learned HCGP to file memorandum of appearance.
This petition under
79
79 A and B, my lord.
2013 AC order, parties are same.
All right. Same order as in 327
3271 of 22.
of 2022
Yes, please.
to appear before the Assistant Commissioner on 58th of March.
Obliged, my lords.
Serial number 7. Sundaresh C.
Petition in this case. It's a matter pertaining to regularization of unauthorized cultivation.
Form 53. then.
Form 53.
Oh,
Form
same.
53, Form
Same,
53 has been
ಮಾಡಿಲ್ಲ.
filed.
Same.
Yes.
Serial number 8. Manisha yes. Okay.
May please.
My lord, these are 3 matters, serial numbers 8, 10, 11. All of them, my lord, covered by my lord's earlier order at page
order.
number
Interim order.
60.
Interim order.
Howದು, 60, page number 60 in this case, my lord.
Page number 60.
60. The first case, H3. The orders passed on 108 K, my lord, cancelling the grant of the same taluk, my lord, similar facts. Tagoli chit is issued in the year 2012. Page
Learned
number 20.
AGA takes notice for all the respondents. Learned counsel for petitioners, he directed to serve a copy of the writ petition along with annexures on the learned AGA. Next para. Learned senior counsel Shri P.P. Hegde, appearing on behalf of the petitioner, submits that under similar circumstances, in WP number 28991 of 2023, this court, by order dated 9/1/2024, has stayed such impugned orders. Full stop. The learned senior counsel prays for similar interim orders. Consequently, ante irodonna continue maಡು. Yes. Page number 60 ಅಲ್ಲಿ.
Serial number 9, MJ Alva.
My lord, 10 and 11.
8, 10, 11.
11.
Same order.
Most grateful.
Serial number 9, MJ Alva.
ಹೇಮಾವತಿ ಅದು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ಸ್. ಹೇಮಾವತಿ ಪ್ರಾಜೆಕ್ಟ್ ಕೊಡ್ತಾರೆ.
Ten 11 order pass. Serial number 12, Prakash T. Abba.
My lord, the annexure A, B and C orders are under challenge, my lord. Annexure A, my lord, is the, annexure C is the order passed by the Tahsildar. My lord, what happens is, the land tribunal has granted occupancy right in favor of the petitioner in the year 1980. Thereafter, my lord, form number 10 was issued. The mutation was sanctioned. Entries were certified and transferred to RTC. My lord, in the year 2005, my lord, the Tahsildar initiates RRT proceedings and passes an order as per annexure C, reducing my extent to 25 guntas and enhancing the extent of my landlord to adding my 2 acre 20 guntas was granted to me. He reduces it to 25 guntas to my holding, and the remaining extent he increases into the landlord's this one. Lord, earlier the land tribunal order was challenged by the landlord. Lord, that I have produced that annexure J. Lord, that clarifies the entire aspect of the matter. Annexure J, page 79. It is a very short order, my lord. May I read, my lord?
Annexure?
Annexure J, my lord. In page 79. Typed copy, my lord, is at page 84. Lord, page number 3, the last paragraph, Lord, would be the observation of the Honorable Court.
Why you had to file the writ petition?
I have not filed, Lord, by the landlord, who is the contesting respondent here.
Your name is Muni Hanumanai.
Muni Hanumanai. Lord, on page, internal page number 3, the last paragraph. The land tribunal has recorded the statements of the petitioner and respondent number 3 and 4 hearing. Respondent number 3 hearing has stated in his statement recorded by the tribunal that he has not been cultivating the land covered by the mango trees. His brother Munianmaya has Mari Kempaya has left the cultivation of the land. Typing is not so clear. I will read the typed copy.
Typed copy correct agide.
Irakampaya has left the cultivation of the land. Since he secured
his brothers Irakampaya has left the cultivation of the land.
Cultivation of the land, since he secured a job in Yeshwantpur and requested the tribunal to register him as the occupant of the land under his cultivation. In his statement, Irakampaya has stated that neither he nor his brother Muni Hanumaya was cultivating the land covered by the trees. he has stated that he has no connection with the land in question and requested that his brother Munianmaya may be registered as the occupant of the land under his cultivation. The petitioner has stated, petitioner, my lord, is the landlord. Petitioner has stated in his statement that the land covered by mango and coconut trees. But there are three areas. One is covered by mango, another one is coconut, and the remaining vacant land was cultivated by Munianmaya. Yes, petitioner has stated in his statement that the land covered by mango and coconut trees was in his possession and enjoyment, and he had not given this portion of the land to anybody. He had no objection to register respondent number 3, Munianmaya, as the tenant of the land cultivated by him, that is Munianmaya. Irkempaya was not cultivating the land, but only Munianmaya was cultivating the land, cultivating the same, and he had no objection to register him as the occupant of the land under his cultivation. On the basis of these statements, the land tribunal has passed the impugned order rejecting the claim of Irkempaya, respondent number 4 hearing, and registering Munianmaya, respondent number 3 hearing, as the occupant of the land under his cultivation, subject to measurement, and directing the special tahsildar to take action to get the land measured and to take further action as per rules. This impugned order passed by the land tribunal is based on the statement of the parties and is in accordance with law, and the same cannot be interfered with. There are no reason for this court to interfere with the same. If there is any dispute regarding the land in question, granted to respondent number 3 after the measurement is done, it is open to the petitioner to challenge the same. So therefore, the landlord has given a statement that except the mango and coconut trees area, the remaining land was cultivated by Munianmaya, and that he has no objection for grant of occupancy right. Now, what is the extent covered is, my lord, is shown in the RTC at page, my lord.
Where is form number 10?
Form number 10, my lord, is at Annexure F, page 62. Thereafter, the survey was done and form number 10 was issued at ink page 62.
In respect of 2 acres and 20 gunta.
Yes, my lord, 2 acre 20 gunta. According to the extent shown in the RTC.
Yes.
But this form number 10 was not challenged.
Yes.
And earlier challenge to the land tribunal order was dismissed by this honorable.
Yes.
Lord, now in the year 2005, Lord, strangely the Tahsildar initiates RRT proceedings at the instance of my landlord. So what he could not get directly, he wanted to get through the Tahsildar indirectly. Therefore, my lord, for the purpose of signing the notice, my lord, some statements of the Munianmaya was taken. He's an illiterate person, and Annexure C shows that the Tahsildar, based on his statement, he modifies the land tribunal order at Annexure C, my lord. Ink page, the ink page 38, typed copy. He does not refer to the land tribunal order. Ink page 38.
The proceedings under which provision?
Lord, he does not say anything. He only says that it is RRT proceedings. RRT proceedings, my lord, is only to make any changes in the.
It is shown that you have approached the Tahsildar. Annexure C.
Yes.
Shows you have approached the Tahsildar.
Lord, it is. I would never approach the Tahsildar for reducing my extent. Then, my lord, Tahsildar has no jurisdiction to reduce the extent at all. Once
that is why I wanted to know under which provision it is initiated.
Lord,
All RRT proceedings.
the order does not.
136.
Huh?
No, 136 alle ಮಾಡ್ತಾರೆ RRT proceedings.
RRT proceedings adre.
136 ನಲ್ಲಿ Tahsildar has no.
RRT proceedings adre.
Yes,
how does the Tahsildar get jurisdiction
Yes.
to change anything after form number 10 has been issued under the provisions of the Karnataka Land Reforms Act?
ಇದರಲ್ಲಿ on order dated 6/9/2005 ಪ್ರಕರಣವನ್ನು ಕೂಗಿಸಲಾಯಿತು.
ಹ್ಮ್.
ಪೇಜ್ 38
ಹಾ,
ಪ್ರತಿವಾದಿ ಆರ್ ಗೋಪಾಲಕೃಷ್ಣ ಅವರು ಖುದ್ದು ಹಾಜರಾಗಿರುತ್ತಾರೆ. ವಾದಿ ಮುನಿ ಹನುಮಯ್ಯ ಅವರು
ಹೇಳಿಕೆ
ಹೇಳಿಕೆ
ಕೊಟ್ಟಿರ್ತಾರೆ.
ನೀಡಿ-
What
ಅಲ್ಲ. Why he has shown as if this person has approached the Tahsildar.
Yes,
Why should he approach?
he is seeking rectification ಅಂತ.
Where is the application or petition or appeal?
Nothing, my lord. Only ಹೇಳಿಕೆ ante, that's what he says.
For that we may have to call the file and
The entire proceedings are
We say.
unauthorized, illegal. It could not have been initiated only.
ಅಲ್ಲ ಬಟ್ ಇದರಲ್ಲಿ
ಮಕ್ಕಳೇ.
ಅಲ್ಲ ಹೇಳಿಕೆ ಅಂತ ಹೇಳಿ
ಹೆಂಗೆ where see,
ಅವ್ರು-
he has
ಅವ್ರು-
shown him as the petitioner.
ಕರೆಕ್ಟ್ ಅವರು
Why he has not approached him? Why should he approach him?
that is his
That
content.
too, my lord, several years after form number 10 was issued by him.
Learned
Yes, I am in possession
AGA.
of only 25 guntas.
takes notice for response number 1 to 4. Issue notice to response number 5 to 8.
Yes.
Learned counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that long after the orders passed by the land tribunal on 3/8/1980 granting occupancy rights in favor of the petitioner in respect of 2 acres and 20 guntas of land. But ನೀವು ಇಲ್ಲಿ synopsis ಅಲ್ಲಿ 3 acres and 21 guntas ಅಂತ
ಅದು
ಬರೆದಿದ್ದೀರಾ.
total extent. ನಾನು apply ಮಾಡಿದ್ದು form number 7. Total extent.
2 acres and 20 guntas of land in survey number 11/7. Of
Agra village.
Agra village,
Agra village, my lord.
Kengeri Hubli,
Kengeri Hubli.
Bangalore South Taluk. And the same being confirmed at the hands of this court in WP number 28153 of 1991 dated 29th of January 1997. And thereafter, form number 10 having been issued by the
Tahsildar.
Tahsildar. ಎಲ್ಲಿ ಅದು ಫಾರ್ಮ್ ನಂಬರ್ 7?
Form number 10, my lord, annexure F, page 62. Page 62.
Form number 10 being issued by the Tahsildar on 21st of October
1981.
1981. ಅಲ್ಲ 20th of October 1981,
80.
comma the
Mutation was also accepted.
fourth respondent Tahsildar seems to have initiated proceedings at the instance of the landlord Shri
R. Gopal Krishna.
Gopalakrishna. Full stop. Where is that order of the Tahsildar that we saw now?
At my lord, annexure C in page 38.
38.
Typed copy.
Learned counsel submits that the proceedings are registered as RRT bracket 1 dispute bar 533, 650, 651 bar 0506 showing the name of the petitioner as petitioner and the name of Sri R. Gopalakrishna as respondent. Full stop. Learned Counsel submits that the petitioner did not approach the special Tahsildar, and it is not known as to how the proceedings were registered and initiated.
Yes.
Full stop. Nevertheless, the Tahsildar passed an order on 6/9/2005 reducing the extent of lands in favor of the petitioner to 25 guntas and directed registration of 2 acres and 26 guntas in favor of Sri Gopalakrishna.
2 acre 36 kunta.
2 acres 26 guntas. Page number 39 ಅಲ್ಲಿ ನೀವು ಬರೆಯುವಾಗ ತಪ್ಪದಿದ್ದೀರಾ?
Sir, type ಮಾಡಿ. Yes.
2 acres 36 guntas.
ಹೌದು.
When the full stop, when the petitioner challenged the same before the assistant commissioner, invoking section 136(2). The assistant commissioner dismissed the same, and the deputy commissioner also has upheld the orders passed by the Tahsildar as well as the assistant commissioner. Full stop. Learned Counsel submits that it was impermissible for the Tahsildar to have initiated proceedings under section 136 proceedings under section 129.
Yes. A disputed case, 129.
In respect of an orders passed by the land tribunal. Full stop. Next para. Consequently, there shall be an ad interim order of stay
Annexure A, B and C.
of annexures A, B and
C. Malad.
C till the next date of hearing.
Correct.
13. Shruti C. Chengati.
I'd made an application in form number 53, which comes to be dismissed by the deputy commissioner, via annexure J at page 27. My lord would see at page 22, the sketch shows, the sketch prepared by the Taluk
Deputy
survey.
Commissioner.
Hello?
Deputy
Sketch it-
Commissioner.
Sorry,
Deputy Commissioner.
deputy commissioner,
Application filed under section 94A.
94B, 108 CC, rule 108 CC has been dismissed by the deputy commissioner by order dated 9/10/2023, and an endorsement is issued to me pursuant thereto, claiming that I was not
For regularization of unauthorized occupation.
unauthorized occupation.
Huh?
Yes, yes, my lord.
How will the deputy commissioner get the jurisdiction?
They are claiming power under one circular, my lord. If my lord would see at annexure, page 27, there's a
Huh.
circular which they refer to at reference 1. Sarkara Patra Sankhya RD 136. They claim that the deputy commissioner, if my lord would see at page 30,
Ah.
the paragraph just below the table, they claim that that circular has empowered the deputy commissioner to
Ah.
dismiss applications. But my lord would see this is there is the sketch at section at page 22 shows that I'm in unauthorized cultivation of the land, shows that I am in possession and cultivation of 4 acres, 30 guntas. And on previous occasions also, the Tahsildar, without any power under the statute or in a procedure completely not prescribed by law, has attempted to dismiss my application. And the deputy commissioner had directed him to do a survey, undertake a proper survey, and to send me a statement to basically tell me what is the status of my application and to report compliance to the deputy commissioner. The sketch shows that I'm in possession and cultivation of 4 acres, 30 guntas of land. Thereafter, this order is passed.
Have you verified that circular?
My lord, that circular,
Does it empower the deputy commissioner
My lord, but it is
consider an
against-
application
My lord, it
under
is,
section 94B and pass orders?
my lord, it is against the statutory scheme, my
Yes.
lord, but there is
Yes.
such a circular in,
Yes.
I found a copy of. It is against the statutory scheme.
Hmm.
But the circular has ostensibly conferred the deputy commissioner with the power to dismiss ineligible applications.
Madam, copy ಕೊಡಿ. Full ಬಂದಿದೆ.
Which is that particular paragraph?
Oh. Apologies, my lord, I don't have another copy to. My lord would see, at page 18, the Tahsildar had issued an endorsement to me on 6/12/2022. Claim when I had made a representation at the reference, my lord would see that my representation dated 30/11/2022 is referred to. This is on page 18. Page 18, my lord has. The reference is of the representation made by me on 30/11/2022. The endorsement states that there are applications pending consideration in survey number 76 of Kunikere village, but my application has been dismissed. Now on that, I address a representation to the deputy commissioner. My lord would see on page 19, there's a letter from the deputy commissioner to the Tahsildar saying that asking why my application has been rejected and asking for a revenue to be, for a survey to be done, and in accordance with law to send me a note on what is, I don't know the exact Kannada word, my lord, ಬಗ್ಗೆ ನೇರವಾಗಿ ಅರ್ಜಿದಾರರಿಗೆ ಮಾಹಿತಿ ನೀಡಿ ಈ ಕಚೇರಿಗೆ ಪಾಲನಾ ವರದಿ ನೀಡಲು ಸೂಚಿಸಿದೆ. On that, the Tahsildar makes an endorsement directing that a survey of my land be done. Thereafter, my lord would see on page 22, there is a survey that's conducted by the Taluk surveyor and the village accountant. And that survey shows that I'm an unauthorized cultivation of 4 acres, 30 guntas of land in Kunikere village, survey number 76. Thereafter, my lord would see that this Tahsildar sends a report saying that my application is ineligible. Reasons are not only that I have not started cultivation in the stipulated period of time, whereas to none of my representations, I have been intimated in this regard. And thereafter, 9/10/2023, a bulk order is passed by the DC. Blindly on the report given by the Tehsildar,
What is
dismissing
Annexure
all
C?
42 applications.
Annexure C, the sketch prepared.
Annexure
showing-
T is the sketch prepared at the direction of the Tehsildar upon instruction by the Deputy Commissioner.
Showing your occupation.
I am in cultivation of that land of 4 acres, 30 guntas. And I have been in cultivation of that land for over 40 years, my lord.
Perfect.
Now,
Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that although the competent authority to consider applications filed under sections 94 capital A and B is the Committee for Regularization of Unauthorized Occupation. The second respondent, Deputy Commissioner, Chitradurga District, has passed the impugned order dated 9/10/2023 at Annexure J, usurping the powers of the committee. Full stop. Apparently, the Deputy Commissioner has proceeded to pass such an order on the basis of a circular dated 1/12/2023 by the Government of Karnataka, empowering the Deputy Commissioner to consider all ineligible applications and to dismiss the same within a period of 1 month from the date of issuance of the circular. Full stop. Learned counsel submits that the Deputy Commissioner has sought to dismiss applications of nearly 42 persons only on the ground that the applicants are found to be not in possession of the lands claimed by them in the application. Full stop. Learned counsel has drawn the attention of this court to Annexure G, which is a sketch prepared by the Taluka surveyor showing the land in possession and cultivation of the petitioner herein. Full stop. Learned counsel would therefore submit that the impugned order passed by the Deputy Commissioner is without authority of law and without affording an opportunity of hearing to the petitioner, and therefore it is liable to be set aside. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned orders passed by the Deputy Commissioner on 9/10/2023 in respect of the petitioner hearing, till the next date of hearing.
and Annexure K, which was issued in pursuance of that order.
Annexure J and the consequent endorsement issued by the Tahsildar at Annexure K dated 28/11/2023. Full stop. Next para. Needless to observe that till the disposal of the writ petition, the possession of the petitioner in respect of the land in question shall not be disturbed. Next para. 2 weeks time is granted to the respondent state and its authorities to file statement of objections.
Number 14, G. Balakrishna Shastri.
There is an area of 2 acre 10 guntas in survey number 1 was granted, my lord, by the Deputy Commissioner in favor of my father. Then, my lord, there is issue of Sagulichet. Mutation, my lord, in their 1975-76, my lord, as per Annexure B. My lord, at page 15, my lord, your lordship says.
Mutation,
mutation.
Hmm.
Then, my lord, record of right entries, annexure C, annexure C1 and annexure C2.
Hmm.
From 78, 79, my lord, till 2000 I have produced. The name of father, my lord, is entered as the owner, cultivator, number 1. Father died. Then, my lord, I gave a representation to the deputy commissioner to make Pavati Kata in my name. Lord, the deputy commissioner as per annexure F on 23/5/2016, my lord, page 27, he wrote to the Tahsildar to make inquiry and take action on the application filed by me seeking Pavati Kata. ಉಲ್ಲೇಖ ಅರ್ಜಿದಾರ ಮನೆಯ ಬಗ್ಗೆ ನಿಯಮಾನುಸಾರ ಕೈಗೊಂಡು ಅರ್ಜಿದಾರರಿಗೆ ಸೂಕ್ತ ಮಾಹಿತಿ ಕೊಡುವಂತೆ. Then Tahsildar reported, my lord, I am an encroacher, that is land grabbing. And annexure G report he submitted to the deputy commissioner at page 28.
ಅಂದ್ರೆ ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತನಾ?
ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತಲ್ಲ, ನಾನು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದೀನಿ, ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅನ್ನೋ ಟೈಪೇ. ಅದೇ ಸೇಮ್ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಅಂದ್ರೆ ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತಲೇ.
ಗ್ರಾಂಟ್ ಆಗಿದೆ ಅಂತ ಒಪ್ಕೊಂಡ್ರೆ ಯು ಆರ್ ನಾಟ್ ಅನ್
I am not an encroacher. Then matter, my lord, case came to be registered by the special court.
ಅಲ್ಲ, 4 ಗುಂಟೆ ಕೆರೆ ಜಮೀನನ್ನು
ಎನ್ಕ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ.
4 ಗುಂಟಾಸ್.
ಹಾ.
It is not in respect of the entire land.
Entire land.
It is only in respect of 4
4
guntas.
guntas.
Yes.
Then, my lord, the special court registered a suo motu case. Annexure J, my lord, your lordship says. Page 37, my lord. Page 37, annexure J. The accused has filed objection resisting the allegation leveled against him that he has encroached 25 guntas of government land in survey number 1 of Chandrasekhara Pillai.
ಪೇಜ್ ಟ್ಯಾಲಿ ಆಗ್ತಾ ಇಲ್ಲ. ಆ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೇಳಿ.
My lord, annexure J, first page, my lord, I am reading. Annexure J, first page. The special court's order, my lord, orders on objection filed by the accused. The accused has filed objection resisting the allegation leveled against him that he has encroached 25 guntas of government land in survey number 1 of Chandrasekhara, which is a tank bed. The gist of the case is that a suo motu case has been registered against the accused based on the information given to the press by KV Kolivard Committee, chairman of the Honorable Committee on Lake Encroachment in Bangalore Urban District, Tahsildar, Bangalore South Taluk, in his report dated 28/11/2018, has confirmed that the accused has encroached 25 guntas of tank bed land, and thus the Tank Encroachment Supervisory Committee has issued notice to the accused. Resisting allegation, the accused has contended in his objection that the allegation is false and baseless, and he has not encroached nor involved in any land grabbing as alleged, and thus he has prayed for withdrawal of suo motu proceeding initiated against him. He further contended that his father, late Gullappa, son of Munishamappa, was in possession and enjoyment of land measuring 2 acres 10 guntas in survey number 1 of Chandrasekhara Pillai village, Begur Hobli, Bangalore.
What is the finding now?
Finding is, my lord, your lordship says, it is not an encroachment, it is a granted land in my favor. Page 34, my
The
lord.
complaint against the accused is dismissed
Dismissed.
as devoid of merit.
Yes. Now, my lord, page 34, para 9, the reasons at para 9, my lord, the documents as grant certificate, mutation register, RTC extract, death certificate of the original grantee, the father of the accused, demand register extract, and tax paid receipts of BBMP and the requisition dated 6/5/2016 given by the accused to the deputy commissioner for change of Pavati Kata cumulatively made out a sufficient ground to show that his father was a grantee of 2 acres 10 guntas of 20 guntas of land in survey number 1 of Chandrasekhara Pillai, and the accused has constructed a house on the said property. The letter dated 23/5/2016 by the deputy commissioner to Tahsildar to substantiate the contents of the accused that only after the deputy commissioner wrote a letter to the Tahsildar in respect of change of Kata, the problem arose between the Tahsildar and the accused. So, my lord, clear finding, my lord, is recorded and the proceedings were dropped. Now, again, my lord, I sought for change. He did not. I filed a writ petition annexure K. At page 40, my lord, para 4, this court directed the Tahsildar to consider my representation.
ಏನ್ representation?
That is, my lord, I am land grabbing. That is, my lord, for Pavati Kata.
To effect Kata.
Pavati Kata. Now, my lord, annexure A, an endorsement issued by the Tahsildar without notice to me and without hearing, saying that, my lord, I am an encroacher. No, my lord, the finding of the land grabbing committee is not challenged. That is binding on everyone. Lord, under the act, Lord, the provisions of the land grabbing committee overrides the civil codes provisions also. Section 9(3), my lord, says all questions of title, lawful possession, ownership shall be decided by the special court alone. Section 10 says, my lord, special court is a civil court. And Supreme Court has held, my lord, civil courts have no jurisdiction in respect of matters, my lord, dealt with by the special courts. It is manned, my lord, by the district judge and, my lord, an officer of the deputy commissioner under the act. The orders are final, my lord, under section 9(7). They are conclusive proof of the facts decided. Then question is, could the Tahsildar, my lord, give the impugned announcement saying that I am an encroachment? The Tahsildar in Annexure A now rejects, my lord, Pautikata, saying that Holy Ward Committee has reported that this is encroachment. Therefore, I refuse to pass inheritance kata. Now, my lord, the judgment of the land grabbing court, my lord, is final. It is binding on all the persons concerned with the land. This is after inquiry, after recording evidence. I have produced all documents before the land grabbing court. There's a charge against me. I filed objections. Tahsildar was examined. If you look to the provisions
Yes.
Uh,
of, what do you say?
Their allegation is that the entire 9 acres belongs to Nageshwara Devaru Karab Kere anta. The entire area of 9 acres is Karab anta. I accept notice and I'll place the record before the court.
No, he is only concerned with the
2 acre 10
8
guntas.
acres and 10 guntas.
guntas.
No.
No doubt
His
there's
father's name was there in the RTC. After his death, he is seeking entry on the basis of inheritance.
Tahsildar says out of 9 acres, 6 acres belongs to the temple. Other 3 acres are Karab. Ye Karab. That is
Ye
what he
Karab.
says. Ye Karab is not a government land nor that of anyone.
That we'll have to assert it.
You continued the name of his father
Father,
in the land records.
yes,
You had no difficulty.
yes.
Even now, his father's name is there in the RTC. What explanation can you give? How can you reject the application seeking entry on the basis
This
of
is of an
inheritance?
existing kata. Inheritance kata.
Huh?
Well, I will seek instructions and submit before the court.
Where is the RTC?
My lord, annexure C, mutation is annexure B, my lord, annexure C is the RTC. At page 17 typed, my lord, page 16, my lord, the Xerox I have enclosed. From 78, 79, column number 9 is Gullappa, 80, 81. Then, my lord, C2. C2. C1, my lord, 93, 94 to 96, 97. Gullappa, my lord, is in column number 9 and cultivator column. Then, my lord, annexure C2,
His entries.
97, 98 to 2000, I have produced.
Entries have continued only till the handwritten Paniswada. Computerized RTC was not made. Even in name of Gullappa.
What about the mutation entry?
ಕಾಲಮ್ ಅದ್ರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ MR16 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ಬೆಂಗಳೂರು ಜಿಲ್ಲಾಧಿಕಾರಿ ಅವರು
ಅಲ್ಲ annexure B ನೋಡಿ.
ಅದೇ LNDCR so and so ದಿನಾಂಕ 28 6.
So if that entry is there,
ಚಂದ್ರಶೇಖರ್ ಪುತ್ರ ಮುನಿಸ್ವಾಮಿ ಎಂಬುವರಿಗೆ 15 ವರ್ಷ ಪರಭಾರೆ ಮಾಡಬಾರದು ಎಂದು ಷರತ್ತಿನಂತೆ ದರಖಾಸ್ತು ಮೂಲಕ ಮಂಜೂರು. There is a mutation entry. I'll verify and submit before this court. Because subsequently,
see, you cannot ignore your own documents.
yes,
He has to give a reason.
As to why.
as to why, even though there is an entry in the mutation register showing that his father was granted these lands and his name was entered in the land records. How is it that by saying that there is some report of some committee and therefore his name cannot be entered? And there is a finding of the special court which the state has put in place to go into the question as to whether a person is a land grabber or not. Berkeley. Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. We'll stop. Next para. The petitioner is aggrieved of the impugned endorsement dated 2/1/2024 at annexure A issued by the third respondent, Special Tahsildar, rejecting the application filed by the petitioner for mutation entry on the basis of inheritance. Full stop. Learned counsel for the petitioner submits that at annexure B is the mutation register evidencing the fact that 2 acres and 10 guntas of land in survey number 1 of Chandrasekharapura, Begur Hobli was granted to the petitioner's father, Sri Gullappa, son of Munishamappa, in terms of the orders of the Deputy Commissioner in LND bracket 2 SR 118/7071 dated 26/5/1971. Full stop. In terms of mutation order in MR number 16 of 1975-76, the name of Sri Gullappa was entered in the land records. Full stop. The petitioner has made an application on 6/5/2016 seeking mutation entry in the land records on the basis of inheritance. Full stop. The learned counsel also brings to the notice of this court proceedings initiated by the Tahsildar, Bangalore South Taluk, on the allegation that the petitioner has encroached upon 25 guntas of public property in survey number 1. Full stop. The special court for land grabbing registered a case in LBC bracket P 867 of 2017 and having considered the material made available by the revenue authorities and information made available by the petitioner, the special court dropped the case against the petitioner, upholding the title of the petitioner in terms of order dated 27/9/2021. Full stop. Learned counsel submits that in spite of the orders passed by the special court and the directions issued by this court in WP number 18064 of 2022, dated 27th of October 2023, the special Tahsildar has issued the impugned endorsement rejecting the claim of the petitioner to enter his name in the RTC only on the ground that there is a report of Sri A.T. Ramaswamy Committee
And KB Koliwad Committee.
huh?
KB Koliwad Committee.
And Sri KB Koliwad Committee stating that the land in question is a part of tank bed. And therefore, the name of the petitioner cannot be entered in the RTC. Full stop. Next para. The learned counsel for the petitioner has made out a prima facie case, while contending that the Tahsildar was duty bound to enter the name of the petitioner in terms of section 128 of the Karnataka Land Revenue Act of 1964, having regard to the undisputed fact that the name of the petitioner's father was entered in the land records, and the petitioner is only seeking mutation on the basis of inheritance. Full stop. Next para.
Prayed for an interim order, my lord.
Huh?
Interim order, my lord, I have prayed for. In
Yenanta?
pursuance to annexure A, my lord.
Huh?
My lord, there shall not be disposition, my lord.
Next para. 2 weeks time is granted to the respondent, state and its authorities to file statement of objections. Full stop. In the meanwhile, the petitioner shall not be dispossessed from the land in question till the disposal of this writ petition.
Number 15. This case, my lord, this is a writ of mandamus. 20C Annexure C, my lord. In the year of 2018, my lord, that I have made an application before the Deputy Commissioner under section 95(5) for grant
Conversion.
of deemed conversion.
Huh?
Deemed conversion grant ಮಾಡೋದಕ್ಕೆ application Annexure C page number 15 ಅಲ್ಲಿ Deputy Commissioner ಗೆ I have given application. Subsequent to that, my lord,
ಅದೇನ್ರಿ ಅದು
Deemed conversion.
application for deemed conversion ಅಂದ್ರೆ ಅರ್ಥ?
deemed section 95 ನಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ there is an amendment. We have to, if at all, if it is required for commercial use, the section 95 subclause 5 prakara now we can make an application for paribhavita parivartanege we can give application.
ಅಂದ್ರೆ
Deemed conversion. Deemed conversion.
deemed conversion will arise only if your application has not been considered within the time.
Yes.
90 days.
There is no provision for filing an application saying, let it be considered as deemed
ಅಲ್ಲ,
conversion.
ಅಲ್ಲ.
ಆ ತರ ಇದೆ, there is no such provision.
ಇದೆ ತೋರಿಸಿ.
It shall be construed as a deemed permission if no orders are passed within the prescribed period. Where the Deputy Commissioner fails to inform the applicant.
ಅಲ್ಲ section 95 subclause 5 deemed.
ಅದನ್ನೇ ಓದ್ತಾ ಇದೀನಿ, subsection 5.
Yes.
Subsection 5 says, where the Deputy Commissioner fails to inform the applicant of his decision on the application made under subsection 2 within the period of 4 months from the date of receipt of the application, the permission applied for shall be deemed to have been granted.
ಅದು ಬೇರೆ. Section
There is no such provision for making an application as deemed conversion, sir.
Section 95, whether application entitled for the benefit of Section 95, even though he has not produced material by the
ಯಾವ್ದು ಓದ್ತಾ ಇದೀರಾ?
Section 95 subclause 5. ಅದ್ರ ಮೇಲೆ ಡಿಸಿಷನ್ ಇದೆ, ಡಿಸಿಷನ್ ತಂದಿಲ್ಲ ನಾನು. If your lordship have it tomorrow, I'll deemed conversion.
You are state by filing an application.
ಪರಿಭಾವಿತ ಅರಣ್ಯ ಕನ್ವರ್ಷನ್ ಮಾಡ್ಕೊಡಿ ಅಂತ.
Where is that provision?
Just Section one ನಿಮಿಷ ತೋರಿಸಿ. Section 95.
Please read your application once again.
Once. ಅದರ ಮೇಲೆ ರಿಪೋರ್ಟ್ ಬಂದು ಚಳ್ಳಕೆರೆ ತಾಲೂಕ್ ಚಳ್ಳಕೆರೆ ತಾಲೂಕ್ ಕಸ್ಬಾ ಹೋಬಳಿ ರಾಮಜೋಗನಹಳ್ಳಿ ಗ್ರಾಮದ ವಾಸಿಯಾದ ಶ್ರೀ ಎಂ.ಎ. ನಾಗರಾಜ ರೆಡ್ಡಿ ಬೀನ್ ಲೇಟ್ ವಾಸುದೇವ ರೆಡ್ಡಿ ಆದ ನಾನು ದಿನಾಂಕ 26/5/2015 ನನ್ನಿವಾಳ ಗ್ರಾಮದ ರೀಸರ್ವೆ ನಂಬರ್ 350/4ರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನು ಡೀಮ್ಡ್ ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿಕೊಡುವಂತೆ ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುತ್ತೇನೆ. ಆದರೆ ಇದುವರೆಗೂ ಆದೇಶವಾಗಿದೆ. ಆದ್ದರಿಂದ ನನ್ನಿವಾಳ ರೀಸರ್ವೆ ನಂಬರ್ 350ರಲ್ಲಿ 2 ಎಕರೆ 1 ಗುಂಟೆ ಜಮೀನಿದೆ. ಇದರಲ್ಲಿ 1 ಎಕರೆ ಕೃಷಿ ನಡೆಸಲು ಮತ್ತು ಸಿ ಫಾರ್ಮ್ಗಾಗಿ ಹಾಗೂ ಉಳಿದ 1 ಎಕರೆ ಕಲ್ಲುಗೋಣೆ ಗುತ್ತಿಗೆಗೆ ಮತ್ತು 350ರಲ್ಲಿ 1 ಎಕರೆ ಕಲ್ಲುಗಣಿ ಗುತ್ತಿಗೆ ಡೀಮ್ಡ್ ಪರಿವರ್ತನೆ ಮಾಡುವಂತೆ ಕೋರುತ್ತೇನೆ. ಇದರೊಂದಿಗೆ ಅಗತ್ಯ ದಾಖಲೆ ಲಭಿಸಿರುತ್ತೇನೆ. Then my lord, Annexure D, I'll show that Annexure D, my lord, that Tahsildar report has been sought by the Deputy Commissioner. And Tahsildar, my lord, has given report on 14/6/2018 saying that the kindly see in page number 17, last para. ಸರ್ಕಾರಿ ಸುತ್ತೋಲೆಯಂತೆ ಅಕರಾಬಿಗೆ ಮಾರುಕಟ್ಟೆ ಶುಲ್ಕ ಭೂರ್ಭ ಶುಲ್ಕವನ್ನು ಪಾವತಿಸಿಕೊಂಡು ನನ್ನಿವಾಳ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 350/17ರಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ 4 ಲೈನ್ ಮೊದಲು ಅರ್ಜಿದಾರರ ಹೆಸರಿಗೆ ಕ್ರಯ ಪತ್ರದಿಂದ ಮೂಲಕ ಬಂದ ಜಮೀನಾಗಿರುತ್ತದೆ. ಅರ್ಜಿದಾರರ ಹೆಸರಿಗೆ ಕ್ರಯದ ಮೂಲಕ ಬಂದ ಜಮೀನು ಪ್ರಯುಕ್ತ ಉಲ್ಲೇಖ 3 ಸರ್ಕಾರಿ ಸುತ್ತೋಲೆಯಂತೆ ಅಕರಾಬಿಗೆ ಮಾರುಕಟ್ಟೆ ಶುಲ್ಕ ಮತ್ತು ಭೂಪರಿ ಶುಲ್ಕವನ್ನು ಪಾವತಿಸಿಕೊಂಡು ನೆನ್ನಿವಾಳದ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 350/4ರಲ್ಲಿ 1 ಎಕರೆ ಅಕರಾಬ್ ಕ್ರಷರ್ ನಡೆಸಲು ಹಾಗೂ ಸಿ ಫಾರ್ಮ್ಗಾಗಿ 1 ಎಕರೆ ಕಲ್ಲುಗುಂಡು ಗುತ್ತಿಗೆ ಹಾಗೂ 350ರಲ್ಲಿ 1 ಎಕರೆ ಅಕರಾಬ್ ಜಮೀನನ್ನು ಕಲ್ಲುಗುಂಡು ಗುತ್ತಿಗೆಗೆ ಪರಿಭಾವಿತ ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಲು ಕಡತವನ್ನು ತಮ್ಮ ಅವಗಾನೆಗೆ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. Then my lord, next that is PTCL case ಇಲ್ಲ ಅಂತ. Subsequent to that, Deputy Commissioner once again sought report from the Tahsildar 23/2/2023ಕ್ಕೆ ಮತ್ತು ತಹಶೀಲ್ದಾರ್ ಅವರು ರಿಪೋರ್ಟ್ ಕಳಿಸ್ತಾರೆ ಮಾಡಿಕೊಡ್ಬೋದು ಅಂತ. ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸೀಯಿಂಗ್ ಪೇಜ್ ನಂಬರ್ 22. ಆದ್ದರಿಂದ ನನ್ನಿವಾಳ 22ರಲ್ಲಿ ಆದ್ದರಿಂದ ನನ್ನಿವಾಳ ಗ್ರಾಮದ ರಿಸರ್ವೆ ನಂಬರ್ 354/5ರಲ್ಲಿ ಬಾಬ್ತು ಕರಾಬು ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಮಾತ್ರ ಪರಿಭಾವಿತ ಪರಿವರ್ತನೆ ಕೋರಿರುವುದ ತಮ್ಮ ಹಂತದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಪರಿವರ್ತನೆ ಮಾಡಬಹುದಾಗಿರುತ್ತದೆ ಎಂದು ಅಂಶವನ್ನು ವರದಿಯೊಂದಿಗೆ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ತಮ್ಮನಿಗೆ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. My respectful submission before this report. This report is there. Consider my application and pass appropriate order. This is my prayer before this court.
This is a report of the ADLR.
Huh?
ADLR report of the Annexure F.
Why is the Deputy Commissioner not considering the application?
Either this way or that way, he has to pass some order.
If the application is filed in the year 2018, why is he not passing any orders?
Prayer ಹೇಳ್ತಾರೆ that the land comes under the PTCL ಇದರಲ್ಲಿ ಬರ್ತದೆ.
PTCL of no objection.
ಯಾವ್ದ್ರಲ್ಲಿ?
ಅವರೇ ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
PTCL no objection already which we have produced.
ಇವರು ಹೇಳಿದಾರಲ್ಲ, PTCL ಕಾಯ್ದೆ ವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುವುದಿಲ್ಲ.
ಒಳಪಡುವುದು.
please take instructions.
Yes, sir.
But your contention that
I'll produce that, my lord. Section 95 deemed conversion amended provision, I'll produce that.
ಯಾವಾಗ ಬರುತ್ತೆ?
Amended,
It is very clear in
Yes.
no, my
subsection
lord.
5.
Insofar as, my lord, commercially,
Not file an application saying, grant me deemed permission. ಆತರ ಇಲ್ಲ provision.
I'll produce.
You will have to file an application
Only for conversion.
ಅಲ್ಲ. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ?
within the period prescribed. If no information is given by the deputy commissioner, see, it is possible that the deputy commissioner may ask for some more information
Yes.
to consider your application and pass orders.
Please.
If he doesn't even ask for any information and no orders are passed within 4 months, then the provisions in subsection 5 will come into operation and this court can declare that there is a deemed permission. You need not go before the deputy commissioner once again. This court can declare under subsection 5 that there is a deemed permission.
Can I make?
You cannot file an application. Please grant me deemed permission. Anta. There is no such provision at all.
I'll point out. Like,
Learned AGA takes notice for response number 1 and 2. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. The grievance of the petitioner is that his application filed on 5/2/2018 and prior to that, an application which was filed on 25/6/2016 is pending consideration before the second respondent deputy commissioner, Chitradurga district, and no orders have been passed under section 95 granting permission for conversion of the lands in question. Full stop. Learned counsel submits that the Tahsildar, Chellakere, and the Deputy Director of Land Records have recommended the case of the petitioner for conversion, as could be seen from annexures D and F. Full stop. Next para.
95 subclass 9, I may permitted to read. There is a provision.
ಅಲ್ಲ, in the ground.
There is a provision.
ಓದಿ. ಯಾವ್ದು?
Whenever 95 subclass 9, that is inserted, my lord, by virtue of amendment dated 8/1/2015. Whenever any occupant of land assessed or held for the purpose of agriculture wishes to divert such land or any part thereof for the purpose of quarrying or minor minerals, whether specified or non-specified, filed accordance with the rules governing quarrying of minor minerals or stone crushing activities under the Karnataka Regulation of Stone Crusher Act 2011, Karnataka Act 8 of 2000, shall make an application along with the fine application to the Deputy Commissioner for diversion of such land. On such application, the permission for diversion of such land shall be deemed to have been granted, subject to obtaining lease license or working permission under the enactment. This is, my lord, the inserted 2015. And, my lord, if making application for the crusher, establishment of crusher ಅಥವಾ quarry lease ಮಾಡಬೇಕು ಅಂತಂದ್ರೆ, I have to make application by producing documents, and, my lord, deputy commissioner by taking fees, deemed conversion ಕೊಡಬೇಕು. That is the provision inserted. Therefore,
That it says
ಪುಸ್ತಕದಲ್ಲಿ ಇದೆ.
deemed to have been granted subject to the obtaining of lease or license.
Lease already that we have obtained.
Lease and license. has to
Lease
be
ಕೊಟ್ಟಿದ್ದಾರೆ already.
Lease and license to run the stone.
ಇದು already ಇದೆ, which I have not produced because
Then along with the application that they have to.
Your application, you have to say so.
I have obtained the.
ಅಲ್ಲ, application 2018 ಅಲ್ಲಿ we have made application under the provisions of amended to 95/5, 95/9. Then, my lord,
95/9 ಅಲ್ಲಿ ಮಾಡಬೇಕು ಅಂದ್ರೆ,
Fine also should.
in
be
terms
paid
of the
upfront.
provision, you will have to enclose the
Yeah.
license
License.
ಅಲ್ಲ, ಅದು
granted by the competent authority.
kindly,
Maybe the
ಇನ್ನೊಂದ್ಸರಿ ಓದಿ.
ಹೌದು,
Read it.
yes,
On such application,
yes,
permission for diversion of such land
yes, please.
shall be deemed to have been granted,
Please,
subject to obtaining lease or license
yes,
or working permission
Yes.
under the said enactments.
Yes.
Ah.
I have produced and which is referred in the the report also. Report allu Tahsildar report koduವಾಗ Deputy Commissioner refer ಮಾಡಿದ್ದಾರೆ, but I will produce that also. And I have produced before the Deputy Commissioner to that effect.
Next para. Learned counsel for the petitioner, however, draws the attention of this court to subsection 9 of section 95, which makes a special provision in cases where the occupant of a land, occupant of an agricultural land wishes to divert such land for the purpose of quarrying of minor minerals, comma, the Deputy Commissioner is required to grant orders for diversion and such orders shall be deemed to have been granted subject to obtaining lease or license or working permission under the said enactments. Full stop. Next para, learned AGA submits that even in terms of the said provision, the requirement is that the petitioner is required to obtain lease or license or working permission under the provisions of the Karnataka Regulation of Stone Crushers Act, 2011,
And KMMRC rules 1994.
and the Karnataka Mines and Minerals
Constitution rules 1994. KM.
Full stop. Next para, learned counsel for the petitioner submits that all that permissions have been obtained by the petitioner.
Yes.
Full stop. Next para, learned AGA is directed to secure instructions from the second respondent, Deputy Commissioner Chitradurga, as to why there is a delay in consideration of the application filed by the petitioner. Full stop. In the meanwhile, the petitioner is also required to furnish all the information
Yes. To the Deputy Commissioner or before this?
having regard,
Illi.
having regard to the provisions contained in subsection 9 of section 95.
Yes. 99 and 95.
If the same has already been submitted to the Deputy Commissioner.
Yes, yes.
Full stop. Yes. Release this matter on 6th of March.
Much.
Number 16, Raju S.
For the petition. Petition is the Rashtrottana Parishad, my lord. Organization established object of provide the service of education, health and poor repressive class society, my lord. In the cabinet meeting, state government took a decision and grant the land, survey number 155/6, block number B, 23 1 acre, 36 gunta situated Uli Mangala village, Jigni, Pobli, Anekal Taluk, Bangalore urban district in favor of the petition annexure A, my lord. Cabinet decision, my lord. Thereafter, my lord, the first respondent issued a government order to clearly say that the
To
land.
grant,
Pardon?
the decision to grant land in survey number 135
155/6,
1 acre 32
36 undas.
Ulimangala village.
Jigni Obli, my lord. Anekal Taluk, Bangalore.
Ah.
Thereafter, the first respondent issued a government order to land in question has been granted in favor of the petition to fixing the 25% of the market value of the land. Annexure A, my lord. Thereafter, the Deputy Commissioner issued a notice to the petitioner directing the deposit to total amount of rupees 77,76,736, my lord. Value of the land granted annexure B, my lord. Thereafter, the petitioner remitted the amount to the demand draft, my lord. Petitioner addressed a letter to the Deputy Commissioner to make clear to the said amount has been deposited, but further requested to conduct the survey and issued a conversion order. Thereafter, the Deputy Commissioner passed an order. Conversion order. The Deputy Commissioner passed a conversion order, my lord. Annexure D, my lord.
Annexure
D, conversion order. Ink page 22, my lord. Upon the conversion order, my lord, Annexure C, my lord. This is undisputed, my lord. Thereafter, Annexure C, my lord. My lords, we can come to the Annexure C, my lord. Bottom is the orders.
Conversion order already idu. This is the grant order.
Grant order, payment of.
Conversion order alla.
Granted.
Huh?
Annexure C, my lord.
Huh?
Next, Annexure C, my lord. Pursuant to this grant order, my lord. I made a representation before the deputy commissioner, my lord. But ಈಗ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಆನೇಕಲ್ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಮಲ್ ಜಿಗಣಿ ಹೋಬಳಿ ಹುಲಿಮಂಗಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 23ರಲ್ಲಿ ನಮಗೆ ಮಂಜೂರಾಗಿರುವ 1 ಎಕರೆ 36 ಗುಂಟೆ ಜಮೀನನ್ನು ಅಳತೆ ಮಾಡಿ ಟಿಪ್ಪಣಿ ಆಕಾರ ಬಂದು ನಕಾಶೆ ಇನ್ನಿತರ ದಾಖಲೆಯೊಂದಿಗೆ ನಮ್ಮ ಸುಪರ್ದಿಗೆ ನೀಡಬೇಕೆಂದು ವಿನಂತಿಸುತ್ತೇವೆ. ಭೂಮಿ ಪರಿವರ್ತನಾ ಶುಲ್ಕವನ್ನು ಪಾವತಿಸಿರುವುದರಿಂದ ಸದರಿ ಜಮೀನಿನ ಭೂಮಿ ಪರಿವರ್ತನಾ ಆದೇಶವನ್ನು ನೀಡಬೇಕಾಗಿ ಕೋರುತ್ತೇವೆ. Thereafter, my lord, deputy commissioner written letter to the government, my lord. Annexure F, my lord. Annexure F, my lord. Ink page 26. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆನೇಕಲ್ ತಾಲೂಕು ಜಿಗಣಿ ಹೋಬಳಿ ಹುಲಿಮಂಗಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 155/6 ಬ್ಲಾಕ್ 20 ನಂಬರ್ 23 1 ಎಕರೆ 36 ಗುಂಟೆ ಜಮೀನು ಶೈಕ್ಷಣಿಕ ಉದ್ದೇಶಕ್ಕೆ ರಾಷ್ಟ್ರೋತ್ಥಾನ ಪರಿಷತ್ ಬೆಂಗಳೂರು ಇವರಿಗೆ ಸರ್ಕಾರ ಸೋಣಿಸೋ ಪಾವತಿಸಿಕೊಂಡು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಹುದ್ದೆಗೆ 3ರಿಂದ ಮಂಜೂರಾತಿ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿರುತ್ತದೆ. ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿ ರಾಷ್ಟ್ರೋತ್ಥಾನ ಪರಿಷತ್ ಉಲ್ಲೇಖ ಈ ಕಚೇರಿಗೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಪ್ರಸ್ತುತ ಜಮೀನಿನ ಪೋಡಿ ದುರಸ್ತಿ ಮಾಡಿ ಹಸ್ತಾಂತರ ಮಾಡಿಕೊಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ತಮ್ಮ ಅರೆ ಸರ್ಕಾರಿ ಪತ್ರದಲ್ಲಿ ಕಂದಾಯ ಇಲಾಖೆ ಸಂಬಂಧಿಸಿದ ಸರ್ಕಾರದ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಸರ್ಕಾರೇತರ ಸಂಸ್ಥೆಗಳಿಂದ ವ್ಯಕ್ತಿಗಳಿಗೆ ಇಂದಿನ 6 ತಿಂಗಳಿಂದ ಮಂಜೂರು ಗುತ್ತಿಗೆ ನೀಡಲಾಗಿರುವ ಜಮೀನು ಮುಂದಿನ ಸೂಚನೆಯವರೆಗೆ ಯಥಾಸ್ಥಿತಿಯಲ್ಲಿಯೇ ಇಡುವಂತೆ ಸೂಚಿಸಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಪ್ರಸ್ತಾವಿತ ಜಮೀನನ್ನು ಸರ್ಕಾರದ ಆದೇಶದಿಂದ ರಾಷ್ಟ್ರೋತ್ಥಾನ ಪರಿಷತ್ ಒಟ್ಟಾರೆ ಸೋಣಿಸೋ ಅನ್ನು ಸರ್ಕಾರ ಪಾವತಿಸಿಕೊಂಡು ಮಂಜೂರಾತಿ ಆದೇಶವನ್ನು ಹೊರಡಿಸಿರುವುದರಿಂದ ಅದರಂತೆ ಜಮೀನನ್ನು ಹಸ್ತಾಂತರ ಮಾಡುವ ಸಂಬಂಧ ತಮ್ಮ ನಿರ್ದೇಶನ ಆದೇಶನ ಕೋರಿದೆ. Next, Annexure G, my lord. Annexure G, typed copy and ink page 29, my lord. The secretary of the first respondent, my lord. ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಯವರ ಟಿಪ್ಪಣಿ ಸಂಖ್ಯೆ ಸೋಣಿಸೋ 25/5/23ರಲ್ಲಿ ಇಂದಿನ ಸರ್ಕಾರದ ಕಳೆದ 6 ತಿಂಗಳಿಂದ ಕಂದಾಯ ಇಲಾಖೆ, ನಗರಾಭಿವೃದ್ಧಿ ಇಲಾಖೆ ಹಾಗೂ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಗಳಿಂದ ವಿವಿಧ ಸಂಸ್ಥೆಗಳ ಜಮೀನು ಮತ್ತು ನಿವೇಶನಗಳನ್ನು ಗುತ್ತಿಗೆ ಮತ್ತು ಪಾವತಿ ಆಧಾರದ ಮೇಲೆ ಮಂಜೂರು ಮಾಡಿದ ವಿವರಗಳನ್ನು ಕಡತದ ಮೇಲೆ 1 ವಾರದೊಳಗೆ ಸಂಬಂಧಪಟ್ಟ ಇಲಾಖೆಗಳು ಸಲ್ಲಿಸುವಂತೆ ಹಾಗೂ ಈ ರೀತಿ ಮಂಜೂರಾದ ಗುತ್ತಿಗೆ ಮೇಲೆ ನೀಡಲಾಗುವ ಜಮೀನು ನಿವೇಶನವನ್ನು ಯಥಾಸ್ಥಿತಿಯಲ್ಲಿ ಇಡಲು ಸೂಚಿಸಲಾಗುತ್ತದೆ. ಮಾನ್ಯ ಮುಖ್ಯಮಂತ್ರಿಯವರ ಸೂಚನೆಯಂತೆ ಕಂದಾಯ ಇಲಾಖೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸರ್ಕಾರದಿಂದ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಂದ ಸರ್ಕಾರೇತರ ಸಂಸ್ಥೆಗಳಿಗೆ ವ್ಯಕ್ತಿಗಳಿಗೆ ಇಂದಿನ 6 ತಿಂಗಳಿಂದ ಮಂಜೂರು ಗುತ್ತಿಗೆ ನೀಡಲಾಗಿರುವ ಜಮೀನುಗಳನ್ನು ಮುಂದಿನ ಸೂಚನೆಯವರಿಗೆ ಯಥಾಸ್ಥಿತಿಯಲ್ಲಿ ಇಡುವಂತೆ ಸೂಚಿಸಿದೆ. ಜಿಲ್ಲಾಧಿಕಾರಿ ಹಂತದಲ್ಲಿ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಕಳೆದ 6 ತಿಂಗಳಲ್ಲಿ ಗುತ್ತಿಗೆ ನೀಡಿದ ಪ್ರಕರಣ ಇದ್ದಲ್ಲಿ ಅದರ ಮಾಹಿತಿಯನ್ನು 3 ದಿವಸದಲ್ಲಿ ಒದಗಿಸುವುದು. ಈ ವಿಷಯ ಅತ್ಯಂತ ತುರ್ತು ಎಂದು ಭಾವಿಸುವುದು. ದಿಸ್ ಇಸ್ ದಿ ಲೆಟರ್ ಚಾಲೆಂಜಿಂಗ್ ದಿ ಪಿಟಿಷನ್ ಮೇಲೆ.
ಚಾಲೆಂಜ್
ಇದಕ್ಕೆ ಭಾಷೆ ಕೇಳಿದ್ರು.
Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Next para. 2 weeks are granted to the respondent, state and the deputy commissioner, Bangalore Urban District, to file statement of objections. Yes.
Date may be given, my lord. It's an urgency education institution, my lord. We are already repaid the entire amount, my lord.
ನೀವು ಕೇಳ್ರ ಎಂಟ್ರಿ ಮಾಡ್ರು ಕೊಡಕ್ ಬರೋದಿಲ್ಲ, ಕೊಟ್ರು ಏನ್ ಪ್ರಯೋಜನನೂ ಇಲ್ಲ.
ಆಗಲ್ಲ ಸರ್.
ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಬೇಕು.
ಅಲ್ಲ, ಡೇಟ್ ಮೇ ಬಿ ಗಿವನ್, my lord. 2 weeks.
For what, sir?
Urgency ಇದೆ ಅಂತ. Urgency ಇದೆ, ಬೇಕಿಲ್ಲ.
Let them file the statement of objections. We'll see. Yes.
Preliminary, serial number 17, Mohammed Tahir.
The petitioner herein is in unauthorized occupation of 31 guntas of land in survey number bearing 99. During the he has filed an application seeking for regularization. During the pendency of those applications, along with the petitioner, some villages also have filed applications in respect to the very same survey number, and all those applications were pending. During the pendency of those applications, the said survey number, some portion of said survey number was notified to be allotted for the under rehabilitation scheme. Displaced persons. So that was notified and it was allotted to the displaced persons. So later on, the petitioners herein filed appeal before the deputy commissioner challenging that order on the premise that there was some fraud mischief has been played, and those who have not been who has not lost the lands in that Hemavati reservoirs have also applied and also are beneficiaries under this scheme. And the further contention was raised that we have filed an application and we belong to the very same village, and we have filed application seeking for regularization, and that application is pending for consideration apart from our other grounds. The deputy commissioner and also the very specific prayer was sought requesting the deputy commissioner to call for records in respect of the allotment made. But in spite of the calling for records and looking into the records, the genuinity of the allotment made, the deputy commissioner has rejected the appeal. Hence, the petitioner's appeal was filed before deputy commissioner. Annexure A, your lordships. Typed copy is at Annexure A. It was filed under section 49 of. And other land was identical, the other land owners who were also parties before the deputy commissioner in that impugned order had approached this honorable court in WP 724 of 23 and WP 707 of 23. And notice have been issued in those writ petitions and they are pending for consideration.
Notice one which they are challenging is the impugned order which they are challenging is Annexure C, my lord, page 23, 2017 ali. The entire land which has been, they are seeking for regularization. The contention of the petition is they are unauthorized occupation, so land has to be given. But these lands has been reserved for those land losers in the Hemavati project, and it has been already granted. And there are some illegal occupants which they are saying
I think, my lord, there are similar matters has been posted before my lordship, where those people have filed a writ petition saying that we are not illegal occupants. But in respect of petition is concerned, my lord, this particular land cannot be regularized for him. For this reason, it is reserved for Hemavati, the land losers of Hemavati project. That is what the order says. If my lordship sees page 33, the only thing is these particular lands have been reserved for land losers of Hemavati project. That is why his application cannot be considered for regularization.
The entire extent of the land is 120 acres, your lordship, in that survey number. What is the extent which has been notified under that scheme? It is not forthcoming in the order, and no records were called for.
Page 33.
Whether entire extent of 120 acres have been notified in that scheme, under that scheme, then the matter would have been different. Otherwise, if some portion of the land has been notified under that scheme, then it requires to be reconsidered also. Because our applications, not only mine, the petitioners hearing, the other landowners, the other villagers also. Some 18 appeals were filed. All the deputy commissioners have clubbed all the 18 appeals and have passed a common order. And very same order is challenged in those writ petitions, that is writ petition 724 of 23 and 707 of 23.
Let it come up along with that. That is all.
Anyway, the order which they are
Yes,
challenging is of 2017.
If you have taken action, or if you have sought to take action against some of the grantees,
Illegal grantees.
having found that they were not entitled for grant.
And my lord, what has happened is, my lord, in respect of those grantees, my lord, who have said that we are the land losers in Hemavati project, and the alternate land was granted in the same survey number, they have filed a writ petition before this honorable court.
Ade.
My lord, the stay agide.
Ade.
Iವ್ರದ್ದು ಏನಾಗುತ್ತೆ, my lord, this particular cases in relation to these petitioners or any other petition cannot be considered because these particular lands were all reserved for this Hemavati project. ಅವ್ರಿಗೆ ಇವ್ರದಾರೆ ಲಿಮಿಟ್ 4 acres 38 ಗುಂಟಾಸ್ ಅಂತೆ, ಅವ್ರಿಗೆ ಆತರ ಇಲ್ಲ. Based on their popular family members, these lands are allotted. ಅವ್ರಿಗೆ 5 acre ಆಗಿರ್ಬೋದು, 6 acre ಆತರ ಕೊಟ್ಟಿದ್ದಾರೆ based on the family members. ಇವ್ರಿಗೆ these people are and my lord, the land losers with these in respect of these projects, they have a right over these lands, my lord, because they are the one who have lost the land.
Contention is the total extent of land is 120.
Adun ಬೇಕಾ I'll get the information.
120 acres. So how much was reserved for them? Whether the entire 120 acres were reserved?
This is what the DC says, my lord.
ಅದ್ರಲ್ಲಿ ಹೇಳಿಲ್ಲ, ಇಲ್ಲಿ ಲಾ ಹೇಳಿದಾರ
32 ಅಲ್ಲಿ, my lordship sees 32 last paragraph ಅಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಿಸಿಕೊಂಡು, my lord, the annexure C page 23. Annexure C, my lord, page 22.
32 or 23 na?
ಅದು page 23 ಇಂದ ಶುರು ಆಗುತ್ತೆ. The relevant para is at page 32, correct?
Page
32. ಅದು annexure C ಬಂದು page 23 ಇಂದ ಶುರು ಆಗುತ್ತೆ.
Nandu, it starts from, you please tell the internal page number.
Internal page number 10, my lord.
10.
10 ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ಪ್ರಕರಣವನ್ನು ದಾಖಲಿಸಿಕೊಂಡು ನೋಟಿಸ್ ನೀಡಿ ವಾದಿ ಹಾಗೂ ಪ್ರತಿವಾದಿ ಪರ ವಾದ ಆಲಿಸಲಾಯಿತು ಹಾಗೂ ಕಡತದಲ್ಲಿರುವ ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ಅಪೀಲ್ದಾರರು ಹಾಸನ್ ತಾಲೂಕು ಶಾಂತಿಗ್ರಾಮ ಹೋಬಳಿ ಸಮಂತಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 99ರಲ್ಲಿ ಹೇಮಾವತಿ ಜಲಾಶಯ ಯೋಜನೆ ಮುಳುಗಡೆಗೆ ಸಂತಪ್ತಿಗೆ ಕಾಯ್ದಿರಿಸುವ ಜಮೀನಲ್ಲಿ ಪ್ರಕರಣ ಅಪೀಲುದಾರರು ಸುಮಾರು 25 ವರ್ಷಗಳಿಂದ ಅನಧಿಕೃತ ಸಾಗುವಳಿಯನ್ನು ಒಗರುಕುಂ ಸಾಗುವಳಿಯನ್ನು ಸಕ್ರಮ ಸಮಿತಿಯ ಮುಂದೆ ಮಂಜೂರಾಗಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಸಾಗುವಳಿದಾರರಿಗೆ ಅಲ್ಲದೆ ಮುಳುಗಡೆ ರೈತರಿಗೂ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿ ಹೇಮಾವತಿ ಜಲಾಶಯ ಯೋಜನೆ ಅವರು ಮಾಡಿರುವ ಮಂಜೂರಾತಿ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸುವಂತೆ ಹಾಗೂ ಅನಧಿಕೃತ ಸಾಗುವಳಿದಾರರು ಸಲ್ಲಿಸುವ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಅರ್ಹತೆ ಆಧಾರದ ಮೇಲೆ ಭೂ ಮಂಜೂರಾತಿ ಮಾಡಲು ಕಾನೂನು ಕ್ರಮಗೊಳ್ಳಲು ಆದೇಶಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಹಾಗೂ ಹೇಮಾವತಿ ಜಲಾಶಯ ಯೋಜನೆಯ ಮಂಜೂರಾತಿ ಪಡೆದಿರುವ ಮುಳುಗಡೆ ಸಂತ್ರಸ್ತರು ಸುಳ್ಳು ದಾಖಲೆ ಸೃಷ್ಟಿಸಿಕೊಂಡು ಮಂಜೂರಾತಿ ಪಡೆದಿದ್ದು ನ್ಯಾಯಸಮ್ಮತವಾಗಿಲ್ಲವೆಂದು ಅಂಶವನ್ನು ಮುಖ್ಯವಾಗಿ ಮುಂದಿಟ್ಟಿದ್ದಾರೆ. ಮುಂದೂಡಿದ್ದಾರೆ. ಪ್ರಶ್ನಿತ ಸರ್ವೆ ನಂಬರ್ ಜಮೀನು ಹೇಮಾವತಿ ಜಲಾಶಯ ಯೋಜನೆಯ ಭೂಮಿ ಕಳೆದುಕೊಂಡ ಸಂತ್ರಸ್ತರಿಗೆ ಪೂರ್ಣವತಿ ಕಲ್ಪಿಸುವ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕಾಯ್ದಿರಿಸಿರುವ ಜಮೀನೆಂಬುದು ನಿಸ್ಸಂಶಯವಾಗಿರುತ್ತದೆ. That is what they say, the full survey number. ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಲಂ 71
You please get that information, we'll see.
Yes, sir. ಯಾಕಂದ್ರೆ the survey number which they are seeking is the survey number which was allotted to them ಅಂತ.
ಗೊತ್ತಾಯ್ತು. Now the contention is that see even otherwise you have sought to take action against some of them.
ಅವ್ರು ತಗೊಂಡಿದೀವಿ, ಅವ್ರಿಗೆ ಆಕ್ಷನ್ ತಗೊಂಡಿದೀವಿ and we have
So after taking action, my lord, if some of them are evicted,
then ಅವಾಗ
so that also is possible.
yes my lord.
And it is possible if we find out
My lord.
whether the entire extent of land was earmarked for them and whether everything was allotted,
My lord.
we will find out.
Yes.
Learned AGA.
For respondent 1
They are 4 and 5.
ಅವ್ರಿಗೆ ಈ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ
Allottis.
Huh?
Allottis.
ಅಂದ್ರೆ ಈ ಸರ್ವೆ ನಂಬರ್ ಹೇಮಾವತಿ ಪ್ರಾಜೆಕ್ಟ್ ಅಲ್ಲಿ ಅಲಾಟ್ ಆಗಿರ್ತಲ್ಲ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ ಎಷ್ಟು ಸರ್ವೆ ನಂಬರ್ ಇದೆ?
ಅಲ್ಲ ಇವ್ರು
ಒಂದೇ
ಕೇಳ್ತಾರೆ
ಸರ್ವೆ
ಇದು
ನಂಬರ್
ನಾವು-
ಒಂದೇ ಸರ್ವೆ ನಂಬರ್ ಎಕ್ಸ್ಟೆಂಟ್ ಬಹಳ ಇದೆ. They claim that whatever they are in possession, the petitioners are in possession, that land is allotted to these persons.
Huh.
So they have been made as a party in that before the deputy commissioner.
Now, have they initiated proceedings against response number 4 and 5?
That I am not aware.
ಮತ್ತೆ?
But the other contention, what I had read before the deputy commissioner was that,
The-
your lordship,
They have already initiated proceedings against persons
Some
whom
person.
they have found to be ineligible and they have obtained orders of grant. ಆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇವ್ರು ಇಲ್ಲ ಅಂತಂದ್ರೆ then they are granted these lands in terms of the decision, policy decision of the state government. How can you challenge that one?
no, that the,
Unless you are saying that they were not entitled for grant.
that was my specific ground before the
But-
deputy commissioner on two premises, your lordships. The one ground which I had raised before the deputy commissioner is that these persons were already allotted the land under the very same scheme in the earlier round. And after getting that land also, by
Therefore-
suppressing that,
So
They have-
therefore, have they taken action against response number 4 and 5?
that I have to ascertain. The second ground which I had raised is, your lordship, these two persons had lost their land to the extent of 28 guntas. But whereas under this scheme, they have been granted 4 acres, 15 guntas of land.
How can you challenge all that, sir?
That was
Yes,
the ground.
Lokesh Tandi from. Learned AGA takes notice for response number 1 to 4, 1 to 3.
1 to 3 my lord.
Issue notice to response number 4 and 5. Learned counsel for the petitioners is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. List this matter along with,
724 of 23
yes.
and 707 of 22.
Number 18, Srikanth NV.
Prepare for the petition, my lord. The impugned order, my lord,
Yes.
passed by the deputy commissioner at annexure A and A1 and A2, my lord, passed by the assistant commissioner and the tahsildar. Case of the petition is that, my lord, sir, the land was granted in the year 1963 to one Pillappa and Akkama, my lord. During the lifetime of Pillappa and Akkama, my lord, they have made a will, my lords, on 9/1/1963 in favor of the petitioner herein, my lords. On the basis of the will, my lord, in the year 2019, the petitioner has filed a probate petition P&SA, my lord, before the competent civil court, my lord, and obtained the succession certificate. Subsequently, my lord, the rival claimant, that is the fourth respondent, has filed a females petition, my lord, before the very same court and obtained the interim order, my lord, to the succession certificate, which is obtained by the petitioner, my lord. In the meantime, my lord, in the year 2017, my lords, after lapse of 50 years, my lord, the respondent number 4, that is Nagappa, has filed a petition before the tahsildar, my lords, for mutation of entry, my lords, in respect of a property bearing survey number 1/P4 measuring 5 acres. my lord. Without making me as a party to the proceedings, my lord, they obtained the order from the Tahsildar, my lord, annexure A2. Subsequently, my lords, after coming to know the order passed with the Tahsildar, the petitioner herein has filed a appeal before the Assistant Commissioner, my lord, annexure A1, page number 18, my lords. And the rival claimants, my lords, have also filed an appeal before the Assistant Commissioner in area number 172 of 2019 and area number 184 of 2019. And all the appeals were dismissed by the Assistant Commissioner, my lord. Subsequently, my lord, the petitioner has filed a revision petition before the Deputy Commissioner, my lord.
ಏನಾಗಿದೆ? Khata is standing in the name of
Khata standing in the name of
Pillappa and Akkalamma.
Pillappa and Akkalamma up to my lord 2019.
Huh?
Up to my lord 2019, the property, the RTC was standing in the name of Pillappa. My lord, after the order passed with Tahsildar, immediately, my lord, the RTC was stayed in respect of the respond number 4. And also, my lord, the civil dispute is also pending before the parties in OS number 636 of 2019, my lords, at annexure L, my lord, page number 81. Page number 81, my lord.
ಪ್ರಶ್ನಿತ ಜಂಟಿ ಆದೇಶವನ್ನು ಸ್ಥಿರೀಕರಿಸಲಾಗಿದೆ. ಯಾರ ಹೆಸರಲ್ಲಿ ಜಂಟಿ?
In respect of, my lords, the fourth respondent. Fourth respondent, my lord. The RTC, my lord, have produced at annexure, my lords, annexure E1, page number 60, my lord. 60. And 61, annexure E2. Yes, Nagappa been late Sondappa. He is claiming the property, my lord, stating that the Pillappa is the paternal uncle of this Nagappa.
ಅಲ್ಲ ಜಂಟಿ ಅಂದ್ರೆ ಎಲ್ಲಿದೆ? ಮೇಲಿನ ಜಂಟಿ ಇದು
ಪೇಜ್ ನಂಬರ್ 60 annexure E1 ನಲ್ಲಿ ಕೊನೆಯಲ್ಲಿ ಕಾಲಮ್ ನಂಬರ್ 9 ನಲ್ಲಿ ಎಸ್ ನಾಗಪ್ಪ ಬಿನ್ ಲೇಟ್ ಸಣ್ಣಪ್ಪ 5 ಎಕರೆ MR ನಂಬರ್ MRH 8 2019-20
ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ OS ನಂಬರ್
PMIS order 15017 of 2019 ಅಂತ ತಾತ್ಕಾಲಿಕ ತಡೆ. And annexure E2, my lord, page number 61. Column number 9, my lords. Yes, Nagappa been late Sonnappa, ವಿಸ್ತೀರ್ಣ 5 ಎಕರೆ.
ಏನು?
Page number 61, my lord, next page, annexure E2. The RTC pertains to year, my lord, 2019 and 20. That column number 9 ಅಲ್ಲಿ the possession is standing in the name of S. Nagappa. Subsequently, my lords, before obtaining this order from the Tahsildar, the land was acquired, my lord, for the purpose of construction of industrial area from the KADB. The notice has been issued, my lord, from the KADB also. I have produced a notification, my lords, at annexure, my lords, H, page number 68. The preliminary notification was issued on 6/11/2014, and final notification was issued on 15/11/2018. The land was acquired, and now, my lords, the notice has been issued as per annexure J by the KADB, my lords. The showing that the Khatedar is the fourth respondent hearing.
So as per the Khata?
As per the Khata, my lord. The contention of the petitioner is that, my lord, without making me as a party to the proceedings before the Tahsildar, he obtained an order of stay. And I have got the probate and success certificate. And he has filed a PMIS petition before the very same court and obtained the stay order for the succession certificate. There are civil disputes is also pending before the parties.
So ultimately, the civil court has to decide.
Yes.
You go file an objection before the KADB.
I have filed an objection.
Special Land Acquisition Officer.
I have also filed an objection.
Ask for raising up a dispute. They will raise a dispute.
I have filed an objections to the, my lords.
Yes.
To the notice.
We are not concerned under the Karnataka Land Revenue Act. We are not concerned with the acquisition proceedings. We are only concerned with the revenue entries.
Yes, ma'am.
Admittedly, there are rival claims.
Yes, ma'am.
Whether the reference court is going to decide that, or if a suit is already filed, the civil court will decide that one.
Now
it's only a question of who is entitled for the compensation.
Yes, madam.
Ashte tane?
Yes.
That will be decided by the civil court.
But
what can now be done in the revenue entries?
My lord, the contention of petition is that the fourth respondent RTA have made the petitioner as a party to the proceedings. Without making me as a party, he obtained an order from the Tahsildar. That too, my lord, after a lapse of 50 years. Since, my lord, the will is executed in the year 1963. He filed a petition before the
The
Tahsildar.
problem is they died issueless
Yes, my lord.
and they have left behind a bill.
Correct. Yes, ma'am.
Naturally, there will be any number of claims.
Correct, my lord.
How should this court or the revenue authorities decide that your claim is only genuine? Madak baradilla. So that has to be resolved only by the civil court.
Please.
Learned AGA takes notice for response number 1 to 3. Issue notice to response number 4 to 9. 4 to 9. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Where is the power of attorney?
Power of attorney I have produced, my lord. Page number, my lord, sir. Page number 89, my lord.
89.
89. Devegowda is the son of the petitioner here. 89, my lord.
Where is the power of attorney to institute the writ petition?
That's page number 93, my lord.
Huh?
Page number 93 ಅಲ್ಲಿ.
No. To file this writ petition, you will have to have a power of attorney. These are all general power of attorney. We are not concerned with that one.
That's the page number 93 ಅಲ್ಲಿ there is one clause. ma'am.
Baradilla.
I will file a fresh.
That was given in the year 2020.
Yes, ma'am. I will file a
I
fresh.
do not know whether this person is alive.
He is alive, my lord.
Therefore, you will have to file. If you are, before filing the writ petition, you should have obtained a power of attorney
Yes.
to file the writ petition specifically.
Please, ma'am. I will file a fresh power of attorney.
Next para. The writ petition has been filed at the hands of a power of attorney holder on behalf of Sri B.R. Munishami Gowda. Munishame Gowda, who is said to be aged about 89 years. Full stop. A power of attorney given by the petitioner for the purpose of instituting this writ petition is not forthcoming. Full stop. Learned counsel for the petitioner submits that within a week's time,
2 weeks,
such
my lord.
power of attorney,
Pray for 2 weeks time, my lord.
within a period of 2 weeks, such power of attorney executed by Sri B.R. Munishame Gowda in favor of Sri B.M. Devegowda shall be executed and filed before this court.
Please.
Serial number 19, Siddhappa BM.
So appearing for the petition.
Yes.
Lord, the petitioner has challenged the order of the Tahsildar before the Assistant Commissioner, which is made in the year 2014. Lord, wherein the names of the respondents have been mutated in the revenue records. Though the petitioner and the respondent's father have got the share under a registered partition deed dated 3/12/1953, madam. That fact is admitted by both the parties. So one Rudrappa is supposed to be the elder member of the family. His name in the revenue records are there. Now, by taking advantage of the same, his children have mutated their name in the revenue records in the year 2014. That I have challenged before the Assistant Commissioner, stating that the Rudrappa, not only Rudrappa, but Basappa is also have a share under the registered partition deed dated 3/12/1953. Then after verifying the registered partition deed, I have produced as an exhibit.
After the partition deed dated 3/12/1953, whether there was a mutation entry in terms of a mutation order?
Regard to that, there is no reference. Only in the year 2014, these respondents got it mutated.
Already, yaar after the partition?
After the partition, the elder name that is Rudrappa's name continued.
Why?
That my lord,
When you say it is a registered partition,
registered partition in
then
the
according to the share allotted to the respective persons,
please, my lord.
the mutation entry should have been carried out.
Yes, my lord. That is not done by the authorities.
You are talking of 1953, sir.
1953, your lordship, a dispute was not there at all between the brothers. Only in the year 2015.
No. It's not the question of dispute.
Please, my
If
lord.
it is a registered partition deed,
Please.
then in terms of section 128,
ಇಲ್ಲ 19
names of the person.
and revenue codes.
ಅದು ಮಾಡ್ಕೊಂಡೇ ಇಲ್ಲ.
ಅದು ಮಾಡ್ಕೊಂಡಿಲ್ಲ. But that fact is admitted by even these respondents also. There was a registered partition deed. That the only the direction issued by the assistant commissioner is mutate the name of Rudrappa and Basappa as per the partition deed, not these persons.
Where is this mutation order dated 16/12/2014?
Mutation order, my lord, that is in the AC's order, it is mentioned, my lord. I have not produced that document.
No, you have challenged that order.
I have challenged it before the assistant commissioner.
Where is that order?
Allowed the appeal.
No, where is that order?
That order, mutation order, my lord, that I have not got it from my counterpart, as therefore I have not produced it. But AC, my lord, consider the registered partition deed, which I produced as annexure A before your lordship. And direct, as per the partition deed, enter the names of both Rudrappa and Basappa. And thereafterwards, Tahsildar, after verification of the LS, he may be changed.
ರುದ್ರಪ್ಪ ಮತ್ತು ಬಸಪ್ಪ ಇವರ ಹೆಸರಿಗೆ ಖಾತೆ ಮರುಸ್ಥಾಪಿಸಿ ರುದ್ರಪ್ಪ ಮತ್ತು ಬಸಪ್ಪ ಇವರ ವಂಶವೃಕ್ಷ ಪಡೆದು ನೈಜ ವಾರಸುದಾರರಿಗೆ ಪೌತಿ ಖಾತೆ ಮಾಡಲು ತಹಸೀಲ್ದಾರ್ ಹೊಳಲ್ಕೆರೆ ಇವರಿಗೆ ಆದೇಶಿಸಿದೆ.
That is only the order passed by the assistant commissioner.
Oh, there is a suit already filed.
Suit, my lord, not on the as on the date of filing of the appeal. During the pendency of the appeal before the assistant commissioner, suit was filed.
So you have filed the suit.
Only on the basis of the partition, declared you are the owners. That is there. Even in the objection statement, in the appeal memo, I have produced before your lordship, they admitted the partition deed. Only merely because the case is pending, the deputy commissioner only on that ground set aside the order of the assistant commissioner. Your lordship, the deputy commissioner's order, relevant page, ink page 63, ದಾಖಲೆಗಳ ಪರಿಶೀಲನೆ, your lordship. ಹೊಳಲ್ಕೆರೆ ತಾಲೂಕ್ ರಾಮಗಿರಿ ಹೋಬಳಿ ಕಂಬ್ಳಿಹಳ್ಳಿ ಗ್ರಾಮದ ಈ ಸರ್ವೆ ನಂಬರ್ 8-19-2-36 ಮತ್ತು 57ರ ಜಮೀನುಗಳ ಮೇಲೆ ಮಾನ್ಯ ಹೊಳಲ್ಕೆರೆ ಸಿವಿಲ್ ನ್ಯಾಯದ ಪ್ರಕರಣದ ಸಂಖ್ಯೆ ಸೋ ಡಿಕ್ಲರೇಷನ್ ಸೂಟ್ ವಿಚಾರಣೆಗೆ ಬಾಕಿ ಇರುತ್ತದೆ. ಸದರಿ ದಾಖಲೆಯನ್ನು ಎದುರುದಾರರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಿರುತ್ತಾರೆ. ಅಪೀಲ್ದಾರರ ಪರ ವಕೀಲರು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಕರಣ ಬಾಕಿ ಇರುವ ಹಂತದಲ್ಲಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮಾಡಿರುವ ಆದೇಶವು ಊರ್ಜಿತವಾಗುವುದಿಲ್ಲ ಹಾಗೂ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಲು ಕೋರಿರುವ ಲಿಖಿತವಾದ ಪರಿಶೀಲನೆ ಲಭ್ಯ ದಾಖಲೆಗಳ ಆಧಾರದ ಮೇಲೆ ಸದರಿ ಪ್ರಕರಣವು ಸಿವಿಲ್ ಸ್ವರೂಪದ ಕೂಡಿರುವುದರಿಂದ ಸಕ್ರಮ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪರಿಹರಿಸಿಕೊಳ್ಳಲು ಸೂಚಿಸಿ ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶ. Even my lord, in the case of the appellants, what is noticed by the deputy commissioner, page 62, my lord. The said properties are fallen to the share of Rudrappa under a registered partition deed 3/12/1953. That fact is not disputed, my lord.
ಬಟ್ ಅದೇನು ಎಂಟ್ರಿನೇ ಮಾಡಿಸ್ಲಿಲ್ವಲ್ಲ.
ಅದೇ ಎಂಟ್ರಿಸೇ ಮಾಡಿಸಿರೋದು
ಹಾ.
ತಪ್ಪಾಗಿ ಕಾರಣಕ್ಕೆ ವ್ಯಾಜ್ಯಕ್ಕೆ ಕಾರಣ ಆಗಿದೆ.
Learned AGA 1 to 3 takes notice for response number 1 to 3. Issue notice to response number 4 to 14. Learned counsel for the petitioners is directed to serve a copy of the writ petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that it is an undisputed fact between the parties herein that the two brothers, namely Rudrappa and Basappa, partitioned the joint family properties under a registered partition deed bar relinquishment deed dated 3/12/1953. Full stop. However, it is contended that in terms of the partition deed,
Rudrappa and Basappa got the property as per Annex AML.
you are claiming through whom?
So Hanamantappa had got 3 sons.
Hanmantappa, between Rudrappa and Basappa, sir.
I am claiming through Basappa, my lord.
Basappa. It is contended that in terms of the partition deed, 4 acres and 4 guntas in survey number 57, semicolon, 8 acres, 24 guntas in survey number 19 fell to the share of Sri Basappa. Full stop. Similarly, 10 acres and 15 guntas in survey number 36 and survey number 57, semicolon, 6 acres, 10 guntas (10 acres, 5 guntas in survey number 36 and 6 acres and 10 guntas in survey number 57 fell to the share of Sri Rudrappa. Full stop. However, the contents of the partition deed, although registered, was never entered in the land records. Full stop. Learned counsel submits that the respondents are taking advantage of the fact that such entries were never made in the land records, although there is a registered document showing the division of the properties. Full stop. The learned counsel submits that the assistant commissioner has only directed that the revenue entries shall continue in the name of Sri Rudrappa and Sri Basappa. Full stop. However, the deputy commissioner has set aside the order of the assistant commissioner, which makes way for the entry of the name of ಯಾರ ಹೆಸರು ಮಾಡಿದಾರೆ ಈಗ?
Respondents 4 to 12, my lord.
ಯಾರು?
Respondent number 4 to 12, my lord. 4 to 13.
ಅಷ್ಟು ಜನದ ಹೆಸರು ಇದೆಯಾ?
ಅವರೆಲ್ಲ LR ಸಾಬ್ ರುದ್ರಪ್ಪ.
Of response number 4 to 13. 13 or 14?
14.
4 to 14.
Please.
In terms of an illegal mutation entry made in
2014. my lord.
MRH 3 of 1415 dated 16/12/2014. Full stop. Moreover, the petitioners have filed a suit in OS number 106 of 2019 on the file of the civil judge and JMFC at Holalkere. And this itself has been taken as a ground by the deputy commissioner to allow the revision petition filed at the hands of the private respondents here. Full stop. Next para. Consequently, there shall be an addendum order of stay of the impugned order at annexure H till the next date of hearing.
On complaints of office objection for first time, period number 20, even at Simar.
Appear for the petitioner. There is one office objection. That's not the overruling of it tentatively. That is, my lord, at page number 16, the grant certificate which has been produced.
Written portion of page number 16.
Please, my lord. At the top, my lord, the one line, my lord, has come in part. That, my lord, I'll make arrangement, my lord, to substitute.
Office objection is overruled.
Please, my lord, please. My lord, the grant that was made in favor of the petitioner is cancelled, my lord, by passing of the impugned order. The petitioner was in unauthorized occupation of land in survey number 28, measuring 2 acre 38 guntas. My lord, Vide annexure D, page number 16, my lord, the grant was made in her favor.
On 13/3/2018.
Please, my lord. Now, what happened, my lord, was the land was acquired. And hence, my lord, a query was made regarding the grant of compensation. At that juncture, my lord, Tahsildar made a report to the assistant commissioner stating that the husband of the petitioner had owned 6 acre 23 guntas of land, and the same had been partitioned amongst himself and his son to the extent of 4 acres and 2 acres respectively. My lord, reckoning the lands that were held by the husband and the son of the petitioner, my lord, the impugned order has been passed. My lord, 2 grounds, my lord, on which I have filed the writ petition. One is, my lord, regarding that 6 acres of land. My lord, there is already a partition suit that have been filed by the sisters of the husband of the petitioner, and that has been decreed. However, a regular second appeal is filed before the honorable.
The third respondent invoking is powers under rule 108K.
Please, my lord.
Ordered for cancellation of the grantor.
Yes,
It was granted to the petitioner.
please, my lord.
Assistant Commissioner.
Assistant
Where is that order?
My lord, the order is at annexure E, my lord, page number 18, it commences. Operative portion is at page number 21.
Where was your, what is your contention?
My lord, my contention is
Before the Assistant Commissioner.
before the assistant commissioner.
Has he noted it?
Note Madia.
Yes, ma'am. My lord have held that it is ultimately the person's holding that is relevant for the purpose of 94A. It is the person's holding that is relevant for the purpose of 94A.
Yes.
If even the other family members hold any other land, since it is a regularization of unauthorized occupation, that cannot be precedent to service, my lord, is the view that my lord has taken. That, my lord, I have relied upon. And in any event, my lord, that property is also subject matter of.
You have enclosed that judgment here?
Yes, my lord. Annexure M, my lord.
Number?
99. Page 99.
99.
Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Full stop. Next para. Learned counsel for the petitioner submits that a grant that was made
March 2018.
on 13/3/2018 is sought to be cancelled, invoking Rule 108K of the Karnataka Land Revenue Rules, 1966 by the impugned order dated 29/5/2023, passed by the Assistant Commissioner, Tumkur Subdivision. Full stop. The appeal filed by the petitioner before the Deputy Commissioner was also dismissed on 10/1/2024,
Upholding the order of the AC.
upholding the order of the Assistant Commissioner. Full stop. Learned counsel submits that the only ground on which the impugned orders have been passed is that the petitioner was ineligible for regularization of unauthorized occupation as he already held.
Her husband, my lord. Her husband held.
Family member, our family.
Her husband and her son.
23 guntas.
That the petitioner's husband and son held land in their names, and therefore the family holding was in excess of what could be regularized in terms of section 94 capital A of the Act. Full stop. Learned counsel submits that this court, in the case of Shri Hanif Saheb and others versus State of Karnataka and others, in WP number 9488 of 2014, dated 21st of August 2022, has held
Page number 104, internal page number 6 of that order.
104 ಅಲ್ಲಿ.
104, internal page number 6 of the order.
Therefore, if the petitioner,
in terms of section 94 capital A of the Act, there is no restriction that the lands should not be granted to more than one member of the family. Full stop. What is required to be considered while regularizing unauthorized occupation is as to whether the applicant is holding any excess land. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned orders at annexures
E and H.
E and H till the next date of hearing.
wait,
Number 21, Divya K.
Please.
This petition, my lord. I have challenged the proceeding, the order passed by the Deputy Commissioner under 136(3), rejecting my revision petition, my lord. The main ground is, my lord, they have not
Office objections.
office
That
objection.
come up for office objections.
That is annexure E.
Legible copy of annexure E.
In this, some portion is slightly cut, my lord. I'll produce that.
E is the order sheet, huh?
E is
Huh?
the order passed by the assistant commissioner. Page 29.
Office objection is overruled.
Is
Yes.
Annexure H is the order sheet, my lord, and I'm committed to. Yeah, bring your lordship's kind attention. The petitioners in this case, my lord, were impleaded by an order dated 4th March 2020.
Matter is pending consideration before the deputy commissioner?
No, my lord. After impleading us, we have not been heard at all in the matter. I've produced the order sheet. Neither me nor the respondent number 5, who's also a petitioner in the case, have been heard. If I may draw your lordship's attention to page 50, my lord, the order sheet. The lordship may kindly peruse, my lord.
You filed an impleading application and got impleaded.
We got impleaded, my lord. The
Ah.
order sheet does not, we are not arrayed as parties, although, my lord, although it was, we are impleaded, we have not been heard. Please kindly see in the further pages, my lord. The matter was adjourned on many instances because the deputy commissioner was not available. And just one day before, my lord, he says, we have been consistently absent, therefore an order is passed against us. We have not been heard in the matter. Matter request we sent back to the deputy commissioner.
Where is the order of the assistant commissioner?
Assistant commissioner is, my lord, Annexure E.
E, my lord, page 29.
Annexure E, that is the office objection.
NH Shivamurthy had filed the appeal.
Please, my lord. See, the petitioners, my lord,
Husband of the petitioner.
the petitioners are the LRs of NH Shivamurthy. Now, NH Krishnamurthy, along with NH Shivamurthy, both of them being brothers, had filed the earlier proceedings, my lord. Leaving out the petitioners, my lord, NH Krishnamurthy approached the DC on as against the order. We got to know only later. And
What happened to this order? What is the order passed by the assistant commissioner?
The deputy commissioner, my lord. The
Assistant
deputy
commissioner.
assistant commissioner has confirmed the order of the special tahsildar, my lord, and
The
said,
assistant commissioner passes an order saying that your grant is only to the extent of 4 acres. We will update the revenue record in the extent of 4 acres, not into the extent of 5 acres, 5 guntas, which you are claiming. The grant record says it is 4 acres. So the revenue record will be updated to the extent of 4 acres.
Like-
That they have challenged.
Only one person challenged it.
Only one person.
Because the other person.
then we got impleaded, my lord, and thereafter neither me nor the other respondent has been heard. The other brother has also not been heard, my lord. The order sheet shows, my lord, no proceedings have taken place subsequently.
No, what is the ground on which you were asking that 5 acres and dot should be shown in
The
your?
grant certificate states that we have been given 5 acres, my lord. And
Can you
also, my lord, there was a tippany that was produced, my lord, before the assistant commissioner. Now we applied for the copy of the tippany, my lord. They have said that they are shifting the office. Therefore, I was not able to produce the tippany. There is a reference that is made by the deputy commissioner in the course of the order stating that except the tippany, nothing else shows that you have been granted 5 acres. Now the tippany, my lord, is a government record.
Where is the grant order?
The grant order is at Annexure A.
Annexure?
A.
How much does it say?
4 acres.
5 acres. 5 acres.
4 acres.
The difficulty, my lord, is because the document is not very legible. It states here, my lord, 5 acres and ಸ್ವಲ್ಪ also givedu. Then it says 5 acres, 5 guntas.
1937 now.
Please, my lord. But out of these 5 acre, 5 guntas, my lord, 4 acres was sold to one Vidyavati Shetty, my lord. When a resurvey was conducted to Podi her portion of the land, even in that document, the extent is mentioned as 5 acres, 5 guntas, and not 4 acres. Annexure B I have produced, which is a copy of the resurvey. On the top, it says, 5 acres, 5 guntas. And also there is a reference in the Deputy Commissioner's order regarding the Tippani mentioning 5 acres, 5 guntas. That has not been considered. Why? That has been rejected, my lord, is not forthcoming. No reasons are assigned to that. We ought to have been heard in this matter.
Have you read the order of the Assistant Commissioner or the Deputy Commissioner? Have they secured the original records? ಇಲ್ಲ ಇಲ್ಲಿ if my lordship sees the order of the Deputy Commissioner, page 30 it starts with page 29. Page 30 ನೋಡಿದ್ರೆ ಮೇಲ್ಮೈದಾರು ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಯಲಂಕ ಹೋಬಳಿ ಪುಟ್ಟೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 41ರಲ್ಲಿ 1 ಎಕರೆ 5 ಗುಂಟೆ ಜಮೀನು ಬಗ್ಗೆ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಮೇಲ್ಮನಿದಾರ ಪ್ರಶ್ನಿಸಿದ ಜಮೀನು ಸ್ವಾಧೀನದಲ್ಲಿ ಇದ್ದ ಮೂಲತಃ ಮೇಲ್ಮನಿದಾರ ತಂದೆ ಜಮೀನು 1937 ದಿನಾಂಕ 8/11/37 ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋನ್ಸೋ ಅಂತೆ ಹರಾಜಿನಲ್ಲಿ ಪಡೆದು ಸಾಗುವಳಿ ಚೀಟಿ ಪಡೆದಿರುತ್ತಾರೆ. ಅವತ್ತಿನಿಂದ ಅವರ ಹೆಸರಿಗೆ ಖಾತೆ RTC ನಂಬರ್ ಬರುತ್ತಿದ್ದು, ನಂತರ ದಿನಾಂಕ 28/11/90 ವಿದ್ಯಾವತಿ ಶೆಟ್ಟಿ ಅವರಿಗೆ ಮಾರಾಟ ಮಾಡಿರುವುದೆಂದು, ನಂತರ ವಿದ್ಯಾವತಿ ಶೆಟ್ಟಿ ಸರ್ವೆ ದಾಖಲೆ ಕಂದಾಯ ದಾಖಲೆ ಬಂದಾಗಿಯೂ ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ನಂತರ ಮೇಲ್ಮನೆ ಸರ್ವೆ ಇಲಾಖೆ ಅರ್ಜಿ ನೀಡಿ 1 ಎಕರೆ 5 ಗುಂಟೆ ಜಮೀನು ಅಳತೆ ಮಾಡಿ ಹದ್ದುಬಸ್ತುಪಡಿಸಬೇಕೆಂದು ಕೇಳಿರುವಂತೆ ತಿಳಿಸುತ್ತಾರೆ. ನಂತರ ಕಂದಾಯ ಪ್ರಾಧಿಕಾರ ಯಾವುದೇ ಕ್ರಮವನ್ನು ವಹಿಸದೆ ಇದ್ದಾಗ ಕರ್ನಾಟಕ ಘನ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ WP ನಂಬರ್ ಸೋನ್ಸಂತೆ ಪ್ರಕರಣ ದಾಖಲಿಸಿ ಅದರಂತೆ ಘನ ನ್ಯಾಯಾಲಯ ಆದೇಶವನ್ನು ಮೇಲ್ಮನೆದಾರರಿಗೆ 2 ತಿಂಗಳ ಒಳಗೆ ಸಂಬಂಧಿಸಿದ ಪ್ರಾಧಿಕಾರ ದಾಖಲೆಯನ್ನು ನಿಯಮಾನುಸಾರ ಮಾಡಬೇಕೆಂದು ಆದೇಶವಾಗಿರುತ್ತದೆ ಎಂದು ಹೇಳಿರುತ್ತಾರೆ. ಮೇಲ್ಮನೆದಾರರು ತಿಳಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಮನೆದಾರರು ಕೇವಲ 4 ಎಕರೆ ಮಾತ್ರ ಮಾರಾಟ ಮಾಡಿದ್ದು, ಒಟ್ಟು 5 ಎಕರೆ 5 ಗುಂಟೆ ಜಮೀನು ಇದ್ದು ಉಳಿದ 1 ಎಕರೆ ಖಾತೆ ದಾಖಲಿಸಬೇಕೆಂದು ಮೇಲ್ಮನೆ ಕೋರಿರುತ್ತಾರೆ.
Annexure B may kindly be seen. Annexure B is at page 19. ಅದು ರೀಸರ್ವೆ ಮಾಡಿದ್ರು. ವಿದ್ಯಾವತಿ ಶೆಟ್ಟಿ ಅವರಿಗೆ ಮಾರಾಟ ಮಾಡಿದ್ಮೇಲೆ the land was resurveyed. On top, my lord, it mentions the extent as 5 acres, 5 guntas, out of which I have sold 4 acres. The remaining 1 acre, 5 guntas ought to have been mutated in our names. That is my only submission. In any event, my lord, this order is passed without hearing any party. The lordship may kindly peruse the order sheet.
But you are not you are not produced other documents to show what was actually granted and the subsequent entry in the RTC.
Before the Assistant Commissioner, my lord, the DC says a tippani has been produced.
Have you at least produced a copy of the sale deed?
Of the sale deed? Sale deed, my lord. I'll produce it, my lord.
See, if you in the sale deed, if you have said what was granted to me is 5 acres.
Please, my lord.
And I have sold only 4 acres.
I'll produce that.
And I have retained 1 acre 5 guntas.
I'll produce that by way of an application. I'll produce it. It has been produced before the authorities. It has been produced before the authorities.
How is it that nothing has been sent about?
Only subsequent. That is why, my lord, I'm stressing on the point on Annexure B, which states the entire extent.
AC ಮುಂದೆ ಹಾಕಿಲ್ಲ, DC ಮುಂದೆ ಹಾಕಿದ್ದಾರೆ. Finding DC. ಈ ಟಿಪ್ಪಣಿ ನಕಲು ಹಾಜರುಪಡಿಸಲ್ಲ, ಅದಲ್ಲ ಸೇಲ್ ಡೀಡ್. If a copy of the sale deed was called for, ಇಲ್ಲಿದೆ ಇಲ್ಲಿ my lordship sees page 57 para 2 ಅಲ್ಲಿ ಅದೇ ಇದು ಸರ್ವೆ ನಂಬರ್ 41ರಲ್ಲಿ 5 ಎಕರೆ 5 ಗುಂಟೆ ಸರ್ಕಾರ ಹರಾಜು ಮೂಲಕ ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ತಾವು ಸರ್ವೆ ಸೂಚನೆಯಲ್ಲಿ 4 ವಿಸ್ತೀರ್ಣವನ್ನು ವಿದ್ಯಾವತಿ ಶೆಟ್ಟಿ ಎಂಬುವರಿಗೆ ಕ್ರಯಪತ್ರದ ಸಂಖ್ಯೆ ನಂಬರ್ ಸೋನ್ಸು ದಿನಾಂಕ 28/11/92 ಮಾರಾಟ ಮಾಡಿದ್ದು ತಮ್ಮ ತಂದೆ 2/3/95 ಪಾವತಿ ಆಗಿರ್ತಾರೆ ಎಂದು ವಿದ್ಯಾವತಿ ಹೆಸರಿಗೆ ಕ್ರಯಪತ್ರದಂತೆ ಖಾತೆ ಆಗಿರೋ ಅದು ಅವ್ರು ಹೇಳಿರೋದಷ್ಟೇ. He has not thought it fit to call for the original records nor call for the copy of the sale deed. ಏನು ಇಲ್ಲ. Learned AGA takes notice for response number 1 to 4. Issue notice. Now the dispute is between whom?
The dispute is between the petitioners and the state, my lord. The state says now it is Gomad land.
Huh?
Out of the blue, the state says that it is Gomad land, therefore we cannot grant you that 1 acre 5 guntas. There is no document to show it is a Gomad land.
Why you are not in talking terms with this respondent number 5?
Lord, the respondent number 5 has, after the death of the petitioners.
They have also filed another writ petition?
No,
Huh?
to my knowledge, they had not filed as in the date I had filed. my lord.
Issue notice to respondent number 5. Learned counsel for the petitioners is directed to serve a copy of the writ petition from the annexures on the learned AGA.
Please.
Full stop. Next para. Learned counsel for the petitioners submits that although the petitioners herein were not parties to the proceedings before the deputy commissioner initiated at the hands of respondent number 5, the petitioners filed an application to implead themselves and an order was passed by the deputy commissioner to implead the petitioners. Full stop. Nevertheless, the petitioners were not formally impleaded and no opportunity was given to the petitioners to file their objections, and the impugned order has been passed dismissing the appeal on the ground that the parties have failed to prosecute the matter. Full stop. It is the contention of the petitioners along with respondent number 5 that 5 acres of land were granted in favor of 5 acres and
5 guntas.
5 guntas of land were granted in favor of late Sri Hanumantappa in an auction conducted on 8/11/1937. Full stop. Late Sri Hanumantappa sold 4 acres in favor of Srimati Vidyavati A. Shetty on 28/11/1994. Full stop. The petitioners are seeking the continuation of their names in the land records in respect of the remaining extent of 1 acre and 5 guntas. Full stop. However, it is now sought to be contended at the hands of the revenue authorities that what was granted in favor of Sri Hanumantappa was only 4 acres and he has sold the entire 4 acres. Full stop. Next para. Learned counsel for the petitioners is directed to furnish a copy of the sale deed dated 28/11/1994. Full stop. Next para. Release this matter on 6th of March 2024. Full stop. In the meanwhile, there shall be an ad interim order of stay of the impugned orders at annexures J.
Annexures, my lord, D, E and H.
AC
A, my lord.
Huh?
D, E and J.
D, E and J
Please.
till the next date of hearing.
Great.
Serial number 39, filing number now to withdraw the petition. Not now, 230 will see. Syllabus. ಫೋನ್ ಮಾಡ್ತಾನೆ
Sir.
ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ದೀವಿ.
ಕ್ಯಾಮ್ರಾ ವರ್ಕ್ ಆಗ್ತದೆ. ಇವರು ಅಲ್ಲಾಡಿಸ್ತಾರೆ. ಸೆಟ್ಟಿಂಗ್ ಮಾಡಿ ಬಿಟ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಲಾಕ್ ಆಗ್ಬಿಡ್ತವೆ. ಲೈಟಿಂಗ್ ಹೊಡ್ಕೋಬಾರ್ದು. ಲೈಟಿಂಗ್ ಹೊಡ್ಕಂದ್ರೇನೆ ಇಲ್ಲ 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 ಇಲ್ಲ, ಅದು ಪಿಂಕಿಂಗ್ ಆಗ್ಬಾರ್ದು. ನೋಡಿ ಬರ್ತಾ ಇಲ್ಲ. ಹಲೋ ಹಲೋ ನೋಡಿ, ಕ್ಯಾಮ್ರಾ ವರ್ಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಹೇಳ್ಬೇಕು ಅವ್ರಿಗೆ. ಆ ಕ್ಯಾಮ್ರಾ ಮಾತ್ರ ವರ್ಕ್ ಆಗ್ತದೆ ನೋಡಿ, ಈ ಕ್ಯಾಮ್ರಾ ವರ್ಕ್ ಆಗುತ್ತೆ. ಎಳ್ದಾಡ್ತಾರೆ. ಹಲೋ ಹಲೋ ನೋಡಿ ಬಂತು. ಅದೇ ಅವ್ರ ಇಂಟಿಮೇಷನ್ ಮಾಡ್ಬಿಡಿ. ಕ್ಯಾಮ್ರಾ ಬೆಳಗ್ಗೆ ಅದು ಇದೇ ವರ್ಕ್ ಆಗಿಲ್ಲ. ಅದೇ
ಸರ್ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಆಗುತ್ತೆ ಅಂತ ಹೇಳಿಕ್ಕೆ. ಅದು ನಾಳೆ ಬರ್ತದೆ ಅಂತ ಹೇಳಿದ್ರು. ಅದು ಹೋಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ನಂಬರ್ ಹೇಳಮ್ಮ. ನಂಬರ್
ಕೇಳಲ್ಲ.
ಅದನ್ನ ಎಲ್ಲ ಅಲ್ಲಾಡ್ತೀರ. ಅದು ಲಾಕ್ ಒಂದೊಂದು ಚೂರ್ ಚೂರ್ ಇರ್ತವೆ, ಹೋಗ್ಬಿಡ್ತವೆ. ಹಲೋ ಹಲೋ ಅದೇನ ಬಂದಿದ್ದು ಹೋಯ್ತು. ಈಗ ಬಂದ್ ನೋಡಿ ಸರ್. ಅದೇನ ಇದನ್ನ ಅಲ್ಲಾಡ್ಸ್ಬಿಟ್ಟಿತ್ತು. ಹಲೋ 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 ಹಲೋ
2015.
ಹಲೋ
28054.
ಅದೇ ವೈರೆಲ್ಲ ಅಲ್ಲಾಡ್ಸ್ಬಿಟ್ಟಿರ್ತಾರೆ ಸರ್. ಹಲೋ ಹಲೋ
Of 2015.
ಹಲೋ ಹಲೋ
ಆಯ್ತು ಹೇಳ್ತೀನಿ. ಇಲ್ಲ
ಅದೆಲ್ಲ ಅಲ್ಲಾಡ್ಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಮೇಕು ವೈರೆಲ್ಲ ಅಲ್ಲಾಡ್ಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದರಿಂದ ಅದು
ಮಾಡಿ ಸರ್.
ಎರಡು ಕಡೆ ನಾನು ಏನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ನಿಮ್ಗೆ ಕೇಸ್? ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಮೆಮೊ ಕೂಡ ಆಗಿಲ್ಲ. ಯಾವ ಮೆಮೊ ಬರಲ್ಲ ಬಿ ಗ್ರೂಪ್.
ಎರಡು ಕಡೆನೂ ಇಲ್ವಾ ಸರ್?
ಅಲ್ಲೂ ಇಲ್ಲಿ ಬರುತ್ತೆ ಎರಡು ಕಡೆ ಅದೇ ನೋ ಡೇಟ್
Continue, sir, list.
ಈ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ
ಸರ್ ಅದು ಅಲ್ಲ ಅವ್ರು ಬೆಳಿಗ್ಗೆ ಅರ್ಜೆಂಟ್ ಏನಾದ್ರು ತಗೊಂಡಿದ್ದಾರ ತಗೊಂಡಿಲ್ಲ ಸರ್ ಏನು ಆಗಿದ್ದಾರೆ
ಹಲೋ 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 ನೋಡಿ ಅದು ಬರುತ್ತೆ ಹೋಗುತ್ತೆ ಅದನ್ನೇನು ಇದು ಮಾಡಕ್ಕೆ ಹೋಗ್ಬಾರ್ದು. ಹಲೋ 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 ಹಲೋ
ಇವತ್ತು
ನೀವೇನ್ ಕೊಡ್ತೀರಲ್ಲ ಏನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಕೇಸ್
ಅದು ಏನೋ ಅವ್ರೇನು ಹಾಕ್ಬೇಕು
ಈ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದ್ರೆ ಬರಲ್ಲ
ಸರ್.
ಈ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದ್ರೆ ಬರಲ್ಲ. ಅಯ್ಯಪ್ಪ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಹಾಕೋಬೇಕು.
ಹೌದಾ? ಅಯ್ಯಪ್ಪ
ಅರ್ಲಿ ಹಿಯರಿಂಗ್
ಅರ್ಲಿ
ಈ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದ್ರೆ
ಅದು ನೆಮೋ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಟೈಪ್ ಮಾಡಿದ್ರೆ ನೀವು
ಹೌದಾ? ಓಕೆ ಸರ್. ಅದೇ ಬಂದೇ ಇಲ್ಲ ಕೇಳಿದ್ರೆ ಹೋಗಿ
ಕಳ್ಸಿಲ್ಲ ಅದನ್ನ
ಏನು ಅಯ್ಯ ಹಾಕೊಂಡಿದ್ದ ಸರ್?
ಏನಕ್ಕೆ ಅರ್ಜೆಂಟ್ ಬರ್ಬೇಕು ಕೂಡಲೇ ಅನ್ನೋದಕ್ಕೆ ಅಯ್ಯ ಹಾಕೋಬೇಕು.
ಅದೇ ಸರ್ ನಾವು ಜಮೀನಲ್ಲಿ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಸರ್ ಸೆಟ್ಗಳೆಲ್ಲ.
ನೀವು ಇಂಪ್ಲೀಡಿಂಗ್ ಇಂಪ್ಲೀಡ್ ಆಗಿಲ್ಲ, ನೀನೇ ಕೇಸ್ ಪಾಸ್ ಮಾಡೋದಕ್ಕೆ ಹೇಳಿಲ್ಲ.
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ವಿ.
ಹಾಕಿಲ್ಲ ಅಂತ ಬರಲ್ಲ ಅದು.
ಇವೆಲ್ಲ ಬಂದಿತ್ತು ನೆಮೋ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು ಅವ್ರೆ. ಪೆಂಡಿಂಗ್ ನೋಡಿ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದೈತೆ. 1, 2 ಸತಿ 3 ಸತಿ ಬಂದೈತೆ. ಬಂದಿದ್ದೀವಿ. ಅವ್ರು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಸರ್ ಅವ್ರಿಗೆ ಪಿಟಿಷನರ್ ಅವ್ರಿಗೆ ಅದೇನು ಹಾಕ್ತಾರೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು. ಇವಾಗ ಅದನ್ನೇ ಹೇಳ್ಬೇಕಾ? ಅದೇ ಹಾಕೊಂಡು ನಾವು ಇಂಪ್ಲೀಡಿಂಗ್ ಮಾಡಿ ಪರ್ಮಿಷನ್ ಎಲ್ಲ ಹೋಗಿ ಬಂದಿದೆ. ಫಾರಂ ಸಿ ಎಲ್ಲ ಹೋಗಿ ಬಂದೈತೆ ಸರ್. ಆ ತರ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಕೇಸ್ ಹಾಕ್ಬೇಕು ಅದಕ್ಕೋಸ್ಕರ ಅರ್ಜೆಂಟ್ ಇದೆ ಅಂತ ನೆಮೋ ಮಾಡಿದೆ. ಮೊನ್ನೆನೂ ಕೊಟ್ಟಿದ್ದೆ ನಾನು, ಅವತ್ತು ಹಾಕಿಲ್ಲ. ಅವರು ಚೇಂಜ್ ಆಗ್ತಾರೆ.
ಒಂದು ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೆ ಹೋಗಿಲ್ಲ ಸರ್.
ಸೇಮ್ ನಮ್ದು ತರ ಅದಕ್ಕೆ ಕೇಳ ಸರ್ ಯಾವಾಗ ಹಾಕಿರ್ತೀರ? ಹ್ಞೂ ಸರ್. 5 ಸರ್ 5 ಬೇಡ ಸರ್, ಅಲ್ಲಿ ಬೇಕೆ. ಹ್ಞೂ ಸರ್ 5ಕ್ಕೆ ಅಲ್ಲಿದೆ ಲೋಯರ್ ಕೋಟೆ. ಹ್ಞೂ ಓಕೆ ಸರ್. ಹ್ಞೂ ಸಾಕು ನೋಡಿ ಸರ್. ಕೊಯ್ಲು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದೇ ಓಕೆ ಸರ್, ಹಂಗೆ ಮಾಡಿ ಸರ್. ಥ್ಯಾಂಕ್ಸ್ ಸರ್. 2ನೇ ತಾರೀಕ ಸರ್? ಹ್ಞೂ ಸರ್ ಥ್ಯಾಂಕ್ಸ್. ಅದೇ ಏನ್ ಹಾಕ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಅದನ್ನ ಫಾರಂ ಸಿ ಆರ್ಡರ್ ಆಗಿದೆ. ಅದಾದ್ಮೇಲೆ ಸಾಹೇಬ್ರ ಮುಂದೆ ಬಂದಿತ್ತು ಏನಾರು ಹಾಕ್ತೀರಾ ಅಂದ್ರೆ ಆರ್ಡರ್ ಮಾಡೋ ಟೈಮ್ ಕರೆಕ್ಟ್ ಆಗಿ ಅವ್ರು ಅದೇನ್ ಹಾಕ್ತಾರೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಹೇಳಿದ್ದಾರೆ. ಫಾರಂ ಇವಾಗ ಅಲ್ಲೋ ಆಗ್ಬೇಕಲ್ವಾ ಸರ್ ಇಂಪ್ಲೀಡಿಂಗ್. ಆಮೇಲೆ ಆಗಿದೆ, ಫೈಲಲ್ಲಿ ಇದೆ ಅಲ್ಲಿ. ಅದಾದ್ಮೇಲೆನೆ ಇಲ್ಲಿ ಕಳ್ಸಿದ್ ಕೋರ್ಟ್ಗೆ. 2 ಸತಿ ಬಂದಿತ್ತು ಸರ್. ನಾನೇ ಇದು ಗ್ರಾಂಟ್ ಲ್ಯಾಂಡ್ ಸರ್, ಅದು ನಮ್ದು. ಓಕೆ ಸರ್, ನಾನೇನೆ ಕಳ್ಸಿ. ಓಕೆ ಸರ್, ಇನ್ನೂ ಒಳ್ಳೇದೇ. ಕೇಳಿ ಸರ್, ಚೆನ್ನಾಗಿದೆ. ಯಾಕಂದ್ರೆ ನಾನು ಕಷ್ಟ ಎಲ್ಲ ಅದ್ರಲ್ಲಿ ಬರ್ದ್ಬಿಟ್ಟಿದ್ದೀನಿ ಈ ತರ ಆಗಿದೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಇಲ್ಲ ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ. 26,521 ಬಾರ್ ಕೊಟ್ಟಿದ್ವಿ. ಹಾ ಇಲ್ಲ ನಾನು ಹೋಗಿ ಪೆಂಡಿಂಗ್ ಬೆಂಚ್ಕೊ ಬಂದೆ ಸರ್. ಇಲ್ಲ ಸರ್, ಡೆಫಿನೆಟ್ ನೋಡ್ಕೊಂಬಂದೆ ಸರ್. ಪ್ಲೀಸ್ ಸರ್, ನಿಜವಾಗ್ಲೂ ನೋಡ್ಕೊಂಬಂದೆ. ಹಂಗಾಗಿ ಬಂದೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಬರ್ತಿರ್ಲಿಲ್ಲ ನಾನು. 26/5/21 or 23 KLR RES.
ನೋಡಿಲ್ಲ ನೀವು ಅಲ್ಲಿ ಮೂಟ್ ಮಾಡಿ ಲೀಡ್ ಮಾಡ್ಬೇಕು.
ಸರಿ ದೂರ ಇದೆ ಅದಕ್ಕೆ ಬರಕ್ ಕಾಣಿಸಲ್ಲ. ಅದು ಅದಕ್ಕೆ ಬರುತ್ತಾ ಇದಕ್ಕೆ ಬರ್ತಾ ಇದೆ ಇದಕ್ಕೆ ಬರುತ್ತಾ.
Wait. Huh? Huh?
Their prayer has been considered, this representation has been considered.
Serial number 39.
39.
Learned Counsel for the petitioner has filed a memo dated 28/2/2024 stating that the prayer in the writ petition has become infructuous since the respondent authorities have issued an endorsement rejecting the application filed by the petitioner for registration of Khata. Full stop. The learned counsel would therefore submit that the petitioners may be permitted to withdraw the writ petition and raise a challenge to the endorsement issued by the respondent authorities. Full stop. Next para. The memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands dismissed as withdrawn with liberty reserved to the petitioners to raise a challenge to the subsequent endorsement issued by the respondent authorities.
Wherein for caveat amalo.
Huh?
For the caveat amalo.
Huh. That's all right. The matters come up for office objection.
We have. Yes, my lord. My lord,
No. All documents to be filed, to be sworn before the oath commissioner. You can't make that submission because according to them, any orders that would be passed on your petition would affect their rights. So therefore, in terms of section 148A, they have filed a caveat petition. You are required to serve a copy. Please serve a copy.
We'll serve a copy, minutes, but
Yes, but you are, they have not been implemented in the writ
they
petition.
have not been
That is your,
added as a party in
submission.
the
All right.
proceedings.
What about the other office objections?
Lots other office objections are with respect to the type copy of the sale.
Oath
Please, minutes.
to be sworn before the oath commissioner.
That is complied, minutes. All those objections have been complied.
Complied.
Please, minutes.
When?
On 23/2/24, minutes has been complied. All those objections.
So only two office objections remain.
Please, minutes. We have made submissions with those.
Typed copy of Annexure C.
But these documents are just only to indicate that we have purchased a property via these sale deeds. And we have been the owners of the property. There is no dispute with respect to the extent of ownership on those.
The learned counsel for petitioner has served a copy of the writ petition
Yes, my lord.
on learned counsel Shri Praveen S,
Yes, my lord.
who has filed a caveat petition on behalf of
Respondent number 3.
respond ಮಾಡಿಲ್ವಲ್ಲ ಇಲ್ಲಿ.
No, my lord.
On behalf of the parties. In fact, my lords, what prayer is only to consider the representation for conducting survey. This also has been in the earlier round of litigation.
Of
Petition is.
one Shri Nag Vinod,
Yes, my lord.
Huh?
Yes, my lord.
Nag Vinod J.
The respondent in W.
Will stop. It is the contention of the learned counsel for petitioners that the prayer in the writ petition is
It's on page number 13, my lords.
to issue a writ of mandamus directing the respondent authorities to consider the representation given by the petitioner for survey and hadbast of the land in question, and therefore the caveator is not in any way prejudiced by the prayer made in the writ petition. Full stop. What is your contention?
My lord, if a date might be given, we shall be objecting it, my lord.
Huh?
Shall be filing objection.
No, you will get an opportunity when the authorities issue
Notices
notice.
have to issue, issued by the.
You are a neighbor,
Yes, my lord.
notice will be issued to you. You go raise your objection.
The copy was served to us now here, so we should.
All right. If that is the only prayer,
That's the only prayer.
hadbasta,
ಹೌದು ಓಡಿ ಅದು ವಸ್ತು ಅಂತ
OD and hadbasta, then you will have to file online application.
ಪ್ರೈವೇಟ್
But-
ಲ್ಯಾಂಡ್ ಅದು.
We have,
You will have to file online application before the authority.
my one submission before your lordships is what has happened. About 2 years back, my lords, there was a dispute between the respondent and the petitioner with respect to certain boundaries of the lands, just situated adjacent to each other in survey number 13. Therefore, my lords, this respondent number 6
instituted the proceedings before the revenue authorities to conduct the survey. That survey notice was issued on a dead person who is my husband. That was challenged before this honorable court, my lords, and this honorable court set aside the notice because saying that the notices have to be issued afresh because the LRs have to be heard, and that order has also been produced at page number 131 of the writ petition, my lords.
130?
131.
130, Annexure J.
Annexure J.
Ah.
There, my lords, what has happened is at page number 134, para number 5, my lords. In the above facts and circumstances, I am of the view that the notice under challenge at so-and-so dated 10/6/2022 has spent itself. Therefore, the respondent number 1 and 2 are directed to issue notice of survey of land in question to petition number 1, who is a GPA holder of petition number 2 to 5, and also to the respondent number 3. Now, what has happened is after that, there has been no notice issued. In fact, there's an earlier direction itself to issue notice and conduct the survey. That has not been done by the revenue authorities. That's the only grievance before I'm before your lordships.
No. That person was asking for survey.
Please, my lords.
Why are you insisting that?
My lords, what is happening is
If he doesn't want the survey to be conducted, how can you insist? No, let him press for the prayer.
Problem is there's a constant
notice has to
interference.
be issued to you.
It is about
If
20
that is the
acres of.
case, in all fairness, you should have implemented him as a party respondent here.
Please, I'll do it, my lords. If your lordships direct me, I'll have it done, my lords.
No,
I'll add them as a party. But
matter can be disposed of even now.
please, my
There
lords.
is no difficulty.
Please, my lords.
You have you filed an application?
Now, I have filed a representation recently, my lords.
Angagadilla. You will have to file an online application then.
Oh, online.
For Podi and Durastha, you will have to file online application. Only then it will be considered. Earlier, that person wanted
We now also we are not objecting to conduct the survey, my lords. Survey may be conducted.
If you want that to be done now, you will have to file an application online.
We'll file it. We'll have it.
ಮಾಡಿ. All the other office objections are overruled. Barkali. Learned AGA takes notice for
All respondents.
all the respondents. Learned counsel, Shri Praveen S. has filed a caveat petition on behalf of
Nagavinod.
Shri Nagavinod J, son of late N. Jagannathan. Full stop. The learned counsel is present before this court. Full stop. Next para. The petitioner is seeking a writ of mandamus directing the respondent authorities to consider the representation dated 8/12/2023 given by the petitioners seeking survey and hadbast of survey number 13 of Hasugavalli village, Belagodu Hobli, Sakleshpura Taluk, Hassan district. Full stop. Next para. Learned AGA submits that for a hadbast and survey to be conducted, the petitioners are required to file online application. Full stop. Next para. The grievance of the caveator is that earlier the caveator had filed similar application for survey and hadbast, and the petitioners herein had challenged the same before this court in WP number 11646 of 2022 on the ground that notice was issued to a dead person and the survey authorities are proceeding to conduct the survey and hadbast without issuing notice to the legal heirs of the previous Kathadar. Full stop. This court by order dated 24th of March 2023 held that the notice ought to have been issued to the legal representatives of late Shri Ibrahim Abdul Sheikh, since as on the date of the notice dated 10/6/2022, Shri Ibrahim Abdullah Sheikh was no more. Full stop. The writ petition was therefore disposed of, directing the respondent authorities to issue notice of survey to the petitioners, to petitioner number 1 therein, who is the power of attorney holder of petitioners number 2 to 5, and also to respond number 3, and thereafter proceed in accordance with law. Full stop. Next para. Having regard to why you are not insisting now on the survey and husband. Earlier you wanted that to be done.
My lord.
What happened now?
Lord, pardon my ignorance, my lord. Kindly, my senior.
You do not know.
Pardon.
Having regard to the facts stated herein above, this court is of the considered opinion that if the petitioner is seeking survey and hadbast, then the petitioner will have to make an online application. Full stop. However, since similar directions were sought at the hands of Shri Vinod.
Yes,
J, the cavator respondent herein, and this court had directed the respondent authorities to issue notice to the writ petitioners therein.
please.
And it appears that nothing further has been done in terms of the directions issued by this court, the fifth respondent, Assistant Director of Land Records, Sakleshpura Taluk, he is hereby directed to comply with the orders passed by this court in WP number so and so. Dated 24th of March 2023. Full stop. If the survey and hadbast was required to be done at the instance of the cavator respondent in terms of the directions issued by this court, notice was anyhow required to be issued to the petitioner herein.
We are the neighboring landowners.
Full stop. In that view of the matter, the Assistant Director of Land Records, Sakleshpura Taluk, is hereby directed to proceed in terms of the directions issued by this court in WP number so and so, issue notice as was directed by this court, and conclude the survey and hadbast as expeditiously as possible, and at any rate within a period of 2 months from the date of receipt of a copy of this order.
Please.
Ordered accordingly.
Grateful.
Non-compliance of the obstruction for third time, serial number 23, Chetan B.
Appear for the petition, my lord. I had completed the office objections on 21/2/2024, my lord. My lord, now, my lord, the office objections is, my lord, regarding the date of endorsement order to be clarified para, my lord. Lord, at annexure A, my lord, I have filed the application, my lord, for conversion at page number 13, land conversion for residential purpose, my lord, on 2/3/2021, page number 13, my lord. My lord, at page number 15, bottom, my lord, on 12/8/2021, my lord, my application came to be rejected, my lord. DC recommendation, my lord. Remark and date is in date means, my lord, the date of filing application.
Outdate is 6/8.
My lord, 12/8, my lord. 12/8, my lord.
Illappa.
Page number 15, my lord. It is mentioned
In
as
date is 5/3/2021. Adar pakkadalli outdate 6/8/2021.
Lord, Lord, I have been referring to, my lord, DC recommendation, my lord.
Adene.
The recommendation, my lord, is rejected. Thereafter, remark is rejected as per ADC report. Next is in date is 3/2/2021 and out date is 12/8/2021, my lord. I'm referring to page number 15, my lord.
Last ಅಲ್ಲಿ DC recommendation ಅಂತ ಬರುತ್ತಲ್ಲ. Last paragraph.
ಏನಿದು? What is this?
My lord, this is the online
Transaction report.
Lord, now we have to file the online application for conversion. Lord, accordingly, I have made the application. Lord, they have rejected on 12/8/2021, my lord. This is the prayer, my lord. In the prayer, I have mentioned the date as 12/8/2021. Office, my lord, says, my lord, need clarification on that.
ಇದರಲ್ಲಿ ಫಸ್ಟ್ ಸ್ಟೇಜ್ ವೈಸ್ ಹೋಗ್ತಾರೆ. ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ಮೇಲೆ ಯಾರ ರೆಕಮೆಂಡೇಶನ್ ಯಾವತ್ತು ಬಂದಿತ್ತು ಅಂತ ಹೇಳಿ. ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಸೀಸ್ 15 ಅಲ್ಲಿ ಟಾಪ್ ಅಲ್ಲಿ AC ರೆಕಮೆಂಡೇಶನ್ ಬರುತ್ತೆ ಫಸ್ಟ್. AC recommendation date it was placed before the AC on 3/2/2021 and out date he passed an order on 22/7/2021. Ad next DC case worker recommendation. ಅದು 3/2/2021 out date 3/8/2021. Last al bande the final one which is rejected by the deputy commissioner. DC recommendation after all these recommendation in the date of in date is the 3/2/2021 as common. Out date and the day when the DC rejected was 12/8/2020.
In my prayer also, my lord, I have mentioned it as 12/8/2021. Lord, office wants clarification on this one. Lord,
Date of annexure D to be clarified.
Lord, annexure B also, my lord, I'm page number 18. My lord, I'm relying only on the second half of the order. Second, my lord, the annexure B, my lord. My lord, I'm just the original copy may kindly be referred to page number 18, my lord. My lord, at the top, my lord, I'm not relying on that, my lord. My notification is, my lord, below, my lord, form B. My lord, that is number RD 46 AQT 81 dated 6th July 1981. My lord, office want clarification, but since in a one page, my lord, there are two notification, they have sought clarification. My lord.
Office objections are overruled.
My lord, as referred at page number 15, my lord, the date of inward is 3/2/2021.
What is the prayer in the writ petition?
My lord, to prayer the quash the, my lord, the endorsement of rejection and to issue a mandamus, my lord, directing the respondent, my lord, to calculate the conversion fees in view of the deemed conversion, my lord. My lord, the deputy commissioner, my lord, ought to have, my lord, issued an endorsement within 4 months from the date of the receipt of my application.
Ah.
My lord, as we could see it, my lord, the inward date is 3/2/2021. The rejection date is 12/8/2021.
But you are not asking for a declaration that there is a deemed conversion.
My lord, prayer B is, my lord, for that, my lord.
Prayer B fees collect ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ.
Prayer B.
Mandamus or any other direction to calculate the conversion fee.
In view of the deemed conversion, my lord, in view of the deemed conversion as
Ah.
per section 95(5) of the Karnataka Land Revenue Act. My lord, even the reason assigned by the deputy commissioner is also, my lord, not, my lord, is erroneous. My lord,
All right. Learned AGA takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures from the learned AGA. Full stop. Next para. Since the contention of the petitioner is that the deputy commissioner did not inform the petitioner
Yes.
of any requirement of furnishing any information or documents, comma, in terms of subsection 5 of section 95 of the Karnataka Land Revenue Act, 1964, comma, there is a deemed conversion.
Yes.
And consequently, the deputy commissioner should be directed to inform the petitioner of the conversion fee and fine that has to be paid, comma, the learned AGA is directed to secure instructions and make submissions. Yes. Full stop. Release this matter on 6th of March.
My lord, office objections may be overruled.
Office, ಆಯ್ತಲ್ಲ?
Oblige.
Non-compliance of office objection.
But seventh, my lord, seventh, my lord. Kindly, it may be taken on 7th.
You want it on 7th?
Yes,
All right, 7th.
Oblige.
Each time.
I require certain document from the party, my lord. Party is not responding. I should write a letter to the party and file a retirement memo, my lord. Your lordship may kindly accommodate a week's time, my lord.
No retirement, I don't accept retirement memos.
No, my lord. Your lordship may kindly see annexure D, my lord.
It's all right, sir.
Please.
You may say so, we will dismiss the writ petition.
Your lordship may kindly adjourn it for a week.
Not by permitting you to
My lord, your lordship may kindly adjourn.
retire and
I
court
seek-
notice has to be issued.
No, my lord. I seek a week's time, my lord, or else I shall take appropriate steps to comply, or else, fine.
There are 14 office objections.
Yes, please,
raised.
my lord.
Full stop. Learned counsel for the petitioner submits that although the learned counsel has made efforts to get in touch with the petitioner and ensure there is compliance of the office objections, comma, the petitioner has not been able to contact the petitioner. Full stop. Learned counsel, however, seeks for some more time.
A week, my lord.
Full stop. Next para. Release this matter on 7th of March,
Please, my lord. Please.
2023.
Please, my lord.
Yes.
Orders, serial number 25. Gurudev Gachingmat. Non-compliance.
Lords, LR application for bringing LRs of the petition number 4 has been filed. My lord. There are certain office objections, my lords. I need to comply. Pray for a week's accommodation.
Finally, a week's time is granted at the request of learned counsel for petitioners for compliance of the office objections raised on IAS number 123 of 2024.
Yes, my lords. Any date, my lord, 6th, my lords, 6th, my lords.
Serial number 26.
Release this matter on 6th of March.
Obliged.
Serial number 26, Shaker LS. Steps. This is R6.
6.1.
Objection
I
to
appear for petitioner, pray for a week's accommodation.
Non taking steps to bring LRs of deceased respondents and 7/1/2022.
Lord, they are unable
over.
to get it. Anyway, I'm seeking for the last time, a week's accommodation.
By operation of law, The writ petition is already abated.
I'll seek necessary file necessary applications, my lord. Cancel the abatement in that. Because he is also one of the persons who has been granted occupancy rights.
Although it was noticed in the order dated 7/1/2022 that response number 6 and 7 are no more. And the petitioner is required to take steps to bring the legal representatives on record. No application has been filed, full stop. However, learned counsel for the petitioner seeks one last opportunity to file necessary application, full stop. 2 weeks' time is granted to do the needful. Yes. What about the connected matters?
Somsekhar is appearing. Even there also LR applications were made probably regarding the same.
ಯಾವ್ದು ಹಾಕಿದ್ದಾರೆ IA 1/2023 for respondent for 4 B and C. ಇದರಲ್ಲಿ respondent number 5 B and C ಅವರೇ ಇರಬೇಕು.
ಅವರೇ ಇರಬೇಕು.
Same person.
Even different numbers. He has not sought a copy on me, so ಹಾಗಾಗಿ ನಾನು I cannot make sufficient.
ನೋಡಿ ಬಂದ್ರು ನೋಡಿ. ಯಾವ್ದು ನಿಮ್ದು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 54373 ಅಲ್ಲಿ IA ನಂಬರ್ 1/2022 ಕೊಡ್ರಿ.
Impleading ಅಲ್ಲ? ಹೋಗಿದ್ಯಾ? ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಕಾಪಿಸ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ ಕಾಪಿ.
ಅಲ್ಲ ಯಾರದು ಪ್ಲೀಸ್ ಸಿ ದಿ ನೇಮ್.
Same ಪುಟ್ಟ ಎಲ್ಲಯ್ಯ ಅನ್ಸುತ್ತೆ. Anyway, he was dead. In my writ petition, his children and wife were made parties. So he gives a different numbers in his writ petition. That's the problem.
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಅದು ನಂಬರ್ಗಳು ಚೇಂಜ್ ಆಗುತ್ತೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್.
ಅಲ್ಲ ಅದಕ್ಕೆ ಹೆಸರು ಕೇಳ್ತದೆ. ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಏನ್ ಹೆಸರು ತೋರಿಸಿದೀರಾ? IA 1/2022 ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಹೆಸರೇನ್ ತೋರಿಸಿದೀರಾ?
Four A Putrajamma and 3A Putrajamma and Lokesh and Puttalaya, son of Mariappa Singh
ಹೌದು,
by
ಹೌದು.
Lars.
ಆ ಫಸ್ಟ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅದನ್ನು ತೆಗಿರಿ. ಫಾಸ್ಟ್ ಟೈಟಲ್ ತೆಗಿರಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 A ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮೀ ದೇವಮ್ಮ
Lakshmi Devma, yes, my lord.
died and respond number 4B Krishnappa
Krishnappa.
died. ನಿಮ್ದು ಯಾವ್ದ್ರಿ?
Krishnappa and Mariappa are dead.
Krishnappa son of
Puttiyallaya, one of the
Avರೇನಾ?
grantee.
ಹಾ
Puttiyalla is one of the grantee of the occupancy.
ಇನ್ನೊಬ್ರು ಯಾರು?
Innobru Mariappa.
ಮರಿಯಪ್ಪ.
7 is Mariappa,
ಅದೇ.
he is also son of Puttiyallaya.
ನೀವು ಅವ್ರದಿನ್ನೂ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ನೀವು?
I have not.
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಹಾಕ್ಬೇಕಾಗಿತ್ತು, ಹಾಕಿಲ್ವಲ್ಲ? LRs of R4B ಕೃಷ್ಣಪ್ಪ ಇಲ್ಲ. R4A R4B R4C ಇಲ್ಲ, ಮೂರು ಹಾಕಿದ್ದಾರೆ.
Krishnappa Thiru.
Leaving behind the response number 4B
And 4B, B2.
4B to F. So they are already there. Since they are already on record, no application is filed.
Yeah, and Mariappa
Krishnappa.
Mariappa also died. And his wife-
Left, left behind Srimati Bhagyamma and
Jairama.
Jairama
Yes, ma'am.
as legal heirs. Hence, the petitioner may be permitted to bring them on record. Mariappa,
4C, my lord, Mariappa, he died. Avargunu
Saubhagya, Ranjita, Soumya.
Yes, my lord. They also died, their legal heirs, wife and children. Saubhagyamma, Ranjita and Soumya.
ಇದ್ರ ಮೇಲೆ ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ?
Notice, my other friend is directed to take notice.
Huh?
on them, my lord.
Huh?
My friend who is appearing,
Mr. Avani Ravindranath used to appear. He said he will take notice, but
Will
he has
take
not
notice,
filed
ma'am.
Wakala.
and he is appearing
Order
for.
ಆಗಿದ್ಯಾ?
Order ಆಗಿರ್ಲಿಲ್ಲ. He made a submission on that day.
That he will file ವಕಾಲತ್ ಅಂತ ಹೇಳಿದ್ರು.
Notice is not at order.
Not
in
at
his
order.
applications.
Since he is appearing for the, all the response, my lord.
ನೀವು ಆರ್ಡರ್ ಶೀಟ್ ಕೊಟ್ಟಿತ್ತು. ಯಾವ್ದಿದು?
Is
Hello, 54373.
For 3B or 4B to F.
54373 ಸಪರೇಟ್ ಆಗಿದ್ಯಾ?
ಆಮೇಲೆ ಇದ್ರಲ್ಲಿ ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಅಲ್ಲೂ ರವೀಂದ್ರನಾಥ್ ಫಾರ್ 4DEF ಅಂತ ಇದೆ. ಬೇರೆಯವ್ರಿಗೂ ವಕಾಲತ್ ಆಗ್ತೀವಿ ಅಂದ್ರು. ವಯಸ್ಸಿಗೆ ನೀವು ಹಾಕಿದ್ರಿ. ಚಿಕ್ಕರಂಗಮ್ಮಗೆ ಹಾಕಿ.
ಬೀನಾನು ಹಾಕಿದ್ದಲ್ಲ ಅವಳು.
19.
Otherwise, I will have to take notice for them. Since he said he will file wakalat, my lord. Perhaps you kindly out next week, my lord, I will make request to my land friend to get the wakalat. my lord.
You please take all this information.
Please, my lord.
I have noted down the information.
You please formally file an application, please. In a week's time,
Please, my lord.
we'll have it listed. We will ensure that the learned counsel appears and we may issue direction. Please.
I'll give all the information to my.
ಅದು 2 weeks time ಅದನ್ನ ತೆಗೆದಾಕ್ಬಿಟ್ಟು a week's time is granted ಅಂತ ಹಾಕಿ. Release this matter on 6th of March 2024. We stop. Please
Please,
ask this learned counsel to
please.
come on the next date of hearing.
I'm sorry, my lord, I was held up in other. Therefore, please.
Number 27, Lata Shetty. move for deletion.
I appear for seventh respondent in this case.
The government have filed the third Tahsildar has filed a report, my lord, stating the encroachment by the respondents.
In this case, my lord, I have to file objection to the commission report as well as the main petition also, my lord. After 10th, any date may be given, my lord, I will file a statement of objection as well as the objection to commission report, my lord.
My lords,
ನೀವು ಹಾಕಿದ್ದೀರಾ?
ನಾನು ಹಾಕಿದ್ದೀನಿ.
ಹಾ.
My lords may kindly take commissioner's report for a moment. It is filed along with the memo dated 14/2/2024.
First, let us see the report.
That is filed along with the memo dated 14/2/2024. Lords may kindly see the reference number 5. Reference number 3 and reference number 5 in the said report. Reference Ulleka. First page ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಉಲ್ಲೇಖದಲ್ಲಿ ಈ ಕಚೇರಿ ಪತ್ರ ಸಮ ಸಂಖ್ಯೆ ದಿನಾಂಕ 6/1/2024. My lord's order is dated 24/1/2024 to conduct the survey by after issuing notice to all the parties concerned. They refer to 6/1/2024. Now kindly come to serial number 5. ತಾಲೂಕು ಭೂಮಾಪಕರು ಕಾಪು ಇವರ ಅಳತೆ ವರದಿ dated 7/2/2023. Now my lord's order is 24/1/2024 to conduct the survey and submit a report. What the Tahsildar does, my lords, he places reliance on the earlier survey report and he gives the opinion that, my lords, that is forthcoming in the report itself. Kindly see the first paragraph itself, my lords. From the first paragraph, 4th line, my lords. ಅದರಂತೆ, my lords, ಪೂರ್ತಿ ಓದಿ ಪ್ಲೀಸ್. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ WP ನಂಬರ್ ಸೊ ದಿನಾಂಕ 13/7/2023 ದೈನಂದಿನ ಆದೇಶದಲ್ಲಿ ಕಾಪು ತಾಲೂಕು ನಟ್ಸಾಲು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೊ 1 ಎಕರೆ ಜಮೀನಿನ ಅಳತೆ ಕಾರ್ಯ ನಡೆಸಿ ಒತ್ತುವರಿಯಾದ ಬಗ್ಗೆ ವರದಿ ನೀಡುವಂತೆ ನಿರ್ದೇಶಿಸಿರುವುದಾಗಿರುತ್ತದೆ. ಅದರಂತೆ ಭೂಮಾಪಕರು ಸಂಬಂಧಪಟ್ಟ ಜಮೀನಿನ ಖಾತಾದಾರರಿಗೆ ನೋಟಿಸು ನೀಡಿ ಈಗಾಗಲೇ ಅಳತೆ ಕಾರ್ಯ ನಡೆಸಿದ್ದು ಒತ್ತುವರಿಯಾದ ಜಮೀನಿನ ವಿವರವನ್ನು ನಕ್ಷೆಯೊಂದಿಗೆ ನೀಡಿರುವುದಾಗಿದೆ. ಈ ಬಗ್ಗೆ ಉಲ್ಲೇಖ 3ರ ಈ ಕಚೇರಿಯ ಪತ್ರದಂತೆ ಸದ್ರಿ ನಕ್ಷೆಯನ್ನು ಲಕ್ತೀಕರಿಸಿ ವಿವರವಾದ ವರದಿಯನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಲಾಗಿರುತ್ತದೆ. That means he places reliance on the earlier survey report, which was conducted, my lords, without issuing any notice to us and without even, my lords, following the procedure known to law. Now kindly come to para 2. ಆದರೆ ದಿನಾಂಕ 24/1/2024 ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ದೈನಂದಿನ ಆದೇಶದಲ್ಲಿ ವಾದಿ ಹಾಗೂ ಪ್ರತಿವಾದಿಯರ ಸಮ್ಮುಖದಲ್ಲಿ ಅಳತೆ ಕಾರ್ಯ ನಡೆಸಿ ಒತ್ತುವರಿಯಾದ ವರದಿಯನ್ನು ನೀಡುವಂತೆ ನಿರ್ದೇಶಿಸಿರುವುದಾಗಿದೆ. ಈ ಬಗ್ಗೆ WP ನಂಬರ್ 7 ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ವಾದಿ ಪ್ರತಿವಾದಿಗಳಿಗೆ ದಿನಾಂಕ 6/2/2024 ಅಳತೆ ಸಮಯದಲ್ಲಿ ಹಾಜರಿರುವಂತೆ ನೋಟಿಸು ನೀಡಿದ್ದು, ಅದರಂತೆ ಕಂದಾಯ ನಿರೀಕ್ಷಕರು, ಗ್ರಾಮ ಆಡಳಿತ ಅಧಿಕಾರಿ ಪಡುಬಿದ್ರೆ ಸೊ ಶ್ರೀ ಹರೀಶ್ ಶೆಟ್ಟಿ ವಾದಿ, 7ನೇ ಪ್ರತಿವಾದಿ ಭಾಸ್ಕರ್ ಶೆಟ್ಟಿ ಬಿನ್ ಶೀನಶೆಟ್ಟಿ ಇವರ ಪರವಾಗಿ ಅಳಿಯನಾದ ರವಿ ಶೆಟ್ಟಿ, 8ನೇ ಪ್ರತಿವಾದಿ ಜಯರಾಮ್ ಕೆಪಿ ಇವರ ಪರವಾಗಿ ಅವರ ಮಗನಾದ ಅರುಣ್ ಕುಮಾರ್, 9ನೇ ಹಿದಾಯತುಲ್ಲಾ ಬಿನ್ ಸತ್ತಾರ್ ಅವರ ಪರವಾಗಿ ಅವರ ಕಟ್ಟಡದ ಬಾಡಿಗೆದಾರರಾದ ಬುಡಾನ್ ಸಾಹೇಬ್, 10ನೇ ಪ್ರತಿವಾದಿ ಮೊಹಮ್ಮದ್ ರಫೀಕ್ ಬಿನ್ ಸೊ ಹಾಗೂ 11ನೇ ಪ್ರತಿವಾದಿ ಸೈಯದ್ ಅಮಾನುಲ್ಲರ್ ಅವರ ಪರವಾಗಿ ಅವರ ಸಹೋದರ ಅಕ್ಬರ್ ಅಲಿ ಇವರುಗಳ ಸಮಕ್ಷಮದಲ್ಲಿ ಈ ಹಿಂದೆ ಅಳತೆ ಮಾಡಿದ ನಕ್ಷೆಯನ್ನು ಕಾಯಮಿಟ್ಟುಕೊಂಡು ತಾಲೂಕು ಭೂಮಾಪಕರು ಅಳತೆ ಕಾರ್ಯ ನಿರ್ವಹಿಸಿರುವುದಾಗಿದೆ. ಪ್ರತಿವಾದಿಗಳು ಅಳತೆ ಮುಗಿಯುವವರೆಗೆ ಜೊತೆಯಲ್ಲಿಯೇ ಇದ್ದು ಅಳತೆಯಾದ ನಂತರ ಹೇಳಿಕೆ ಮಹಾಜರಿಗೆ ಸಹಿ ಮಾಡಲು ನಿರಾಕರಿಸಿರುತ್ತಾರೆ ಹಾಗೂ ವಾದಿಯವರು ಹೇಳಿಕೆ ಮಹಾಜರಿಗೆ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ. ಈ ಹಿಂದೆ ಅಳತೆ ಮಾಡಿದ ನಕ್ಷೆ ತಯಾರಿಸಿರುವುದು ಸರಿ ಇರುವುದು ಅಳತೆಯಿಂದ ಕಂಡು ಬಂದಿರುವುದಾಗಿ ಉಲ್ಲೇಖ 5ರಂತೆ ತಾಲೂಕು ಭೂಮಾಪಕರು ವರದಿ ನೀಡಿರುವುದಾಗಿ. ಉಳಿದಂತೆ ಉತ್ತುವರಿಯ ವಿವರ ಈ ಕೆಳಗಿನಂತಿರುತ್ತದೆ. ನಾವು ನಟ್ಸಾಲು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ that is he has stated. Now kindly come to, my lords, the last paragraph. ಪ್ರಸ್ತುತ ಭೂಮಾಪಕರು ನೀಡಿರೋ ಅಳತೆ ವರದಿ ಹಾಗೂ ಕಂದಾಯ ನಿರೀಕ್ಷಕರ ತನಿಖಾ ವರದಿಯಂತೆ ಕ್ರಮ ಸಂಖ್ಯೆ 4/5/7 ಒತ್ತುವರಿಯು ಪಟ್ಟಾ ಜಮೀನು ಆಗಿರುವುದರಿಂದ ಈ ಕಚೇರಿಯ ಕಾರ್ಯವ್ಯಾಪ್ತಿಗೆ ಒಳಪಡುವುದಿಲ್ಲ. ಕ್ರಮ ಸಂಖ್ಯೆ 6ರ ಸರ್ವೆ ನಂಬರ್ 52/12 ಖಾತೆದಾರರಾದ ಹಿದಾಯತುಲ್ಲಾ ಬಿನ್ ಅಬ್ದುಲ್ ಸತ್ತಾರ್ ಇವರು ನಟ್ಸಾಲು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೊ 1 ಎಕರೆ ಜಮೀನಿನ ಪೈಕಿ 0.0021 ಎಕರೆ ಜಮೀನಿನಲ್ಲಿ ಮಾಡಿರುವ ಒತ್ತುವರಿಯನ್ನು ದಿನಾಂಕ 25/8/2023 ತೆರವುಗೊಳಿಸಿರುತ್ತಾರೆ. ಇನ್ನುಳಿದಂತೆ ಕ್ರಮ ಸಂಖ್ಯೆ 1, 2, 3, 8 ಮತ್ತು 9ರಲ್ಲಿನ ಒತ್ತುವರಿಯು ಸರ್ಕಾರಿ ಜಮೀನಿನಲ್ಲಿರುವುದು ಒತ್ತುವರಿಯಾಗಿರುವುದು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಪ್ರಸ್ತುತ ಸದ್ರಿ ಜಮೀನುಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ WP ನಂಬರ್ 7 ಪ್ರಕರಣ ದಾಖಲಾಗಿ ವಿಚಾರಣಾ ಹಂತದಲ್ಲಿರುವುದರಿಂದ ಸರ್ಕಾರಿ ಜಮೀನಿನಲ್ಲಿರುವ ಒತ್ತುವರಿಯನ್ನು ತೆರವುಗೊಳಿಸಿ ಸರ್ಕಾರದ ಸ್ವಾಧೀನಕ್ಕೆ ಪಡೆದುಕೊಳ್ಳುವರೆ ಅಸಾಧ್ಯವಾಗಿರುತ್ತದೆ ಎಂಬ ವರದಿಯನ್ನು ಘನ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿದೆ. This is the report.
Yes.
Now my respectful submission to my lords is I am concerned serial number 2, my lords. Page number 3.
Page number 6.
3. First report alle second page. Second page, serial number 2.
ಹಾ
ನಟ್ಸಾಲು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 52/1 0.01 ಹೌದು
ಒಂದು ಸೀರಲ್ಲಿ
ಒಂದು ಸೀರಲ್ಲಿ 0.01 ಎಕರೆ ಅಂದ್ರೆ 1 ಸೆಂಟ್ಸ್ ರ ಪೈಕಿ 0.0038 ಎಕರೆ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಸರ್ವೆ ನಂಬರ್ 52/7 ಖಾತೆದಾರರಾದ ಭಾಸ್ಕರ್ ಶೆಟ್ಟಿ ಇವರು ಒತ್ತುವರಿ ಮಾಡಿ ತಮ್ಮ ಪಟ್ಟಾ ಜಮೀನನ್ನು ಸೇರಿಸಿ ವಾಣಿಜ್ಯ ಕಟ್ಟಡವನ್ನು ನಿರ್ಮಾಣ ಮಾಡಿರುತ್ತಾರೆ. This is the allegation against
Yes.
me. Not even 1 cent. That means, my lords, 0. Not even half cents. This is the allegation against me.
ಫೋಟೋಸ್ ಏನಾರು ಇದೆಯಾ?
Yes, my lord.
ಇವರೇನೋ ಫೋಟೋಸ್ ಹಾಕಿದಾರ?
ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
Let us see.
ಅವ್ರೇನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
His photo, my lord. They have a 1 acre of land. Because of that reason, my lord, they are doing all.
Behind this property, my
because
lords,
it's not a PL, this writ petition itself is not maintainable. And that area, my lord,
behind this, my lords, our property, the property of the petitioner, my lords, is situated.
and
Now,
This open space.
yes.
that's
Now,
open place is their land.
Their
It's
land.
abutting to that land, my lord, is a highway.
Now-
Highway next to our land, our shop is there.
Hmm.
Since from 1966, my lord, we are in the possession of that property. And some of the property is purchased by the, some of the, and they are the respondent number 9 and 11, my lord, they are deleted. They are the owners, they are in possession of that property. And only who are not sell the land to their possession, that is the reason they are raising this aspect, and the revenue officials is collude with together.
What exactly is your grievance?
My grievance is, my lord, they have encroached on my land also, which is
Which-
adjacent to the.
So, if there is
and I-
encroachment on your land, you'll have to go to the civil
And
court.
further, my lord, they have encroached the Nala, my lord, due to which
Therefore,
during the rainy.
That was the
season-
only ground on which you have come before this court.
Please, my lord,
Huh? If you see these photographs,
I have not made available the
available.
copy.
This one is another one.
see these photographs. The entire open land is your land. ಈ ಸೈಡ್ಸ್ ಅಲ್ಲಿ ರೋಡ್ಗೆ ಅಬಟ್ಟಿಂಗ್ ಕೆಲವು ಚಿಕ್ಕದು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆ, ಅದು ನಮ್ಮದು.
That construction is
ಅಲ್ಲಿ-
on Nala, my lord.
ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ನಾಲ? ಅಲ್ಲಿ
ಅದೇ
ನಾಲ
ಎದುರಿಗೆ-
ಇಲ್ಲಿದೆಯಮ್ಮ
ಅದೇ
ಅಲ್ಲಿ.
ಆ ಬಿಲ್ಡಿಂಗ್, ಆ ನಾಲ ಮೇಲೇನೆ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದ್ದಾರೆ.
ಸೊ ದೇರ್ ಫಾರ್
That is the
If I
report
did-
what the.
ಅವ್ರು ಆಕ್ಷನ್ ತಗೊಂತಾರೆ. How are you agreed with that?
I'm
You are
not,
not going to get anything out of this.
no, my lord, I'm only,
You are not
on the
going to
mandate
get-
was to
see,
consider my
You
representation.
can see in that photograph that you have a big gate to your property.
I'm not aware of
You
the.
go use your property as you want with the permission of the competent authority, obtain a sanction plan, put up your construction. How are you concerned with the small encroachment that you are talking of? Let
My
them
lord,
take action in
you-
accordance with law.
No, let them take action in accordance.
Photograph,
It's
please.
not a PL also, my lord.
As per the report, my lord,
All
You
right,
can-
we will take note of that
please, my lord.
and we will
Take-
direct them to take action in
Please, my
accordance.
lord.
Nothing more in this. Barkali.
As per the report, they may take action. That's the-
Civil suit also pending, but.
Huh?
Civil suit already
also
pending.
With the civil court.
Who has filed?
We filed, one of the respondent filed a civil suit, and that is pending as I say municipality, because we purchased the land from the earlier owner. And half cents of land is the acquired by the highway authority.
The
In turn, my
Tahsildar, the Tahsildar has given details of wherever the public property is encroached.
Please, please.
He has given the information.
May I make
He
one?
is also given information regarding the encroachment on private
My
property.
lords, that insofar as that aspect of the matter is concerned, my lords, my respectful submission to my lords is, lords, in some cases where, my lords, the properties are acquired by national highways for the, my lords, purposes of widening of the road, they have granted, my lords, 1 cent of land, half cents of land to the persons whose properties are.
Therefore,
So Tahsildar will have to consider
Aitu.
that.
No. If they take action in accordance with law,
Yes.
when they issue notice.
Yes.
You put forth all
Yes,
this content.
that
That's what-
liberty may be, my lords.
The petitioner. seems to be aggrieved of,
May I make one request, my lords?
Non-consideration of my representation dated 23/7/2018.
encroachments said to have been made at the hands of the private respondents herein. And therefore, the prayer in this writ petition is to issue a writ of mandamus directing the respondent authorities to clear the illegal encroachment made on stormwater drain and public property. Full stop. Next para. During the course of these proceedings, directions were issued to
For the direction.
Third respondent has.
May I make one request here, my lords?
23-1.
It's not as per the direction of this honorable High Court, my lord.
Allah, during the course of these proceedings, it has been noticed that the matter was taken up before the special court for land grabbing. And during the course of the proceedings before the special court, information was made available at the hands of the Tahsildar that having regard to the distance between the local body and the lands in question, and having regard to a notification dated 13/10/2022 issued by the state government, the special court held that it will have no jurisdiction to try the matter. Full stop. Accordingly, the case against the accused persons was disposed of as abated. Full stop. Next para. This court held in its daily order dated 23/1/2024 that if that is the conclusion of the special court, then the ball now shifts to the jurisdiction of the local body, that is the Padubidri Panchayat and the Tahsildar. Full stop. Since the allegation of the petitioner is that the private respondents have encroached upon public drain, this court held that it was necessary to take action. Full stop. Therefore, a specific direction was issued to the fifth respondent Tahsildar, Kapu Taluk, to conduct a joint survey in the presence of the petitioner as well as the contesting respondents to find out as to whether there is encroachment of the public drain as alleged by the petitioner. Full stop.
May I make one request?
It was also noticed that in terms of the material available on record, the lands in question are in survey numbers 52/1B, 1C, 1D, 1E, 1F, 1G, 1H, 1J, and 1K of Nadasalu village, Kapu Hobli. Full stop. This court directed the Tahsildar to conduct a joint survey in the presence of the petitioner as well as the contesting respondents, conduct a spot inspection and inquiry and submit a report to this court.
May I make one
Full
request?
stop. Accordingly,
May I make one request?
Next matter. I'll come back.
The learned AGA submitted a memo along with the survey report on 14/2/2024. Full stop. Opportunity was given to all the parties, all the private parties to file their objections. Full stop. Objections have been filed to the inquiry, to the report
I have not.
at the hands of respond number 7. Full stop. Next para. Learned counsel for respond number 7 has pointed out from the survey report submitted by the Tahsildar that the encroachments at serial number 4, 5, and 7 pertain to patta lands, the removal of encroachment will not come within the purview of the Tahsildar. Full stop. According to Tahsildar, there has been minor encroachments at serial number 1, 2, 3, and 8, 1, 2, 3, 8, and 9 in terms of the sketch which has been annexed along with the survey report. Full stop. Next para. At this juncture, learned counsel for respond number
8 and 10, my lord.
8 and 10 has furnished a photograph of the lands in question. Full stop. On going through the said photograph, it is clear that the land belonging to the petitioner, ಎಷ್ಟು ಅದು measuring
1 acre.
ಎಷ್ಟಮ್ಮ ನಿಮ್ದು ಜಾಗ?
1 acre land.
1 acre.
1 acre land.
1 acre.
1 acre land. Plain land. They are going to construct.
Measuring 1 acre. Is situated in the heart of the town.
Please, near to highway.
Huh?
Near to highway. Between the highway and.
In the heart of the town, abutting the highway. ಯಾವ highway?
National highway. National highway.
ಯಾವ route ಹೇಳ್ರಿ?
Mangalore Udupi. Mangalore Udupi.
National highway. Mangalore Udupi route.
Between that, my lord, our land is there. Our shop is.
Full stop. ಇದು towards what side is the ಇದು highway? Any idea?
No idea.
As could be seen from the photograph, the national highway is on one side of the property belonging to the petitioner, and another main road is abutting the other portion of the land belonging to the petitioner. Full stop.
One
Looks
submission.
like, it looks like a corner site. Full stop. However, it is also clear from the photographs that there are small constructions between the land belonging to the petitioner
One
and
submission, my lord.
the highway and the road.
One submission, my lord. I dispute the photograph, my lord. I'm not aware of the,
ಇದನ್ನೇನಮ್ಮ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತೀರಾ ನೀವು?
I'm not aware, my lord, whether the photograph belongs
all
to the
right.
same.
Full stop. Prima facie, it appears that the petitioner is trying to make use of the extraordinary jurisdiction of this court to have the small tenements evicted or cleared. Full stop. As pointed out in the report of the Tahsildar, if the private respondents herein have encroached on private properties, then the person aggrieved will have to take action in accordance with law. Full stop. If the private respondents have encroached upon any public property or drain, then the competent authority, that is the Padubidri Town Panchayat, Gram Panchayat, or the Tahsildar will have to take action in accordance with law. Full stop. At any rate, there cannot be a grievance at the hands of the petitioner that can be redressed in this writ petition. Full stop. This is not a public interest litigation, as rightly pointed out by the learned counsels for the contesting respondents. Full stop. If any part of the property belonging to the petitioner has been encroached upon by the private respondents, then the petitioner will have to approach the competent civil court to redress the grievance. Full stop. Next para. With these observations, the writ petition stands disposed of.
One more submission. This respond number 8 and 10, my lord, they purchased the property. In the year 1966, that land is granted by the authority. That is the reason why if that finding
They
is
want
not.
to take action, let them take action in accordance with law.
Because the public,
In accordance with law, they'll have to issue notice to you. You give a reply, you file your objections. Please file this along with the memo, please. Observation. An observation after issuing notices to us. ಅದಕ್ಕೆ ಹೇಳಿದೀನಿ, in accordance with law.
ಈಗ ಈ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಅವ್ರೇನಾರು ಆಕ್ಷನ್ ತಗೊಂಡ್ರೆ ಮತ್ತೆ ಸಮಸ್ಯೆ ಆಗುತ್ತೆ.
Serial number 28.
Appearing for petitioner in this case.
Marilingi Gowda.
Earlier occasion, this honorable court directed the respondent number 3 to furnish the original scanning copy of the grant certificate.
In this matter, Your Lordship. There was a direction. What of? Firstly, Your Lordships. Last time, the original
Yes,
issue
yes.
register and all.
I had
are-
asked you to find
Yes.
out from the
Yes, yes,
department.
yes, Your Lordship.
Yes.
Now, this is the latest order in which they are digitizing all the revenue records. This is the latest order.
ಅಲ್ಲ ಅಲ್ಲ.
ಅಲ್ಲ,
See,
ಹಳೇದಕ್ಕೆ-
what I pointed out is
Yes,
that as far back as
yes, your lordship. Yes.
2000, 2005, ಅವಾಗ್ಲೇ such
The-
circulars were issued by
fact
the
is-
government.
Yeah, unfortunately, the fact is what happened was I am given upon instructions, the tender was issued. Then there was some issue with regard to the monetary aspects with the tender. So the matter was discontinued. So most of the hard disks that were, whatever work was digitized was taken away by the tender because there was some dispute regarding the monetary aspects with the government. However, some hard disks are in the office, in the record room, but they have been corrupted and there is no, after the order of this honorable court, they're trying their best to retrieve, if they can retrieve any data. But as far as the latest thing is concerned, the government now has issued an order and there is a training program that is doing, and as a pilot project, they had selected certain talukas, and in which the Bangalore South also is one of the talukas that are selected, which is serial number 5, which the order I have filed it. So this is dated 11/1/2024. Serial number 5, Bangalore Urban, Bangalore South Taluk. So instead of floating a tender to scan and do all the documents, now the government has taken the exercise by training their own officers, for which separately they are building infrastructure, and also that they are buying some computers and other equipment to digitize. Now that is in process, your lordship. Now, apart from that, upon verification on the record rooms, 2 documents that have original documents are placed here. That is called as the charge register. All the transactions that have been taken and all those documents that are placed with the record room for those years are entered here, including all RRTs, all conversion applications, everything. And upon verification, the application of this person is not found.
Application.
ಅಲ್ಲ, ಇವ್ರದ್ದು ಗ್ರಾಂಟ್ ರಿಜಿಸ್ಟರ್, ಗ್ರಾಂಟ್ ಅಪ್ಲಿಕೇಶನ್, ಅದು ಎಂಟ್ರಿ ಎದರಲ್ಲೂ ಇಲ್ಲ ಇದರಲ್ಲಿ. ದಿಸ್ ಇಸ್ ದಿ ಚಾರ್ಜ್ ರಿಜಿಸ್ಟರ್.
ಅಲ್ಲ, see, on the basis of the records made available by you last time,
Yes, sir.
we have recorded
Yes, sir.
that,
That is the issue register and
yes, as far back as 1980 to 83,
yes,
during the time of Podi and Durast,
yes, sir.
it has been recorded in the office of the Tahsildar that 5 persons, including Iskappa alias Venkatappa, were granted 2 acres each in survey number 10
Yes,
of Tippasandra village.
yes, yes.
The learned AGA would therefore submit that the impugned endorsement denying the fact that no information is available in the records may not be correct.
Yes. Now that I have submitted, those 2 records are there in the custody of this honorable court. ಇಲ್ಲೇ ಇದೆ ಸರ್.
Either,
ಹೌದು.
that is why we have kept it.
Apart from that, there are no other documents.
But then how that entries will come in then? ಹಿಂಗ್ ಹೇಳ್ತಾರೆ ಅಂತ ಗೊತ್ತು, ಅದಕ್ಕೇನೆ if at least in some places you have information at an undisputed point of time that you have recognized the grant made in favor of this person,
Yes.
you can't totally deny, ಇಲ್ಲ ಕೊಟ್ಟೆ ಇಲ್ಲ ಹಾಗೆ ಇಲ್ಲ ಅನ್ಬಿಟ್ಟು. On the basis of that, the RTCs have been recorded in their name. He is only asking for a certified copy of the grant order.
In such a scenario.
See, you are saying that the original grant register is not in a position to be looked into.
Yes.
So therefore, you also cannot totally deny grant ಆಗೆ ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ ನೀವು. That is why when your officers give that endorsement, they will say ಶಿಥಿಲವಾಗಿದೆ ಆದ್ರಿಂದ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ. They can't say we are verified and it is not there ಅಂತ ಹೇಳಕ್ ಬರಲ್ಲ. He has filed a appeal before the assistant commissioner under the PTCL Act.
Yes.
Allunu there is a requirement of him producing the original
Right.
certificate.
But now,
That is why he is asking for a copy,
now,
certified copy.
now the only hope now here is, they have found a hard disk, which according to them is corrupted because at that point of time, the previous tender. Now there is a procedure, they say that it can be retrieved, the data can be retrieved. They have received it now. I mean, they have found that after the order of this honorable court, they have found the hard disk.
Hmm.
They will try and retrieve, and if anything is found in the, as a scanned copy there,
ಮಾಡ್ಬೇಕಾಗಿತ್ತು ಇಷ್ಟರಲ್ಲಿ.
ಇಲ್ಲ, ಈಗ ಸಿಕ್ಕಿದೆ ಅಂತ ಅವ್ರಿಗೆ.
ಹ್ಮ್. ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ? ಅದನ್ನ ನೋಡೋದಕ್ಕೆ ಎಷ್ಟೊತ್ತಾಗ್ರಿ ಆಗುತ್ತೆ?
ಅಲ್ಲ, ಕರಪ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ ದೇ ಆರ್ ಟೇಕಿಂಗ್ ಅ ಚಾನ್ಸ್, ಬಟ್ ವಿ ಆರ್ ನಾಟ್ ಅ ಟೆಕ್ನಿಕಲ್ ಪರ್ಸನ್. ಐ ಆಮ್ ಅಲ್ಲ,
What was supposed to be a
the hard disk contains 6,38,000 pages, which is corrupted. He said it will take at least a week's time to retrieve the data. Once it is retrieved, they will search, and if they find ISCAPA's grant certificate, we'll have it issued.
ಇಪ್ಪತ್ತು ವರ್ಷದಿಂದ ಏನು ಮಾಡ್ಬೇಕಾಗಿದ್ದನ್ನ ಇವಾಗ ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. What will you get now?
Now, whatever the scanned copies are there, all that 6,38,000 pages, they will have to search. But that wouldn't be a problem, I suppose, because the technical, it's a soft copy.
No, that is why I said about 20 years ago, this kind of an
Digitization.
exercise was directed to be undertaken. ಅವಾಗ್ಲೇನೆ ಹಂಗಿತ್ತು ಅದು ರೆಕಾರ್ಡ್ಸ್. ಅಟ್ ಲೀಸ್ಟ್ ಅವಾಗ ಮಾಡಿದಿದ್ರೆ something you would have restored.
Yes.
That information would have been collected at that point of time. ಇವಾಗಂತೂ ಏನು ಕಾಣೋದಿಲ್ಲ ಅದರಲ್ಲಿ. ಏನ್ ಮಾಡ್ತೀರಾ ಇವಾಗ?
In fact, now, after the digitization, the idea is, your lordships, that the public should be able to go and search, like how Bhumi is there now for the RTCs. And now the similar exercise was done on the Kaveri portal for registration exercise. Now, for assumingly for an income certificate is required now. Previously, you would have to go to the office and file. Now that is all available online. You can make some online payment, and if you want, you can take a printer or you can view only anta barte. So that is the idea, whole idea. Once all the grant records, being all the land records that are for any properties, they want to digitize. That is the pilot project that they have taken up. So if you give the survey number along with the now MR and RTCs are available.
ಅದೆಲ್ಲ ಅರ್ಥ ಆಯ್ತು. ಆ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡೋದಕ್ಕೆ ನಿಮ್ಗೆ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಾ?
ಅದಕ್ಕೆ the only hope now is the hard drive that they have found. At least by order of this court and direction, they have at least found the hard drive in one.
No, but this information
Yes, sir.
is not what I was asking for.
So this is what has
I
happened.
said more than 10-15 years ago,
Yes, sir.
circulars were issued by the government
Yes. To
to
digitize.
ensure that these records are digitized.
Yes.
Where is that information?
That information itself, orally what they have said.
Where is that information in writing?
This is the latest information.
ಇದಲ್ಲ ಲೇಟೆಸ್ಟ್ ಎಲ್ಲ ಕೇಳ್ತಾ ಇರೋದು ನಾನು.
That I will.
I asked you,
Yes, sir.
more than 10-15
I-
years ago, this exercise was directed to be undertaken. What happened?
Orally, that is what they have submitted to me, because the now payment.
I will not accept all that.
Yes, yes.
I don't have any faith in this officers.
I will ask them to get this.
You put it in affidavit, we'll see.
Yes. I will, a week's time may be granted.
The principal secretary, revenue department should file the affidavit.
Yes. In fact, your lordship, I can keep him present before this court.
ಯಾರು?
The principal secretary, revenue department. I think there are a lot of questions that are coming up with the revenue department
I don't want him to come here. This
regarding this.
answer to the query raised by this court should be given, a reply should be given by the principal secretary by filing an affidavit.
Yes.
I don't want him to come here.
Yes,
I'm only asking for information
yes.
that to
What
my
happened?
knowledge,
What happened 15
this
years ago?
kind of a direction was given by the government more than 15 years ago.
Yes, sir. We will collect it.
It is almost next to impossible to accept this contention because of some
Non-payment, tender and dispute between. the tender.
non-acceptance of the conditions. The entire procedure itself was
Derailed.
closed. ಸಾಧ್ಯನೇ ಇಲ್ಲ.
I will get the information. In the meanwhile, we'll also retrieve those 638 pages and search for the grant certificate.
Berkeley. On the previous date of hearing, this court had observed that the state government, come out through the revenue department, had issued circulars and directions probably about 10 to 15 years ago to digitize the original grant registers and originally Sagavali chit issue registers. Full stop. The learned AGA was directed to secure information from the revenue department as to when such directions were earlier issued by the revenue department. To scan and preserve the original grant registers and Sagavali chit issue registers. Full stop. Next para. Learned AGA has filed a memo dated 28/2/2024.
This is only with regard to the latest.
Along with a recent communication dated 11/1/2024 made by the commissioner, revenue commissionerate, revenue department, addressed to all the deputy commissioners in the state. Full stop. Learned AGA submits that a direction has been issued in terms of the said communication to digitize and keep a scanned copy of all the revenue records within a period of 100 days. Full stop. Next para. In the considered opinion of this court, this is not the answer that the court was expecting from the revenue department. Full stop. This court wanted to know when was the first time such directions were issued by the revenue department to digitize the original grant registers and Sagavali chit issue registers. Full stop. Next para. The principal secretary, revenue department, is hereby directed to file an affidavit on the next date of hearing, answering the query raised by this court. Full stop. Specific information shall be given by the principal secretary in respect of the talukas in Bangalore urban district and Bangalore rural districts. Full stop. Next para. In the meanwhile, if any further information in respect of the present petitioner is available, such information should also be placed before this court on the next date of hearing. Full stop. Release this matter on 7th of March 2024.
Number 29, Lata Shetty.
Appear for the petitioner, my lord. In this matter, my lord, I am challenging the order passed by the,
Memo for reporting death of respondent number 7.
that is already complied, my lord.
ಆಗಿದೆಯಾ? ಮತ್ತೆ why are they showing it again?
Last occasion, I undertake to file wakalat on behalf of the respondent.
MR of the year 72, my lord, after a gap of 46 years, has been challenged by the respondent, 4 to 6.
My lords, I appear for the respond number 8 to 16 in this matter. I am praying for 1 week's time, my lord. Matter may be taken up next week.
Regarding the memo reporting death of respondent number 7, Srimati Yashodamma, this court has already passed orders on 1/2/2024. Stop. Office is directed not to put up any note in respect of the said memo. Astena. Next para, at the request of learned counsel for
R 8 to 16.
response number 8 to 16.
Kindly a date may be fixed, my lord.
Release this matter on 6th of March.
Great, my lord.
Interim order may kindly be extended.
Interim order granted earlier and extended till next date of the.
Much of.
Hearing interlocutory application.
For first respondent, my lord.
Election.
My lords may kindly take it up in the next week, my lord, kindly.
This is for the third time it is coming up.
My lord, my apologies, my lord. Next week, my lord, kindly, my lord.
ಇದು ಮೂರನೇ ಸರಿ ನೀವು ಕೇಳ್ತಾ ಇರೋದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್.
ಎರಡನೇ ಸರಿ.
Third time.
You are forgetting that this is an election petition.
No, my lord, I'm sorry, my lord. Just next week, my lord, I will go ahead with the matter.
You are required to make submissions in respect of which IA?
There are
Number
two
4 and
IAs.
5.
Huh?
IA number 4 and 5.
4 and 5.
4 and
One is for striking down the pleadings and another for rejection of plight for want of cause of action. For which
1 of 2024.
1 of 2000,
2024,
that is for
strike out the pleadings in paragraph number 6. Ada
6 to 24.
6 to 24.
6 to 24.
Yes.
Huh?
ಹೌದು ಸ್ವಾಮಿ ಅವೆರಡು
Rejection of the election petition. IA number
Election.
2 of 2024.
24
ಇವೆರಡು ತಾನೆ?
ಎರಡು
Huh?
ಎರಡು.
This is the third occasion on which the learned counsel for the contesting respondent is seeking adjournment to make submissions on IAS number 1 and 2 of 2024. Filed by the very same respondent. Full stop. As a last opportunity, release this matter.
4th or 5th.
Huh?
4th or 5th.
Next Friday, my lord.
Friday illa.
Thursday.
4 or 5. 4th.
On 7th of March 2024. As a last opportunity. Bandidiya? Huh? Full stop. If no submissions are made on behalf of respondent number 1 on the next date of hearing on IA number 1 and 2 of 2024, the same will be disposed of as not pressed.
Please.
Yes.
Hearing number 31. Yes, revision petition. 2,378 days. Adu, my lords, in the review petition papers, the order sheet of the writ petition is not there, my lord. That is necessary. I taken time to file objections, my lords. I request for.
Put up the writ petitions also along with this review petition so that it will be convenient.
ಇಲ್ಲ ಹೋದ್ ಸರಿ ನಾ ಹೇಳಲ್ವೇನ್ರಿ ಅವಾಗ್ಲೇ ಆರ್ಡರ್ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದೆ ಪ್ರತಿ ಒಂದಕ್ಕೂ ಹಿಂಗೆ ವಾರ ಮುಂದಕ್ಕೆ ಹೋಗ್ತಾ ಇದ್ರೆ ಹೆಂಗೆ ಆಫೀಸ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಪುಟ್ ಅಪ್
WP 14998.
the petition papers in WP number 14982 of 2015. Full stop. Release this matter on 6th of March. Please.
Number 32. A.B. Gangadharappa.
For the petition in this matter, my lords.
Huh?
Earlier in application has been filed by the respondent in this matter. my lords.
Yeah, by the respondent.
Yes, my lord.
Hearing. Yes. You are ready?
My lords, one date may be fixed for the hearing minutes.
List this matter for final disposal on 11th of March 2024 at 2:30 PM. Stop. IA number 1 of 2023 is accordingly disposed of.
Much.
ಇದು ಬಂದಿದ್ಯಾನ್ರಿ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್
ಇಲ್ಲ, ಬಂದಿಲ್ಲ. I will secure the records.
ಬಂದಿಲ್ವಾ?
ಬಂದಿಲ್ಲ.
ಹಂಗಾದ್ರೆ ಆಗೋದಿಲ್ಲ. On 18th of March 2024. Full stop. In the meanwhile, the learned AGA is directed to
Secure the original.
secure the original records from the land tribunal.
One submission on 18th, 2:30, my lord.
2:30.
Number 33, Prithvi Odayar. Hearing.
A short accommodation.
Huh?
Short accommodation.
ಏನ್ ಮ್ಯಾಟರ್ ಇದು?
This is the matter pertaining to the KDB acquisition.
Huh?
KDB acquisition.
ಹಾ
The KDB has acquired the properties of the petitioners in the first petition and also the lands of the petitioners in the connected second petitioner. Now, in respect of the petitioners in the second writ petition, the KDB has passed an award and award of compensation has been paid. In respect of these petitioners, in the first petitioner, on the installment basis, the general award has been passed. That general award is questioned in this writ petition, in the first writ petition. Now, before this honorable court, on the last date, a statement was made that there is overlapping in between these two lands, that is the lands of the petitioners in the first petition and the lands of the second petitioners. And thereafter, on last occasion, they had filed an affidavit of the SLAO stating that there is overlapping. So I need some time. Your lordships kindly have next week. So
There are two issues are there, Mala. Other two writ petitions are filed by, last petition also filed by petitioners. Well, they challenge the Code Durasta made in favor of the other petitioners in second case. That has been rejected by the deputy commissioner. That means there is overlapping. That's why they questioned the Code Durasta made in favor of the rival claimants. They suffered an order before the deputy commissioner. Well, earlier they succeeded before deputy commissioner. Based on that, they made a representation to pay the compensation because they succeeded before the deputy commissioner. That was questioned by the other rival claim before Dismissal court. Dismissal court set aside that and sent back to deputy commissioner. Now, my lord, deputy commissioner rejected their claim. Now, only question is, my lord, they have to go for civil court for reference, adjudicate everything there on the step.
You would not sought for enhancement?
I have challenged those general award itself, your lordship, in the first. I have challenged that general award itself in the first petition.
On what ground?
on the ground that earlier in the respect of very same notification, some of the land owners had challenged the very same general award which were passed in respect of their lands before this honorable court. And this honorable court has quashed those general awards and has directed the KADB to pass award, consent award, as per the decision taken.
That can be done, that there is no difficulty about that.
That is the only relief which
No, no,
I am seeking in the
No,
first
no, no.
petition.
Now, there is a rival claim.
Correct. No, that it needs.
Therefore, the apprehension of the KDB is that if both the parties are permitted to lay a claim for the award, then the.
For the same land twice, Manoj. That's the problem. One person has already taken.
Therefore,
Kindly have it on Monday,
it is
tomorrow.
for
Your
you.
Worship.
No, it is for the parties to get the title grievance cleared. If there is overlapping,
There is no overlapping. I will establish through the documents. Through the documents, I will establish, Your Lordship. Kindly have it next Monday, Your Lordship. So Monday.
Let them
The
establish
last
before the reference court.
who is the other party that is claiming here?
Manmohan P.
Huh?
Manmohan's writ petition.
They have not come here?
Colleague,
Niva, colleague. So therefore, here itself you have two claims. How can you say, no, there is no overlapping?
No, that is not. The
So
fact remains that.
no, if there is any understanding between you two, you put it in paper
It is
that
not.
this much of compensation in respect of this property can be given to them and this much to be given to you. You come to an understanding and submit it.
Already told.
Therefore, ಅವ್ರು ತಗೊಂಡೋಗಿರೋದನ್ನ ಬಿಟ್ಟು ಏನಾರು ಇದ್ರೆ
ಅದನ್ನ ಆಲ್ರೆಡಿ ಡಿಪಾರ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಷ್ಟೇ.
Kindly have it on Monday, Your Lordships.
ಏನ್ರಿ ಇದು 2014-15 ಇಂದ ಹಿಂಗ್ ಹೇಳ್ಕೊಂಡ್ ಬರ್ತಾ ಇದ್ರಲ್ಲ. What benefit will you get out of this? Huh?
Your Lordships, I will establish there is no overlapping for the reasons on the two.
This court cannot decide all that.
That I am not disputing. I am not making a single submission on the title. And also regarding the identity of property.
That person has taken away the compensation.
If that was so, Your Lordship, that was so, the SLO KDB has passed an general award during the pendency of this writ petition in the year 2022 in my favor. If that was the claim in the first instance itself, if that was the claim of the KDB, they would not have passed this second general award in respect of the remaining portion of my properties. When they have passed this general award in respect of the remaining portion of the petitioner, that too in the year 2020-22, during the pendency of this writ petition, that shows that they are not, there is no overlapping in respect of the properties of the petitioners and the second petitioners.
Which is that order? Which is that order?
That I have filed along with the amendment application. That is allowed.
ಯಾವ್ದ್ರಲ್ಲಿ? Writ petition number?
36803.
28 July 2022.
I have, that application is filed on 2nd December 2022, Your Lordship.
ನೋಡ್ರಿ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. ಅಲ್ಲ, but anyway, we have to have it in our records. ಅದು ಬೇರೆ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಹಾಕೊಂಡಿದಾರ ನೋಡಿ.
26. WP number 36803-805.
36803. Date, sir, date. 2nd December 2022.
ಈ ತರ ಇದೆ photo. Same land, same survey.
produced as annexure A1. It starts from page 6.
Yes.
Your Lordship may kindly turn to ink page 15 or typed page 10 of annexure A1. ಅದರಲ್ಲಿ ಕೆಳಗಡೆ ಬಾಟಮ್ಗೆ ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಾಗೂ ಇದರ ಅವಲೋಕನ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ಕೆಳ ಕಾಣಿಸಿದ ಮಾಲೀಕರ ಸರ್ವೆ ನಂಬರ್ ಹಾಗೂ ವಿಸ್ತೀರ್ಣದಂತೆ ವಿಂಗಡಿಸಿದಾಗ ಈ ಕೆಳಕಂಡಂತೆ ಅವಾರ್ಡ್ ಮೊಬಲಗು ನಿಗದಿಯಾಗುತ್ತದೆ. ರತ್ನಮ್ಮ ಕೋಮರಾಮಕೃಷ್ಣ 6 ಪೈಕಿ 1 ಎಕರೆ 35 ಗುಂಟೆ ಅವಾರ್ಡ್ನಂತೆ ಅಮೌಂಟ್. ಮುನಿವೆಂಕಟಪ್ಪ ಬಿನ್ ಭೈರಪ್ಪ 1 ಎಕರೆ 20 ಗುಂಟೆ. ರಮಾಮಣಿ ಕೃಷ್ಣಪ್ಪ 35 ಗುಂಟೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮೊದಲೇ 15 ಗುಂಟೆ ಅವರಿಗೆ ಮೊದಲೇ ಆಗಿತ್ತು. 15 ಗುಂಟೆ ಮೊದಲೇ ಆಗಿತ್ತು. ದಟ್ ಆಲ್ಸೋ ವುಡ್ ಕಮ್ ಟು 1 ಎಕರ್ 10 ಗುಂಟಾಸ್. ಇದರಲ್ಲಿ 35 ಗುಂಟೆ ಇದನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಮೇಲೆ
So you are?
ನಾವು ರತ್ನಮ್ಮ, ಮುನಿವೆಂಕಟಪ್ಪ, ರಮಾಮಣಿ.
All the three?
All the three. They are the petitioners.
What is the petitioner's name there?
He is appearing for Karar Ahmad, which now they wanted to put it as it. ಅದಕ್ಕೆ last date ನಲ್ಲಿ I pointed out and your lordship said wanted to know from KDB or the government. Karar Ahmad avarದ್ದು all the 3 numbers are separately notified in the final notification. Our names are separately notified under survey number 6. Whereas his name is notified under 128, 129, 130. Separately, they are separately notified. Therefore, question of overlapping adu idnu madadi. And they themselves say they got the report made, and that report says that both the grants are genuine grants. Adralage namige there is no question of B16 ನೋಡ್ಬೇಕು, page 98. ಅದರಲ್ಲಿ that is 368803, page 98. Kindly see, first your lordship may kindly see last column nalli serial number 43 ಕೆಳಗಡೆ names ಬರ್ದಿದ್ದಾರೆ. Right hand side last ಗೆ 43 ರತ್ನಮ್ಮ ಕೋಮರಾಮಕೃಷ್ಣ. ಅದಕ್ಕೆ ಆ ಸ್ಕೆಚ್ ನಲ್ಲಿ 43 ಅಂತ ಒಂದು ಮಿಡ್ಲ್ ನಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ. 43. Similarly
28.
Kindly go to serial number 28. ಮುನಿ ವೆಂಕಟಪ್ಪ ಸನ್ ಆಫ್ ಭೈರಪ್ಪ. ಅದು ಈ 43 ಕೆಳಗಡೆ ಸ್ವಲ್ಪ ಕೆಳಗಡೆ 28 ತೋರಿಸಿ. Then 39 ಕೆ ಕೃಷ್ಣಪ್ಪ ಬೆಂಕರಿಯಪ್ಪ, ಅದು 39. ಈ 43 ದಿಂದ ರೈಟ್ ಹ್ಯಾಂಡ್ ಸೈಡಿಗೆ ಕಾರ್ನರ್ ನಲ್ಲಿ. ಆಮೇಲೆ ನಮ್ಮ ಗ್ರಾಂಟ್ಸ್ ನ ಈ 136 ಪ್ರೊಸೀಡಿಂಗ್ ಆಗಿ ಇಟ್ ವಾಸ್ ಚಾಲೆಂಜ್. Page 170.
170.
So motu proceedings were initiated against the petitioners. 170. ಅರ್ಜಿದಾರರು ಸರ್ಕಾರ, ಎದುರುಗಡೆ ರತ್ನಮ್ಮ ಕೋಮರಾಮಕೃಷ್ಣಪ್ಪ.
ಅದು page 171 ನಲ್ಲಿ
ಹ್ಮ್
3/2/2010 order. They used the records. It is contended on behalf of the respondent. She was granted an extent of so and so in survey number 6 of so and so as per the Tagoli chit dated so and so. Further record of rights have also been effected in her name in the MR number so and so. In support of her contention, she has produced a certified copy of the Sagoli chit issued on 3/2/2004, granting an extent of 2 acre 20 guntas in survey number 6 of Singanalli village, Jala Hobli, Bangalore so and so, in favor of Ratnamma, wife of Ram Krishnappa. She has also produced the copy of so and so under the so and so. Under the circumstances, entries in the name of the respondent in respect of the said land cannot be held to be unauthorized entry. Therefore, the instant proceedings are dropped. This Hagene H1 and H2 are in respect of other two petitioners. Idinna kindly go to annexure J, page 179.
This Karar Ahmad, how does he come into the picture?
ಅವರಿಗೆ 128, 129, 130 he is a notified ಖಾತೆದಾರ ಅಂತ ಹೇಳಿ ಅವನ್ನ ನೋಟಿಫೈ ಮಾಡಿದ್ರು.
Where is the confusion? Why is the confusion like this?
Why is the confusion? It all started with a presumption that ಈ ಅವರಿಗೆ ಕೋಡಿ ಮಾಡಿ ಸರ್ವೆ ನಂಬರ್ ಕೊಟ್ಟಿರೋದು ಸಮ ಅಲ್ಲ. ಆ 128, 129 ಬರ್ತಿರ್ಲಿಲ್ಲ. ಅವರಿಗೆ 128, 129 ಬರೋದಾದ್ರೆ ಈ ಜಾಗ ಯಾರಿಗೆ ಬಂದಿದೆ? Somehow all things started, but 179 ನೋಡ್ಬೇಕು. In respect of grantees in survey number 6, 52 ಜನರ 63 ಜನ grantees. ಎಲ್ಲರಿಗೂ ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಮೇಲೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಡ್ರಾಪ್ ಆಗಿದೆ. State filed the writ petition against that order of the special deputy commissioner. ನಮಗೆ ಸಂಬಂಧಪಟ್ಟ ರಿಟ್ಸು page 179 ನಲ್ಲಿ you lost me, kindly go to page 181.
Krishnappa.
ಹೌದು. ಒಂದು ಕೃಷ್ಣಪ್ಪ ಸನ್ ಆಫ್ ಕರಿಯಪ್ಪ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ page 191. ಮುನಿ ವೆಂಕಟಪ್ಪ ಸನ್ ಆಫ್ ಭೈರಪ್ಪ. ಇನ್ನೊಂದು 194 ರತ್ನಮ್ಮ. Srimati Ratnamma, wife of Ramakrishna. All these writ petitions were dismissed. Kindly see page 202. In this batch of writ petition, state has questioned the legality and correctness of the impugned order passed by the Special Deputy Commissioner, Bangalore District, with reference to land in question under so and so. Shri so and so panel advocate for Public Lands Corporation Limited, Bangalore, appearing for the petitioner state, submits that Special Deputy Commissioner, Bangalore Urban District, initiated promoter proceedings under 136(3) of the Karnataka Land Revenue Act on the basis of the report, but erred in dropping the proceedings, holding that revenue entry in the revenue records in respect of the lands in question cannot be construed as unauthorized entry. The Special Deputy Commissioner, on scrutiny of the documents and existence of revenue entries for number of years, has reached the conclusion that the revenue entry cannot be construed as an unauthorized entry. I see no illegality or infirmity in the order. In the result, the writ petitions fail and they are hereby rejected. Therefore, at this stage, denying us the compensation, that too.
Yes, what is the grounds on which you are saying no, there is overlapping?
Rashmi, kindly see, first of all, the prayer which have been sought from, Rashmi, kindly see the relief what they have sought from. What they are seeking is, my lord, to pass a consent award
Sorry, that we have done in many cases.
No, not that, when the title dispute is there, my lords, with regard to overlapping of the land.
Mr. Chandrasekhar knows, we have passed many orders permitting them to setting aside the general award and permitting them to take the compensation as a consent award.
When there's
We
no,
have passed many
when
orders.
there's no
Even in
dispute as a
cases-
title.
No, even in cases where there is dispute between private parties, we have directed that the dispute will be resolved.
That is all, that is, my lords, in this case, award amount, one person has already taken the amount. The question is, my lord, the same.
No, that is why we are asking you,
Yes.
from where do you get this information?
In
That the
fact,
very same land which the petitioners are now asking for compensation in terms of your own notification.
page 233, the order part,
In respect of the same land, that person has taken the compensation. ಹೆಂಗ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು?
page 233,
representation.
Huh?
page 233,
Representation.
233.
Page 238.
230, sorry, 238. Then at 233 is the order passed by the DC Malos between Ratnamma Munivenkappa and State of Karnataka, Hassan Ahmad side, where that order came to be, revision petition came to be allowed.
38,
Revision dispute, Malos, the revision petition came to be allowed. That is dated 24th February to 2014, pursuant to a representation given by them itself, Malos.
ಏನಂತ? ಓದಿ.
Issued by Ratnama, my lord.
That all three of them have given the representation.
ಹೇಳಿ.
ಮೂಲಕ ಮೇಲ್ಕಂಡ ತಾವು ತಮ್ಮಲ್ಲಿ ಹೇಳಿಕೊಳ್ಳುತ್ತೆ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಜಾಲ ಹೋಬಳಿ ಸಿಂಗಳ್ಳಿ ಆರರಲ್ಲಿ 220 ಗುಂಟೆ ಜಮೀನು ಇವರಲ್ಲಿ ಶಾಸಕ ಮಂಜೂರಾಗಿತ್ತು. ನಮ್ಮ ಕೇಂದ್ರ ಸರ್ಕಾರದ ಅಂತ್ಯಗೊಳಿಸುತ್ತೇನೆ ಮತ್ತೆ ಅಂತ್ಯಗೊಳಿಸುವ ಮೂಲಕ ಭೂಸ್ವಾಧೀನ ಹೊಂದುತ್ತೆ. ಸದರಿ ಜಮೀನು ಎಕರೆ ಒಂದಕ್ಕೆ 62 ಲಕ್ಷ ಕೊರತೆ ಪಡೆಯಲು ಸದರಿ ಜಮೀನಿಗೆ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲೆಗಳನ್ನು ತಮ್ಮ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿ ಭೂಹಾರ ಪಡೆಯಲು ದಿನಾಂಕ 19/5/2009 ನೋಟಿಸ್ ನೀಡುತ್ತಾರೆ. ನಂತರ ತಾವು ನೋಟಿಸ್ ಕೇಳಿರುವ ಎಲ್ಲ ದಾಖಲೆಗಳನ್ನು ಲಗತ್ತಿಸಿ ಭೂ ಪರಿಹಾರ ನೀಡುವಂತೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದೆವು. ತಾವು ಸದರಿ ಭೂ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ತಾವು ರಚಿಸಿದ ಜಂಟಿ ನಕ್ಷೆ 25 ಎಕರೆ ಮಾತ್ರ ಅನುಭವವಿದ್ದು ಉಳಿಕೆ 135 ಎಕರೆ ಜಮೀನು ಕೋಣೆಯಾಗಿರುವ 129 ಸೇರಿದೆ ಎಂದು ಮತ್ತು 25 ಗುಂಟೆ ಜಮೀನು ಮಾತ್ರ ಪರಿಹಾರ ಬಗ್ಗೆ ತಿಳಿಸಿರುತ್ತಾರೆ. ನಂತರ ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ಬೆಂಗಳೂರು ಉತ್ತರ ತಾಲೂಕು ಸದರಿ ಸಿಂಗಳ್ಳಿಗರ 6 ಕೋಟಿ ದುರಸ್ತಿಯಾಗಿರುವ ದೇಶ 228 130 ದುರಸ್ತಿಗಳು ಅನುಭವದ ಮೂಲ ಮುಂದಿದಾರರ ಗಣಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳದೆ ಕೋಡಿ ದುರಸ್ತಿ ಮಾಡಿರುವುದು ತಪ್ಪಾಗಿದ್ದು ಸರ್ವೆ ನಂಬರ್ 128 ಜಮೀನು ಖಾತೆದಾರ ಮಂದಿಗೆ ಸಂಬಂಧಪಟ್ಟ ದಾಖಲೆ ಇಲ್ಲದಿದ್ದರೂ ಈ ಸರ್ವೆ ನಂಬರ್ ರದ್ದುಪಡಿಸಬೇಕೆಂದು ದಿನಾಂಕ 13/8/12 ಸ್ವಯಂ ತೂಕು ದಾಖಲಿಸಿದ್ದು. ಅದರಂತೆ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ನಗರ ಜಿಲ್ಲೆ ದಿನಾಂಕ 10/13 ನೋಟಿಸ್ ನೀಡಿ ಪ್ರಕರಣ ಸಂಖ್ಯೆ ಭೂಮಾಪನ ರಿವಿಷನ್ ಪಿಟಿಷನ್ 24/12/13 ದಾಖಲೆ ಸುಧರಿ ವಿಚಾರಣೆ ನಡೆಸಿ ದಿನಾಂಕ 24/2/24 ಸದರಿ 28/1/20 ರದ್ದುಪಡಿಸಿ ಆದೇಶ ನೀಡಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ತಾವುಗಳು ನಮ್ಮ ಜಮೀನು ಅನುಭವದಲ್ಲಿದ್ದು 129 ಕೋಡಿ ದುರಸ್ತಿಯನ್ನು ಮಾನ್ಯ ಜಿಲ್ಲಾ ರದ್ದುಪಡಿಸರಿಂದ ನಿಟೋ ಸಿಂಗಳಿಗರ 6 ನಮ್ಮ 220 ಗುಂಟೆ ಜಮೀನು ಭೂ ಹರಪಾವತಿಗೆ 60 ಲಕ್ಷ ಕೊಡಬೇಕೆಂದು ಕೋರುತ್ತೇನೆ.
ನಾವು ಓವರ್ಲ್ಯಾಪ್ ಹಾಕತಿ ಅಂತ ಹೇಳಲಿಲ್ಲ. ಕೈಂಡ್ಲಿ ಸಿ ಹೌ ದೀಸ್ ಥಿಂಗ್ಸ್ ಆರ್ ಡನ್. ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ನಾವು ನಮ್ಮ ದಾಖಲೆಗಳೊಂದಿಗೆ ನಿಮ್ಗೆ ಎಲ್ಲದನ್ನೂ ಸಲ್ಲಿಸಿದ್ವಿ. ಆವಾಗ ಅವ್ರು ಹೇಳಿದ್ರು ಸೆಕೆಂಡ್ ಪ್ಯಾರ ಪೇಜ್ 238 ಸೆಕೆಂಡ್ ಪ್ಯಾರ ತಾವು ಸದರಿ ಭೂ ಪರಿಹಾರದ
ಒಂದ್ ನಿಮಿಷ please take the acquisition notifications.
ಪ್ಲೀಸ್.
In the acquisition notifications, if names of all the persons are shown separately with the numbers separately, there can be no confusion at all.
That is how.
Yes, please point out to the acquisition notification.
The Lordship may kindly go to Annexure D, page 134.
25.
The preliminary, 134 is final.
123.
Alla, 134 Annexure D.
134. Yes.
Adu, that is 25th September 2008.
Yes.
ಇದರಲ್ಲಿ
28(4)
Yes,
ಅಂಡರ್ ಕಾಯ್ದೆ ಕಲಂ 28(4).
yes.
ಅದರಲ್ಲಿ ನಮ್ಮ ವಿಲೇಜು 139, ಪೇಜ್ 139, ಶಿಂಗಹಳ್ಳಿ. ಫಸ್ಟ್ ಐಟಮ್ಮೇ ತಾವು ನೋಡ್ಬೇಕು, ಸರ್ಕಾರಿ ಗೋಮಾಳ ನೇಮ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. 6 ಪೈಕಿ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ 256 ಎಕರೆ 18 ಗುಂಟೆ.
Yes,
8 ಎಕರೆ 21 ಗುಂಟೆ ಖರಾಬು.
yes.
ಭೂ ಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಳ್ಳಬೇಕಾದ ವಿಸ್ತೀರ್ಣ ಹಾಗೆ 247.37.
All right.
ಅಲ್ಲಿ ನಮ್ಮ ನೇಮು ಪೇಜ್ 141 ಬಂದ್ರೆ ಮಿಡ್ಲ್ ನಾವು ಅವತ್ತು ನೋಡ್ಬೇಕಾದ್ರೆ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡು
Yes, yes.
ರತ್ನಮ್ಮ ಕೋಂ ರಾಮಕೃಷ್ಣಪ್ಪ.
Yes, yes.
ಒಂದು
K. Krishnappa,
ಕೃಷ್ಣಪ್ಪ ಬಿನ್ ಕರಿಯಪ್ಪ. ಆಮೇಲೆ
P. Venkatappa.
142
bin Bhairappa.
ಮುನಿ ವೆಂಕಟಪ್ಪ ಬಿನ್ ಭೈರಪ್ಪ. ಅದೇ ರೀತಿ
ಈ ಕರಾರಾಮದ್ದು ಇದೆಯಾ ಅಲ್ಲಿ?
ಕರಾರಾಮದ್ದು
ಹಾ.
ಅಲ್ಲಿ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಪೇಜ್ ಮಿಸ್ ಆಗಿದೆ. ಆ 37,809 ನಲ್ಲಿ ಇದೆ ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್. ಅವ್ರು ಫುಲ್ ಇದನ್ನ ಹಾಕ್ಯಾರ.
ನಿಮ್ಮ ಹತ್ರ ಫುಲ್ ಕಾಪಿ ಇದ್ರೆ
ಅಲ್ಲ, ಇವ್ರ ನೋಟಿಫಿಕೇಶನ್ಸ್ I have produced, it's a body, annexure R2 I produced. That extent has reduced. Extent, our extent, ಇದ್ರಲ್ಲಾಗಿದೆ, whole extent ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ, individual extents ಎಲ್ಲ ಇದೆ. That was reduced. In annexure R4, along with my statement of this, R4, what is that extent?
ಅಲ್ಲ, ಈಗ ಎನೆಕ್ಷರ್ ಜಿ ತಾವು ಒಂದ್ಸಲ ಈ WPL ನೋಡ್ಬೇಕು. 3708
ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್.
ಹೌದು,
ಫೈನಲ್
ನೋಟಿಫಿಕೇಶನ್ 37089 ನಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ನಲ್ಲಿ 37089 ನಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ
ಒಳ್ಳೆಯದು.
ಪೇಜ್ 68 ಶುರುವಾಗೋದು. Chinganalli starts from page 73. ಅದರಲ್ಲಿ kindly go to last page 78.
75 ಅಲ್ಲಿ KN ರತ್ನಮ್ಮ,
ಹೌದು,
ಕೃಷ್ಣಪ್ಪ.
ಚಿಂಗನಹಳ್ಳಿ ಶುರುವಾಗೋದು ಇದರಲ್ಲಿದೆ ಪೇಜ್ 74. 75 ನಮ್ಮ ಹೆಸರು ಇದೆ.
ಅದೇ
ರತ್ನಮ್ಮ ಕೃಷ್ಣಪ್ಪ, ಆಮೇಲೆ ಮುನಿ ವೆಂಕಟಪ್ಪ ಬಿನ್ ಭೈರಪ್ಪ, ಕೆಳಗಡೆ ಕೆ ಕೃಷ್ಣಪ್ಪ ಬಿನ್ ಕರಿಯಪ್ಪ, ಅಷ್ಟು ನೇಮ್ಸ್ ಇದಾವೆ. ಅದರಲ್ಲಿ ಪೇಜ್ 78 ಲಾಸ್ಟ್ ಹದಿನಾರು, 17, 18 ಸೀರಿಯಲ್ ನಂಬರ್ 16, 17, 18. ಪೇಜ್ 78 ನಲ್ಲಿ ಲಾಸ್ಟ್ 3 ಎಂಟ್ರಿ.
ಕರಾರ್ ಅಹಮದ್.
ಕರಾರ್ ಅಹಮದ್ 16, 128 ನಲ್ಲಿ 8 acres. ಕರಾರ್ ಅಹಮದ್ 129 ನಲ್ಲಿ 4 acres. ಕರಾರ್ ಅಹಮದ್ 130 ಅಲ್ಲಿ 8 acres. ಅವ್ರದ್ದು ನೇಮ್ ಸಪರೇಟ್ ಆಗಿ ತೋರಿಸಿಯ. ಈಗ 256 ಎಕರೆಯಲ್ಲಿ ನಮಗೆ ಗ್ರಾಂಟ್ ಇದ್ದು, ಆ ಗ್ರಾಂಟ್ ಅನ್ನ ಒಂದ್ಸಲ ಚಾಲೆಂಜ್ ಆಗಿ ಇನ್ ಪ್ರೊಸೀಡಿಂಗ್ ಇಲ್ಲಿವರೆಗೆ ಬಂದು ಕನ್ಫರ್ಮ್ ಆಗಿದ್ದಿದ್ರೆ ನಮಗೆ ಯಾವ ನಂಬರ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ, ಯಾವ ನಂಬರ್ ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದಲ್ಲ. ಅಲ್ಟಿಮೇಟ್ಲಿ ದೇ ಆರ್ ಎಕ್ವೈರಿಂಗ್ ಆಲ್ಮೋಸ್ಟ್ ಎಂಟೈರ್ ಸರ್ವೆ ನಂಬರ್ 6. ಒಂದು 10-12 ಎಕರೆ ಬಿಟ್ಟು ಉಳಿದಷ್ಟು ಎಕ್ವೈರ್ ಮಾಡ್ಕೊಂತ ಇದ್ದಾರೆ. 247 acres ಎಕ್ವೈರ್ ಮಾಡ್ಕೊಂತ ಇದ್ದಾರೆ. ಅದು ಇರೋದು 251 acres. Therefore, ನಮಗೆ ಕಾಂಪೆನ್ಸೇಷನ್ ಕೊಡೋದಕ್ಕೆ ಅವ್ರದ್ದು ಇದಾಗ್ತತಿ ಅನ್ನೋದು that will not.
How did this Karar Ahmad get the property?
ಅವರು he is a purchaser from one Hassan Saab.
ಅಲ್ಲ ಸರಿ,
ಅವರು
ಇವ್ರೇನಾದ್ರೂ ಅಕಸ್ಮಾತ್ ಮಾರಾಟ ಮಾಡಿದ್ರೆ,
ನಾವಲ್ಲ
ಇವ್ರೇನಾದ್ರು ಅಕಸ್ಮಾತ್ ಮಾರಾಟ ಮಾಡಿದ್ರೆ ಏನೋ ಒಂದು ಡೌಟ್ ಬರ್ತಾ ಇತ್ತು. ಇಲ್ಲ, ಅವ್ರೇನ್ ಮಾರಾಟ ಮಾಡಿಲ್ಲ. That person has purchased it from someone else.
If that is the case, then what made them to approach the deputy commissioner at the court, my lord?
The confusion was that
ನಾನಲ್ಲ ಆ ಫೋರ್ಡಿಗೆ ಇದಕ್ಕೆ ಸ್ಟೇಟ್ ಇಸ್ ದಿ ಫಸ್ಟ್
Petition number 2 and 3.
ಸ್ಟೇಟ್ ಇಸ್ ದಿ ಫಸ್ಟ್ ಅಪ್ಲಿಕೆಂಟ್ ನಾವು ಕಾಂಪೆನ್ಸೇಷನ್
State can file a petition, my lord.
ಅಲ್ಲ
How state can file a
No, it has
ಮಾಡೋದು.
it has filed 233, page number 233, along with Ratnam and.
Just by pointing out to that communication, you cannot deny the fact that all these names are found in the acquisition notification separately.
There one aspect, my lord.
ಆಮೇಲೆ
As your lordship,
ನಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ನೋಡ್ಬೇಕು. ನಾವಾಗೆ ಹೋಗಿ ಓವರ್ಲ್ಯಾಪ್ ಆಗೈತಿ ಅಂತ ಹೇಳಿಲ್ಲ. ನಾವು ಕಾಂಪೆನ್ಸೇಷನ್ ಕೇಳೋದಕ್ಕೆ ಹೋದಾಗ ಇಲ್ಲ ಕೊಡೋದಕ್ಕೆ ಬರೋದಿಲ್ಲ, ಅದ್ರೊಳಗೆ ತೊಂದರೆ ಆಗೈತಿ, ಅದಾಗೈತಿ, ಇದಾಗೈತಿ ಅಂತೇಳಿ ನೀವು ಶುರು ಮಾಡಿದ್ದು.
it's like this, my lord. Question is, for one land, compensation has to be given only once. Their names by virtue of entry in the revenue record, whatever.
ಈಗ ದಯವಿಟ್ಟು please come to page number 68, the first page of the final notification.
Please, my lord.
ಆಯ್ತಾ?
68, my lord.
ಆಯ್ತಾ? Commencing from serial number 1,
Page number, yeah.
page number 2, page number 2 ಅಲ್ಲಿ serial number 1 ಇಂದ commence ಆಗುತ್ತೆ.
Preliminary notification, my lord.
ಇದು
Page-
final notification ಇದು.
Final notification, please, my lord. That is at page number 134.
ಹಾ?
134. Writ petition number 38. Okay, anyway, take the.
37089.
This is notification dated 26th of September
Please, my lord.
8.
2008, my lord.
ಆಯ್ತಾ?
Please.
Please see the serial numbers. 1, 2, 3, continuous numbers,
Please, my lord. Correct, till 22, my lord.
till
ಆಮೇಲೆ
22.
ಶಿಂಗನಹಳ್ಳಿ ಶುರುವಾಗುತ್ತೆ.
ಆಮೇಲೆ ಬೇರೆ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
ಶಿಂಗನಹಳ್ಳಿ ನಮ್ಮ ವಿಲೇಜ್.
ಇದರಲ್ಲಿ
Page 141, my lord.
ಕರೆಕ್ಟ್.
In middle
In
and.
respect of survey number 6, ಇವ್ರ 3 ಜನದ ಹೆಸರು ಇದೆ.
My lord, that is correct. What-
ಆಮೇಲೆ commencing from serial number 2, it ends at serial number 18.
Please,
The
my lord.
last 3 numbers pertain to Karar Ahmad. ಆಯ್ತಾ?
Correct, my lord.
ಎಲ್ಲಾ ಸೇರಿಸಿ total extent.
Please, my lord.
See the total extent of land.
247.
331 acres, 18 guntas. Including Karab, it will be 321 acres.
26.
ಅಲ್ಲ minus Karab, it will be 321 acres, 26 guntas.
ಅಲ್ಲ ಅದು ತಾವು ಪೇಜ್ 73 ದಲ್ಲೇ ಸಿಗುತ್ತೆ. ಸರ್ವೆ ನಂಬರ್ 6 ಎಂಟೈರ್ಲಿ ಎಕ್ವೈರ್.
How can there be a doubt that ಅವ್ರದ್ದು that will be overlapping with these people's ಅಂದ್ಬಿಟ್ಟು?
Not,
From where do you get this
not
doubt?
the question of overlapping. The question, the only 2 points, my lord. What is the 2 petitioners, or what is the extent, which survey number is the same, which extent, what is the title document is a question, my lord. That has to be examined whether they're independent or one and the same. They'll have to show their title document to show it is independent,
Independent of?
each other, because separate orders of grant has been given to them.
ಹೌದು.
So they'll have to prove that aspect, you know, saying that it is not overlapping, survey number is the same.
Overlapping what?
No, they've got independent grant orders in their name, my lord.
ಇದೆ.
No, that is not for,
Orders passed by the special deputy commissioner.
no,
ಸ್ಪೆಷಲ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಆಗಿ ತಾವು ಚಾಲೆಂಜ್
That is a,
No,
that is a confirmation. He has gone through the records at the instance of the Tahsildar.
that is one, please, my lord. That is the confirmation, but there's no original title deed of documents between both the petitioners, my lord. As long as we are satisfied as to title of both of them being independent of each other, not overlapping, my lord, under the same claim, then it's a different thing.
Definitely, there cannot be any doubt. This extent of 331 acres, 18 guntas has different extents of land pertaining to these people and Karar Ahmad.
No, ultimately, my lord, for 300 and odd acres, we should not give compensation for 400 and odd acres. That's
Correct.
the only concern.
ಹೌದು.
So therefore, as long as they're independent coming within that extent, my lord, we have no problem. The only question is, my lord, we need to verify this title dispute as to, and as the, therefore, my lord, award has been, as the lordship pointed out,
That
consent award can be passed. As one person has already taken the award, one person, the second award was passed in 2022.
subject to, my lord, they're proving the title before the trial court, let them be permitted to withdraw, my lords.
No question of them proving the title before the civil court.
No,
Angala
under
Parade.
section 18 reference, my lord, let them
Insofar as the grant is concerned, it has been affirmed by the special deputy commissioner at the instance of the Tahsildar.
my lord, that is regarding only
Otherwise,
revenue records
ಅವ್ರ
proceeding.
ಹೆಸರು ಬರಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ ಅಲ್ಲಿ. ಅಕ್ವಿಷನ್ ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಅವ್ರ ಹೆಸರು ಬರಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ.
ಅಲ್ಲ, usually acquisition ಅಲ್ಲಿ ಯಾರ revenue records ಇದ್ರೆ ಕಾಪಿ ಮಾಡ್ಬಿಟ್ಟು ಅದನ್ನ notification ಅಲ್ಲಿ issue
Correct.
ಮಾಡ್ತಾರೆ.
ಹೌದು.
That doesn't give title, my lord. For example, that is what.
That is why I am saying, at the instance of the Tahsildar, the title has been verified by the special deputy commissioner.
My lord, ultimately, before we disperse the amount, my lord, or the, on 33 of section 8.
You please tell us why this confusion has come in your mind, on what basis? That these lands of these two persons are overlapping ಅಂತ ನೀವು ಇವಾಗ ಕಾಂಪನ್ಸೇಷನ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಿದಿರಲ್ಲ, SLAO has distributed the compensation. All the persons who have been notified. ಆಯ್ತಾ? The entire extent of distribution of the acquisition compensation will be to an extent of 331 acres, 18 guntas.
Based on the notification, that is revenue
ಹೌದು.
record. The lordship tells us, therefore,
ಹಾ.
modified alarm notification issued annexure R4. That is not they're saying, their extent was reduced.
ಎಲ್ಲಿದೆ?
Annexure R4.
That is dated, my lords. Annexure.
March, February 2012. It was reduced.
No, 17 December 2012.
Annexure R4.
R4. Yeah, 17.
ನೀವು ಫೈಲ್ ಮಾಡೋದಾ? ಈ ಯಾವ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ?
First rate patient.
36803.
Survey ಆಗಿಲ್ಲ.
Objections. 36803. Statement of objections, PV Chandrasekhar. ಹಾ.
Page 19 ಅಲ್ಲಿ, that is the notification, valid notification. The relevant portion in last dated page 24.
ಹಾ.
Page 24 ಅಲ್ಲಿ, ರತ್ನಮ್ಮ ರಾಮಕೃಷ್ಣಪ್ಪ 25 ಗುಂಟೆ ಅಷ್ಟೇ. RTC ಅಂತ ಜಾಸ್ತಿ ಇದೆ, JMC ಅಂತ 20 ಅನುಭವ ಇರ್ತಾರೆ. Next. On the right side. Next 25 page. ಅಪ್ಪ ಬಿನ್ ಕರಿಯಪ್ಪ. ಬರೀ 15 ಗುಂಟೆ. Next page 29.
ಮುನಿ ವೆಂಕಟಪ್ಪ ಬಿನ್ ಭೈರಪ್ಪ.
ಹೌದೇನಾಗಿದೆ, JMC ಹೆಸರು ಬರೋದಿಲ್ಲ, ನೈಜತೆ ಇಲ್ಲ ಅಂತ ಬರುತ್ತೆ.
ಹಾ?
JMC ನಲ್ಲಿ ಹೆಸರು ಬರೋದಿಲ್ಲ ಅಂತ ಮುಂದೆ 120 ತೋರಿಸ್ತಾರೆ. Then ಮಲಾಡ. Next R2. JMC ಕೊಟ್ಟೆ R2. Page 12. 30.
What are you trying to do by this, by issuing this notification? Huh? See, what is the extent of land that you are actually acquired? By issuing this one, you are trying to reduce the extent of these persons, and what you are trying to do is that the remaining extent is government land. ಅದರಿಂದ ಅದು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡೋದು ಬೇಕಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು
ಏನಾಗ್ತದೆ ಕೋಡ್ ಆಗದೆ ಇದ್ರೆ ಎಕ್ಸಾಕ್ಟ್ ಸಿಗೋದಿಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ.
Correct.
ಸಪೋಸ್ ಅವ್ರ ಹೆಸರಿಗೆ 2 ಎಕರೆ ತೋರಿಸ್ಬಿಟ್ಟು ರೆಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ದಟ್ ಇಸ್ ರಾಂಗ್. There is no specific extent shown in the final notification.
ಹೌದು.
Therefore, there was a confusion. And therefore, Rashid kindly paragraph 5 and 6 of the statement objection.
ಅದಕ್ಕೆ ನಾನು ಕೇಳ್ತಾ ಇರೋದು, what did you actually acquire, notify and in terms of the final notification, what is the extent? Total extent 300 and odd. ಇಲ್ಲೇನಾಗಿದೆ ಇವಾಗ?
ಕಡಿಮೆ.
ಹಾ, ಮಿಕ್ಕಿದೇನಾಗಬೇಕು?
ಅಲ್ಲ, ಅದಕ್ಕೆ ಓವರ್ಲ್ಯಾಪಿಂಗ್ ಅನ್ನೋದಕ್ಕೆ
ಮಿಕ್ಕಿದ್ದನ್ನ you are trying to make it as if it's a government property, so therefore there is no need to pay compensation. ಅಷ್ಟೇ ಆಗೋದು. See, that person has taken the compensation in respect of the lands that were notified in his name.
Because they code everything was done.
Correct. ಆ ತರದ್ದು ಎಷ್ಟೊಂದಿದೆ, ಆ ತರದ್ದು ಎಷ್ಟೊಂದು ಕೇಸ್ ಇದಾವೆ. Many of them have taken the compensation in terms of the extent of land that was shown in the notification. There is no difficulty. Only in respect of survey number 6. Only in respect of survey number 6, because there were many grantees and poured agirilla. But my question is,
62 grantees
when you have notified and acquired survey number 6 ಅಲ್ಲಿ in the final notification, what is the total extent of land that is notified and acquired?
Including Karab, it is 256 acres. Excluding Karab, 247 acres.
ಯಾವ್ದ್ರಲ್ಲಿ ನೋಡ್ತಾ ಇದ್ದೀರಾ ನೀವು?
ಇದು ತಾವು 37,803 ಯಾವ
Fi-
petition ಇದೆ?
ಅಲ್ಲ, final
Final
notification.
notification ಅಲ್ಲೇ survey number 6
ಹಾ,
ಶಿಂಗಹಳ್ಳಿ ಅಂತ ಶುರುವಾಗಲಿ ಶುರುವಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದೇ ತಾವು annexure G ನೋಡಿದ್ರೆ page 73.
ಹಾ.
ಅದರಲ್ಲಿ page ಇದರಲ್ಲಿ page 73. 37,084.
Page number?
ಅದು ಶುರುವಾಗೋದು 68ರಿಂದ.
ಹಾ.
Kindly go to page 73.
ಹಾ.
ಫಸ್ಟ್ ಐಟಮ್ ನಲ್ಲೇ ತೋರಿಸಿದ್ದಾರೆ. ಸರ್ವೆ ನಂಬರ್ 6ರ ಪೈಕಿ
ಹಾ.
256 ಎಕರೆ 18 ಗುಂಟೆ ಖರಾಬು ತೋರಿಸಿ 5 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಭೂ ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಬೇಕಾದ ವಿಸ್ತೀರ್ಣ
Yes.
ಇದು ಅಲ್ಲಿವರೆಗೆ ಪೋಡಿ ಆಗದೆ ಇದ್ದವರದ್ದು ಅಷ್ಟರದ್ದು ಇಲ್ಲಿ ಕವರ್ ಆಗ್ತದೆ. ದಟ್ ವಿಲ್ ಗೋ ಅಪ್ ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಪೇಜ್ 77 ವರೆಗೆ.
ಇವಾಗ ನೀವು ತೋರಿಸಿದ ಡಾಕ್ಯುಮೆಂಟ್ annexure R4 is in respect of only this survey number 6, is it? Huh? Survey number 6 ಮಾತ್ರನಾ ಇದು?
ಒಂದೇ ಇರೋದು. ಅದು ಕೋಡ್ ಆಗಿರೋದು ಅದು ನಂಬರ್ 122.
Annexure R2 ನೋಡ್ಬೋದು.
ಹೌದು.
Annexure R2 R2. JMC report sketch ಅಲ್ಲಿ. ಅಲ್ಲ JMC report ಬೇಡ. ಈಗ what I'm trying to
overlapping ಅಂತ ಹೇಳಿರಲ್ಲ, ಅದಕ್ಕೆ ಅದನ್ನ ಮಾರ್ಕ್ ಮಾಡಿದ್ರೆ that is specific contention or taken statement objections also.
ಇಂಗನಹಳ್ಳಿ ನಿಮ್ಮ ಪೇಜ್ ನಂಬರ್ 20 ಅಲ್ಲಿ ನಿಮ್ಮ R4 ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ ಲ್ಯಾಂಡ್ 256 acres 17 ಗುಂಟಾಸ್ ಆಯ್ತಾ? as shown in the final notification. Now you please see ಈ ಇದನ್ನೆಲ್ಲ ಎಕ್ಸೈಸ್ ಎಲ್ಲ ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದ್ಮೇಲೆ ವಾಟ್ ಇಸ್ ದಿ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್?
234 ಅನ್ನ ಮಾಡಿ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ.
ಮತ್ತೆ ಮಿಕ್ಕಿದ ಜಾಗ ಎಲ್ಲ ಏನಾಗ್ಬೇಕು?
ಭೂಸ್ವಾಧೀನ ವಾಸ್ತಿ ಇರುವ ಸರ್ಕಾರಿ ಜಮೀನು ವಿಸ್ತೀರ್ಣ ಅಂತ ತೋರಿಸ್ತಾರೆ. 45
ಮಿಕ್ಕಿದ ಜಾಗ ಏನಾಗುತ್ತೆ?
ಸರ್ಕಾರಿ ಜಮೀನು ಆಗ್ತದೆ.
ಅದೇ. So it is not the question of overlapping. By doing this exercise, you are now trying to say, no, these are government land because they are not in possession, and therefore we will restrict the compensation only to 28 guntas. Although from the records, it was found that Ratnamma was granted 2 acres 20 guntas. She is found in possession only in respect of 28 guntas. So I will restrict the compensation to 28 guntas. In fact, there is no overlapping. Now you are trying to say the rest of the lands is a government land and therefore they need not be given compensation. ಹಂಗಾಗೋದಿಲ್ಲ.
ಆಮೇಲೆ ತಾವು ಇನ್ನು ಇದ್ರ ಜೊತೆಗೆ ಈಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ annexure A1 ನೋಡ್ಬೇಕು. annexure A1 in 36/803 amendment application dated 2/12/22.
ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
36/803 ದಲ್ಲಿ ಅದು it is filed on 2/12/22.
ಹಂಗೇನಾದ್ರೂ ಓವರ್ಲ್ಯಾಪಿಂಗ್ ಇದ್ರೆ ಅಲ್ಲೇ ಬರ್ಬೇಕಾಗಿತ್ತು ನಿಮ್ಮ JMC ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ. ರತ್ನಮ್ಮ ಅವ್ರದ್ದು 28 ಗುಂಟಾಸ್ ಮಾತ್ರ, ಮಿಕ್ಕಿದ್ದು ಇಟ್ ಇಸ್ ಇನ್ ಪೊಸೆಷನ್ ಆಫ್ ಕರಾರ ಅಹಮದ್. ಆತರ ಏನ್ ಬಂದಿಲ್ಲ.
2 ಎಕರೆ ಬರಬೇಕಾಗಿದೆ. 25 ಗುಂಟೆ ಯಾಕೆ ಕಾಂಪನ್ಸೇಷನ್ ತಗೊಂತಾರ ಅವ್ರು? ಹಾಗಾದ್ರೆ
ಯಾರು
ಅವ್ರು ತಗೊಂತಾರ 25 ಗುಂಟೆ ಅಗ್ರಿಮೆಂಟ್ ತಗೊಂತಾರ ನಮ್ಮ ಹತ್ರ ಫಸ್ಟ್ ತಗೊಂತಾರಲ್ಲ ಅವರು.
ಅವ್ರಿಗೆ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ? they have received and now they are before the court saying ಈ ತರ ಅನ್ಯಾಯ ಆಗಿದೆ ನಮ್ಗೆ ಅನ್ಬಿಟ್ಟು. Should the court not look into it?
I'm not saying that.
See, it is one thing to say that KADB or the state should not be forced to pay twice in respect of the same land.
Public money.
ಆಯ್ತಾ? Public money. We totally agree with that. But ಈಗ ಆಗ್ತಾ ಇರೋದು ಹಂಗಲ್ಲ. ಅವ್ರದ್ದು notified extent ಗೆ ಅವ್ರ compensation ತಗೊಂಡಿದ್ದಾರೆ. Now by conducting this exercise, you can see clearly that there is a reduced extent in terms of your JMC. And now you are seeking to claim that these are government lands and therefore there is no need to give compensation. It should be restricted only to such extent which is found in the JMC, which is in possession of these people. ಹಂಗಾಗೋದಿಲ್ಲ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆಗೆ annexure A1 ಒಂದ್ಸಲ ನೋಡ್ಬೇಕು.
In fact, what they seek to argue and what they pleaded in the petition is totally different. Your Lordship, may kindly page 16, Manoj, what they seek is survey number 6 has been converted to survey number 128, 129 and 130, Manoj.
See, there may be some confusion.
Oh, that is what, Manoj.
At what time this confusion has occurred, how we do not know.
Your Lordship, may kindly.
But I am one with you when you say court should ensure that there is no double payment.
I'm only on that, Manoj. Let that be verified, Manoj,
Yes,
and
yes.
let only to that extent, Manoj, that wherever, Manoj, I mean, first of all, we have acquired the land, Manoj, we cannot deny them the compensation also, Manoj. On first principle, Manoj, I have taken the land. The question is,
What was
sorry.
notified in survey number 6 was 258 acres
Correct.
and 18 guntas. Now by conducting this exercise of JMC, you have identified only 238 acres. What should happen to the rest of the lands?
What they say is, Manoj, they are.
What you are now trying to say is, it is government land. So therefore compensation need not be paid to that.
I'll put it slightly twist.
Yes.
The question is this, whatever the extent of land, what has been acquired, the question is whether both the petitioners, one, as you say, whether it is overlapping. Or second aspect, Manoj, even if it is not overlapping, whether the petitioners have right title interest.
Yes.
What are the documents that can be looked into and passed an order, Manoj? Ultimately, Manoj, with regard to establish the title over the property, either independently or together, whether it's overlapping. So that has to be done, Manoj. Or your Lordship may keep it, we'll look into it, pass an order before your Lordship, Manoj. Your Lordship may consider, instead of going into all these facts, what it is, that can be done.
ಏನಾಗುತ್ತೆ, see, I've been watching every day. ನೀವೇನಾದ್ರೂ ಅವ್ರು ಕಳ್ಸಿದ್ರೆ they will make sure that they will say ಇಲ್ಲ ಯಾವ ರೆಕಾರ್ಡು ಇಲ್ಲ, ಇವ್ರದ್ದು ಏನು ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Then the reference court at least.
This is what they are going to do.
Or before the reference court or any other independent.
Reference court ಮುಂದೆ,
I understand very Lordship. Don't.
Reference court ಮುಂದೆ ಏನ್ ಮಾಡ್ತಾರೆ, ಇವ್ರ ಹತ್ರ ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ ಅವ್ರು ತಗೊಂಡೋಗಿ ಇಡ್ತಾರೆ.
Please, let that be decided.
That again they will send it to the Tahsildar or the assistant commissioner or the deputy commissioner to verify from their records.
Well, without that, how can compensation? Because
No,
that needs to be examined, Malok.
No.
Because what happens sometimes, Malok, whether the genuineness of the grant, whether it has been granted, because.
See, all this started by saying there is overlapping.
In fact, Malok, say.
There is overlapping, and please ensure that there is no double payment.
Subsequent notification, Malok, we have restricted.
He go to the extent of saying, no, we'll verify their title now.
No, we will not do, Malok. Let the civil court do it, Malok.
ಒಂದ್ ನಿಮಿಷ annexure A1 ನೋಡ್ಬೇಕು.
Yes.
Amendment application ಜೊತೆಗೆ. It is dated 28/7/22.
Amendment application.
ಹೌದು.
That is subsequent award of.
2/12/22.
ನೋಡಿ ಇದರಲ್ಲಿ
36/8/03.
ಬರೀತಾ ಇರ್ತಾರೆ.
ಹಾ, 2/12/22. Annexure A1. ಇದು ನಮ್ಮ ರಿಟ್ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ ಅವ್ರು ಮಾಡಿದ ಅವಾರ್ಡ್. Page 6. It is dated 28/7/22. ಅವ್ರೇನು ರಿವೈಸ್ಡ್ ಜಾಯಿಂಟ್ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿದ್ವಿ ಅಂದಲ್ಲ, subsequent to that 28/7/22 ಇದರಲ್ಲಿ your lordship may kindly go to page 15 or typed page 10.
Yes. ಅದೇ ಅವಾಗ ತೋರಿಸಿದ್ರು.
ತೋರಿಸಿ. ಈಗ ರತ್ನಮ್ಮ 1 ಎಕರೆ 35 ಗುಂಟೆ, ಮುನಿವೆಂಕಟಪ್ಪ 1 ಎಕರೆ 20 ಗುಂಟೆ, ರಮಾಮಣಿ 35 ಗುಂಟೆ, ಇದನ್ನ ಅವಾರ್ಡ್ ಮಾಡಿ ಅಮೌಂಟ್ ಇದು ಮಾಡಿದ್ದಾರೆ. ಮೊದಲೇ ಎನೆಕ್ಷರ್ ಎ ದಲ್ಲಿ in the writ petition annexure A, the common award is page 39 in that writ petition.
ಸಾಮಾನ್ಯ ಅವಾರ್ಡ್.
ಹೌದು.
ಹಾ.
ಸೀರಿಯಲ್ ನಂಬರ್ 8 ರತ್ನಮ್ಮ 25 ಗುಂಟೆಗೆ ಮೊದಲು ಮಾಡಿದ್ರು, ಈಗ 1 ಎಕರೆ 35 ಗುಂಟೆಗೆ ಮಾಡಿದ್ದಾರೆ. So totally it is 2 acre 20 guಂಟಾಸ್.
ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಏನು?
ಅದರಲ್ಲಿ 39.
ಹಾ ಹಾ.
ಸೀರಿಯಲ್ ನಂಬರ್ 8.
ಎಸ್. ಹಾ.
25 ಗುಂಟೆ ಕೊಟ್ಟಿದ್ರು ಮೊದಲೇ, ಉಳಿದಿದ್ದು ಓವರ್ಲ್ಯಾಪ್ ಅದು ಇದು ಅಂತೇಳಿ 25 ಗುಂಟೆ ಮಾತ್ರ ಮಾಡಿದ್ರು. ಈಗ ಅವಾರ್ಡ್ ಮಾಡಿ 1 acre 35 ಗುಂಟಾಸ್. ಟೋಟಲಿ ಇಟ್ ಕಮ್ಸ್ ಟು 2 acre 20 ಗುಂಟಾಸ್ ನಾವು.
ಅಲ್ಲಲ್ಲ, ಸಿ ಐ ಕ್ಯಾನ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ಏನಾದ್ರೂ ತಪ್ಪಾಗಿ if award has been passed to an extent which they are not actually entitled to, you please point out. We will say no, it will be restricted only to the lands which were actually granted to them as shown in the records. ಆತರ ಏನು ಆಗಿಲ್ಲ ಇಲ್ಲಿ. Heard, learned senior counsel Shri Jaikumar S. Patil for the petitioners in WP number so and so. Comma, learned Advocate General for the respondent state, and learned counsel Shri P.V. Chandrasekhar for Advocate General for the state as well as the KAD. Aye. Full stop. Next para. However, at the request of the learned Advocate General, release this matter on 5th of March at 2:30 PM. Yes.